Hello, and thank you for joining us here at the First Alert Desk on Atlanta News First Plus. In just about 15 minutes, court is expected to resume in what was a fiery and passionate hearing that kicked off yesterday, including Fulton County District Attorney Fani Willis and Special Prosecutor Nathan Wade. Now, that hearing was centered around whether Fulton County DA Fani Willis should remain on the investigation into former President Donald Trump's election interference allegations and the RICO indictments that he faces right here in Georgia. So again, moments from now, I'm going to bring this live bug down as you're looking at yesterday's footage. We will take you back out to the courtroom as soon as we see the judge. You will see the judge, and we will take you throughout today through that coverage as we keep you updated both on air and online here at Atlanta News First. But before we jumped in, I thought I would catch you up on what you might have missed yesterday, just recapping what is expected today. Now, Judge Scott McAfee has already said he is not going to make a decision on whether the Fulton DA will be disqualified from pursuing Trump any further. He said today is focused on hearing evidence in this disqualification hearing. And for more on all that transpired yesterday, I want to send it over to Atlanta News First reporter Abby Kasouris.
People tuning into the live stream, listening to the intricate details of the relationship between Fulton County DA Fani Willis and Special Prosecutor Nathan Wade. The big bombshell from today's hearing, Willis herself taking the stand after a woman claims that the pair started their relationship years before they admit.
Please state and spell your full name for the court.
Robin Latrice Yurdy.
Robin Yurdy testified Thursday that the personal relationship between Wade and Willis began in 2019 before he was hired in the election interference case against former President Donald Trump.
Did you observe them do things that are common among people having a romantic relationship?
Hugging, kissing.
Nathan Wade maintains the relationship began after.
Our relationship wasn't a secret, it was just private.
Their relationship is under the microscope because if Willis paid Wade as a quid pro quo, it could disqualify her from prosecuting the case. The defense trying to keep Willis from the stand, but after listening to testimony, Willis came barreling into the courtroom.
And I would too, Your Honor.
Taking questions about vacation, meals, and excursions.
I think I bought him, he likes wine. I don't really like wine, to be honest with you. I like Grey Goose. I bought him a bottle of wine while we were there, and the sippings that you do.
All of that is great TV, and people are glued onto it.
Criminal defense attorney Suri Chada Jimenez says Willis is losing in the court of public opinion, but there's not enough evidence to disqualify her from the election interference case.
I do not foresee that this case will ever go before a jury who are the right people to decide whether or not they did what they're accused. They're presumed innocent, and they're charged with very serious crimes, and only a juror should decide whether or not they're guilty beyond a reasonable doubt.
Both Willis and Wade say their romantic relationship is over, but the two remain friends. In Atlanta, I'm Abby Kasouris.
And the allegations of Fani Willis's romantic relationship with Nathan Wade, which she had confirmed in a response, came from Michael Roman, an attorney for Trump's former campaign officials. He's also one of the defendants alongside former President Donald Trump in his racketeering case. Now, that motion filed on January 8th, Roman said that he claimed the two, quote, engaged in an improper, clandestine personal relationship during the pendency of this case, which was resulted in the special prosecutor and in turn the district attorney profiting significantly from this prosecution at the expense of the taxpayer. Now, that is what today is focused on, whether there was a financial conflict of interest. And if you were with us yesterday here on Atlanta News First Plus, some of that was played out with attorneys asking the Fulton County DA about her financial transactions and spending and how that related to Special Prosecutor Nathan Wade. Now, in particular, Roman also claimed in his motion that the two took lavish vacations investigations together using Wade's salary from the district attorney's office. He also said that Willis didn't have the legal authority to appoint Wade as a special prosecutor, making the investigation invalid. Again, those allegations and claims coming from attorney Michael Roman in his January 8th motion against Willis. Now, the motion was called to dismiss, and here we are today, Friday, day 2 of this court hearing, to determine whether the Fulton DA will be disqualified from pursuing former President Donald Trump in his RICO case any further. Again, as I mentioned, Judge Scott McAfee clarifying yesterday that he is not expecting to make any disqualifying decision today. What he does want to focus on today is the evidence and hearing that out. So that is something that we will take you out to. Again, still waiting to take you back into that courtroom. As soon as we see Judge Scott McAfee and the court start to fill up, we will take you live to that hearing that is expected to kick off here in just about 10 minutes at 9 o'clock. In the meantime, our Atlanta News First, Rebecca Schramm, has been outside of this courthouse with a look at everything that you can expect to play out later on today.
This is one of those hearings that really has people glued to their screens. It is bizarre to see a prosecutor in the hot seat being questioned about her romantic relationship. But this wasn't just any relationship. Take a look. Nathan Wade is the man District Attorney Fani Willis hired as an outside contractor to spearhead the Trump case. He was questioned right after a former friend of Willis testified that Willis and Wade's romantic relationship began in 2019. That contradicts what the pair said in sworn affidavits. They said their relationship started after Wade took the case. Wade and Willis repeated that on the stand, insisting that their friendship didn't turn romantic until after. But at the crux of the case is whether Fani Willis benefited financially from the arrangement. They acknowledged going on vacations together, but she testified she paid him back each time with cash or by paying for other outings. Willis was on the stand all afternoon, and things were testy between her and Ashley Merchant, the attorney who first exposed the relationship.
You think I'm on trial? These people are on trial for trying to steal an election in 2020. I'm not on trial, no matter how hard you try to put me on trial. But I didn't give him money out in a contract. What happened? No, we're going to answer it since you said it. He worked more hours than he was paid, and the county paid him for the work that he did. So don't be cute with me and then think that you're not going to get an answer.
The hearing resumes at 9 o'clock this morning with Fani Willis taking the stand again. We will stream it for you on Atlanta News First Plus. At the Fulton County Courthouse, Rebecca Schramm, Atlanta News First.
And former President Donald Trump taking to his platform, Truth Social, to weigh in his opinion on Thursday's trial, saying, quote, Fani never paid cash. She got free trips and other things from her lover with the exorbitant amount of money she authorized to be paid to him. A giant scam, witch hunt, end quote. That is Truth Social, directly from former President Donald Trump, who I'm sure we can all imagine is watching this closely and seeing how this is going to play out into today from what began yesterday. Nathan Wade, Special Prosecutor Nathan Wade, taking the stand right before Willis and really revealing a lot of details into the relationship, into the timeline of when they met and all that transpired since then. And then Fani Willis taking to the stand and, well, listen for yourself.
You think I'm on trial? These people are on trial for trying to steal an election in 2020. I'm not on trial, no matter how hard you try to put me on trial. But I didn't give him money out in a contract. What happened? No, we're going to answer it since you said it. He worked more hours than he was paid, and the county paid him for the work that he did. So don't be cute with me and then think that you're not going to get an answer. I don't need anybody to foot my bills. The only man who's ever foot my bills completely is my daddy.
Fani Willis, again, defending her decisions, her actions in her role with entering a romantic relationship with Special Prosecutor Nathan Wade. But the allegations that are being focused on right now is whether Wade and Willis misused taxpayer money and crossed ethical boundaries. But that is something that Fani Willis has been very clear did not happen. And really the focus for these attorneys is trying to prove that with today's evidence hearing centering around that specific allegation.
I don't need anybody to foot my bills. The only man who's ever foot my bills completely is my daddy.
Again, that quote directly from the Fulton County District Attorney herself. Now, we spoke to an attorney here in Atlanta on how Thursday's hearing plays out and what that could mean for Fani Willis and the disqualification decision that everyone is expecting to come.
Both her performance and Mr. Wade's were easily considered evasive. I don't believe they answered the questions forthrightly and straightforward in a way that you would expect from people charged with such an important job. And I think it will be very hard for Judge McAfee to ignore that when he considers whether to disqualify or not.
Again, we are still waiting moments from now. In less than 5 minutes, court is expected to resume. As soon as we see Judge Scott McAfee, as soon as we see folks pouring into that courtroom, we will take you out live. In the meantime, we are just previewing everything that you can expect from today, talking a little bit about all that's happened yesterday. Again, Fulton County Superior Court Judge Scott McAfee overseeing this case, overseeing the Trump RICO case as well, saying that he is not going to make a decision on disqualification today. What he wants to do today is hear evidence into the allegations suggesting that former Fulton County District Attorney Fani Willis and Special Prosecutor Nathan Wade misused taxpayer money and crossed ethical boundaries. That is on the attorneys to prove that today. Fani Willis has said repeatedly and passionately that that these allegations are not true, that they are false. Take a listen to this.
I don't need anybody to foot my bills. The only man who's ever foot my bills completely is my daddy. You think I'm on trial? These people are on trial for trying to steal an election in 2020. I'm not on trial, no matter how hard you try to put me on trial. But I didn't give him money out in a contract. What happened? No, we're going to answer it since you said it. He worked more hours than he was paid, and the county paid him for the work that he did. So don't be cute with me and then think that you're not going to get an answer.
And Fulton County DA Fani Willis saying time and time again that the allegations are a lie, that despite them having a relationship, that it did not go further into crossing ethical boundaries, and the financial aspect of the allegation, she argues and claims is not true. And again, the attorneys today are determined to prove that those allegations are in fact true. So you have two sides of the story that will continue here. Now, we did hear yesterday powerful testimony from the Fulton County District Attorney that very well is expected to continue into today, but also other people from the innermost circles of both Fani Willis and Nathan Wade, as well as those involved in some of the evidence being presented, we will expect to hear from today. Again, this all stemming from the Fulton County District Attorney's relationship with a special prosecutor on the RICO case, Nathan Wade, that making headlines earlier late last year and earlier into this year, and now leading to a disqualification hearing determining whether Fani Willis will stay on the case into the former president. Again, the former president taking to social media to really weigh in his opinion, saying, quote, Fani never paid cash. She got free trips and other things from her lover with the exorbitant amount of money that she authorized to be paid to him. A giant scam, a witch hunt. That directly from former President Donald Trump, as I'm sure he's watching these hearings closely, seeing how it's going to play out again into day 2, Friday, as attorneys, as the Fulton County District Attorney returns to this courtroom, Judge Scott McAfee overseeing the hearing that very well will continue into today. We are just a minute away from the start of this court hearing. Again, as soon as we see the courtroom and people pouring into that, the judge speaking, we will take you live out to those remarks. In the meantime, I do just want to take you back through what transpired yesterday and what you can expect today.
People tuning into the live stream, listening to the intricate details of the relationship between Fulton County DA Fani Willis and Special Prosecutor Nathan Wade. The big bombshell from today's hearing, Willis herself taking the stand after a woman claims that the pair started their relationship years before they admit.
Please state and spell your full name for the court.
Robin Latrice Yurdy.
Robin Yurdy testified Thursday that the personal relationship between Wade and Willis began in 2019 before he was hired in the election interference case against former President Donald Trump.
Did you observe them do things that are common among people having a romantic relationship?
Hugging, kissing.
Nathan Wade maintains the relationship began after.
Our relationship wasn't a secret. It was just private.
Their relationship is under the microscope because if Willis paid Wade as a quid pro quo, it could disqualify her from prosecuting the case. The defense trying to keep Willis from the stand, but after listening to testimony, Willis came barreling into the courtroom.
And I would too, Your Honor.
Taking questions about vacation, meals, and excursions.
I think I bought him. He likes wine. I don't really like wine, to be honest with you. I like Grey Goose. I bought him a bottle of wine while we were there, and the sippings that you do.
All of that is great TV, and people are glued onto it.
Criminal defense attorney Suri Chada Jimenez says Willis is losing in the court of public opinion, but there's not enough evidence to disqualify her from the election interference case.
And we do want to take you now live out to Judge Scott McAfee's courtroom in what will be day 2 of the disqualification hearing for Fulton County District Attorney Fani Willis and Special Prosecutor Nathan Wade. Let's listen in.
Joining us by Zoom again.
Good morning, Your Honor. This is Jack Van Wy on behalf of Mark Meadows. He waives his presence.
Thank you.
Wade, McAfee Wade. She waives her presence.
Your Honor, Mike Smith, Clark V-Shake for Mr. Hampton with local counsel John Monroe.
I'm sorry, I didn't hear that at all.
With local counsel John Monroe. To my right.
Okay.
Richard Price and Chris Evelowitz from Mr. Chief, who waives his presence. Your Honor, who waives his attendance at the hearing.
I think we're now to Mr. Roman.
Good morning, Judge. Ashley and John Merchant for Mr. Roman, and he waives his presence.
Greg Gillen and Anthony Lake for Mr. Schaefer, and he is present.
All right. And then Mr. Floyd. All right. Not seeing Mr. Floyd present today or anyone on behalf of his counsel. He received notice that today would resume. And so I will make a finding that he's decided not to attend today's round 2. All right, anything we need to take up before resuming? We have someone from the gallery.
Sorry, Robin Martin, I wanted to bring up John Morrison's office. He's sick today.
Okay, and Mr. Floyd has decided what exactly? Did he? Ms. Cross?
It sounds like it's a deliberate choice for Mr. Morrison not to be present this morning, and the defendant was certainly here yesterday if he joins later. Otherwise, I think we can call that a voluntary waiver.
Okay, I agree, and I haven't heard anything else from Mr. Morrison or any other counsel. Is there anything we need to take up before resuming testimony here? Let me start with the state.
I'm sorry, thank you, Your Honor. Yesterday, the state had asked that Ms. Yurdy be, her subpoena be held in case we needed to recall. I let her attorney know last night after speaking to him. We don't intend to recall her, and as far as the state's concerned, I know she'd already been released from the subpoena from the other side, so there was no reason for her to be released today from the state's concerned.
All right, Ms. Merchant, can we excuse Ms. Yurdy?
I talked to her attorney last night, and I said we had a different conversation, so I think she's still on standby.
So your position has changed since yesterday?
Well, based on the state's representation that they may have rebuttal evidence, but they didn't give us that, so I don't know what that is. So in rebuttal, if they present something in rebuttal that I need to call her to talk about, then I would.
All right, we'll address it as it comes up. What else? Anything else, Ms. Cross?
Not from the state, Your Honor.
Okay, Ms. Merchant.
I know that we're still in the middle of Ms. Willis, but we need to address some of the things that were said yesterday in court in regards to Mr. Bradley, privilege, things like that. Do you want to do that now, or would you rather do that before Mr. Bradley?
When you say address them, what do you mean?
Well, there's a couple different issues, but we've got the privilege issue is one of them. But I also, what I did was I drafted all my questions, and I thought I could give those to the court, opposing counsel, everyone could review them, so we didn't have to worry about the privilege stuff. There were some allegations made. I had a transcript made of the proceeding yesterday. Some specific allegations that I think I should have an opportunity to refute. Specifically that I had egregiously misrepresented, that things that I had said were patently false, and that all of that information came from Mr. Abadi. Speaking of Mr. Chopra, I spoke with Mr. Chopra. We talked to him in the car on the way here on speakerphone, Mr. Merchant and I. And he said that he didn't tell Mr. Abadi any of that information, doesn't know where Mr. Abadi got it from. Mr. Abadi says that he did. And so, you know.
If there's any clearing of the air that needs to happen, and if we need to get to that, I think the right time would be once we've actually seen all the evidence that comes out. So.
Thank you. I just wanted to let the court know. Thank you.
And in terms of the privilege issue, if you're planning to recall Mr. Bradley, and you've actually typed out some specific questions, then yes, I think that would be helpful and might allow things to proceed a little more efficiently through his testimony. So to the extent you've got those typed out and are willing to provide those to counsel for Mr. Bradley and the state, I'd encourage you to do that. And before we call him, we can get into that as well.
Okay, great, thank you. And I have a copy for the court, I have one copy for Mr. Evans. I know Mr. Abadi was objecting to privilege yesterday, but I think it's actually Mr. Evans that needs to do that.
Mr. Evans is here, okay. All right, anything else from any counsel?
Vote the rule, make sure it's still in place.
Rule is still in place. All right, not seeing anything else. If we could bring back in Ms. Willis.
Actually, Your Honor, the state has no further questions for Ms. Willis, so.
All right.
No need to recall.
Okay, Ms. Merchant. Next witness.
I think we're about to hit the privilege issue.
We are about to hit the privilege issue.
There we are. Okay. Then do you need counsel need a moment to take a look at her questions?
Yes. So I've got a copy. Oh, I guess Mr. Evans.
And then do we have Mr. Bradley somewhere in the whereabouts nearby?
Mr. Chopra. I informed Mr. Chopra that he's still under subpoena. So
Well, him and his client.
Yes. I'm also with Mr. Bradley, and he's actually not here today.
We need you to identify yourself for the record, sir.
Nate Van Ward. He's not here at this moment. He has a doctor's appointment that he's currently in as we speak. And his representation is on the way here as well. I'd love to be able to get one of the
We have a copy of that?
I just want Mr. Evans.
Do you have a time estimate of when he's supposed to be here?
I have one copy of the questions.
Where's the doctor in relation to here?
Yes, at the very earliest, he would be free about 10 to 10:30.
All right, he's currently driving here as we speak.
He's at the actual doctor's office as we speak.
Okay. And
I think the council was informed of that last night, that he would not be here until at the earliest 10 to 10:30.
All right.
I wasn't until 10 or 10:30, but.
Sure. Ms. Merchant, other than Mr. Bradley, did you have any other witnesses?
Not that I can call before Mr. Brown.
But I do think we can take up some of the privilege questions.
Sure. No, I think we can use this time to do that. So why don't y'all take a moment to look at the questions and then let me know when you're ready to proceed.
Okay. My part of it doesn't have to do with questions. I understood yesterday. I know these gentlemen are looking at the same time, so you want me to wait until they have a chance to.
Well, I think you're about to maybe make a legal qualification here, so why don't we hear what you've got?
Right. Yesterday it sounded as if the witness was going to decline to answer any questions at all in relation to communications or observations or anything, be it independent source or otherwise, that took place during the time of the alleged attorney-client privilege relationship, which is 2015, I think, until the present. I understood that as referencing not simply attorney-client privilege communications, but what we commonly refer to under 1.6 as confidences and secrets, which are not covered by the attorney-client privilege and are not barred from testimony or evidence in a courtroom. But it sounded as if the court is going to have to order Mr. Bradley to testify, and then Mr. Bradley will have to take a position of whether he's going to follow the court's order, heed the court's order, or whether he's not. If he does, then we'll be able to get in hopefully to the questions that Ms. Merchant has prepared on Mr. Roman's behalf. If he says, I'm not going to comply, then theoretically we're in a position in which the court will have to hold him in contempt. And then, at that point, my guess would be that somebody would say, I would like him to have the contempt stayed while I take it up on appeal. So I'm just trying to play through where we're going to be. Because if we're going to do that, we might as well know this before we start putting him on the stand.
I think that's a good thing to flag now, and I agree that yesterday during the hearing there was some intermingling of 1.6 and attorney-client privilege, and now having had the time to kind of parse through that, and it does seem that there is a distinction between the two. One is not covered by the evidentiary privilege, and pulling the case of Tenet Healthcare Corp. 273 Georgia 206. Supreme Court doesn't make that distinction. So to that end, Mr. Evans, as we work through these issues, I would say that when Mr. Bradley takes the stand, I would be directing him to respond and be responsive to any questioning that may be covered by Rule 1.6. That would be the order of this court. But that still reserves the issue of attorney-client privilege. So as you're reviewing those questions, we'll keep that in mind, and I'll be interested to hear your response. Anything else you think we should clarify before we take a break to look at the questions? Do you have a copy for me?
Yes, I do. A copy of the questions, Judge, and I also have copies of there's the exhibit that I was filing. Would you like that as well? I just took those.
So I have objections to filing. You say you want to file it?
No, that I'm going to use in Mr. Bradley's testimony. I think it'll help, but we can wait and I can use it there. After it's the question that I gave Mr. Bradley.
All right, and counsel for Mr. Bradley, I'm sorry, can I get your name one more time? I didn't write it down.
Maybe Ward.
Mr. Ward?
Yes.
Okay. All right, Mr. Ward, if we could get some regular updates of where he is and how he is progressing towards the courtroom. And then when everyone has had a chance to read these questions in the interim, let me know and we can take this up. Mr. McDougall.
I have a text message from one of Mr. Floyd's lawyers that he's logged in on the Zoom conference, Your Honor.
Okay. Is someone joining us by... Thank you. Is someone joining us by Zoom that wants to appear for the record?
Yes, Your Honor. Chris Kucheroff for Mr. Floyd.
All right. Thank you, Mr. Kucheroff. And I think we had a legal assistant here announcing on Mr. Floyd's behalf, but I think it would be better to have counsel of record any announcement in terms of Mr. Floyd's presence this afternoon, or excuse me, today.
I'm sorry, Your Honor. I don't know. Did you ask a question?
Yes, sir. So Mr. Floyd joined us yesterday, but I do not see him here today. Do you have an announcement about his presence for today's hearing?
No, he will not be present, Your Honor.
All right.
We would waive his presence.
Okay. Thank you, Mr. Kucheroff. All right. We'll be in recess until I hear from the parties.
Thank you.
Good day to buy a lottery.
Oh, yeah.
All right, and as you saw court taking a sudden recess moments after starting, really, thank you for joining us as we continue to follow and take you out live through day 2 of a disqualification hearing for Fulton County District Attorney Fani Willis and Special Prosecutor Nathan Wade. I'm Maria Moreau, joined by anchor Rick Fulbaum. Rick, yesterday was something that we couldn't take our eyes off of. Today, a lot of people expecting a continuation of that as evidence is presented, but as we saw moments ago, the judge calling a recess, waiting for parties in this evidence hearing to arrive so that they can proceed.
Right. So yesterday was what we used to call must-see TV. I think anybody who was either watching it or listening to the audio of it, which I was because I was in the car driving my kids around in the afternoon, it was something that you really could not take your eyes and ears off. And the expectation was that Fani Willis was going to take the stand again today, this time to be cross-examined by her own attorney. Nobody was anticipating any kind of combative back and forth like we saw yesterday, but another chance for her to take the stand and perhaps, explain and defend herself against these charges that she has, committed ethical misconduct and should be disqualified from this case. But they didn't call her to the stand. So that was a bit of a surprise. I think people were expecting to hear from her. That was what we were anticipating. But then we found out right at the beginning of today's proceedings that she was not going to be testifying. Instead, the defense team is calling back to the witness stand someone who testified yesterday, a former law partner of Nathan Wade, who is the lead prosecutor that was hired by Fani Willis, with whom she's alleged to have admitted to have this romantic relationship. So this former law partner of Wade's was called, but he's at a doctor's appointment or something like that. He's not in court. Now, this is not unusual. I think that a lot of people were anticipating that much of the beginning of today's hearing would be Fani Willis back on the stand. And so, people have their lives that they've got to sort of go about their business. He might have scheduled this appointment thinking that he'd be able to get back to court in time. But now they're in recess because, of course, they're trying to figure out exactly who they are going to call to testify. But just to, I think, Maria, we should just sort of bring everybody back up to date and sort of try to explain exactly what is going on here. First of all, Fani Willis is the Fulton County District Attorney, and her office impaneled a special grand jury that has criminally indicted former President Trump and 18 other co-defendants, accusing them of interfering with the 2020 election here in Georgia. And so that is not changed by any of this. The work of the grand jury, which handed down these indictments, is not being called into question. The conduct of the prosecutors working on this case is, with the exception of Nathan Wade and Fani Willis and their personal private relationship, is not being called into question. So, there are these indictments that are still on the table and that are not impacted by what's going on here. What's going on here is an attempt on the part of the defense attorneys for former President Trump and some of the other co-defendants involved in this case to try to disqualify Fani Willis and basically to get her removed from the case. Now, why would they want to do that? Because if she is removed from the case, that means that another prosecutor from somewhere in the state of Georgia would be assigned the case in her place. And there is no guarantee that that prosecutor, whoever it may end up being, would want to go forward with the case at all. There's a possibility that that prosecutor could decide to drop the charges and not to pursue them. And that would be something, obviously, that would be a big victory for former President Trump and his co-defendants. So that's really what this is about here. This is an attempt on the part of the former president's lawyers and the lawyers representing his co-defendants in this case to try to derail this case and basically get it sidetracked to the point where it either doesn't happen for months and months and months, or, Maria, doesn't happen at all.
And I just want to show you here former President Donald Trump taking to his platform, Truth Social, to weigh in on Thursday's hearing, saying, quote, Fani never paid cash. She got free trips and other things from her lover with the exorbitant amount of money she authorized to be paid to him. A giant scam, a witch hunt. So he's obviously invested in how this plays out, weighing in, not being very shy about his own opinion. Now, Wade
When is he ever shy?
Right, right. Now, Trump's Georgia attorney claimed that Willis failed to provide full transparency in her response into her relationship with Nathan Wade. He also was saying, the motion here is the financial aspect, and that allegation is, I think, what people often lose track of. Seeing some of the comment section yesterday with people asking, why is there a hearing into a romantic relationship? Well, it's not exactly that, as you pointed out. This is an allegation into whether Wade and Willis misused taxpayer money and crossed any ethical boundaries in this RICO case involving the former president, and that is what attorneys for the former president are really pushing for and trying to prove this allegation. Fani Willis has come out and many times said this is a lie, this is not true, that the financial aspect and her ethical morality is intact here. So this evidence hearing that's supposed to play out today, Judge Scott McAfee saying he's not going to make a decision on whether Fani Willis will be disqualified from pursuing Trump and the RICO case. He wants to hear evidence today before making a decision.
Right. And just to go back to the money issue that you raised a minute ago, because I do think you're right, that's a very important part of this and could be confusing for people because there really are so many different issues at play here. But what the defense lawyers for former President Trump and the other co-defendants are trying to do is to create a storyline which may or may not be 100% accurate, but this is what they're trying to put out there. A storyline that Fani Willis hired her boyfriend, someone that she was already in a relationship with, paid him an exorbitant amount of money, some $650,000 so far, of, as you said, taxpayer funds. This is a publicly funded trial, and the prosecution is funded by the taxpayers, the DA's office. And so the allegation here is that she hired her boyfriend, paid him a ton of money, and then they traveled the world together, going on fancy vacations and cruises and dinners and you name it. And so that's why the money is coming into play. The idea of a misuse of public funds, that is really sort of the conflict of interest that the defense attorneys are trying to put out there. And it's why you hear Fani Willis so indignant, insistent that she was not treated to anything, that she is a modern, successful woman in her own right who was able to pay her own way when it came to vacations and dinners. And so whenever Nathan Wade paid for something and they were able to produce some bank statements and some divorce affidavits that he had to attest to as part of his divorce, they were able to show that he paid the money up front. She's saying, yes, he may have paid the money up front, but then I reimbursed him in cash. And so that's what Donald Trump's post on his social media site is referring to when he says that she never paid him cash. There is, obviously no way to trace and keep track of cash transactions. And so, I think that just, again, creates a question in the minds of some, and it opens a door to these attorneys who are trying, again, to paint this picture, to tell this story that they hope will eventually lead Judge McAfee to disqualify her from this case. Because, again, if she's disqualified, It's not as though a different attorney within the DA's office would be assigned to it. A different DA from somewhere else in the state of Georgia would be assigned to the case, not from here in Fulton County. And so that would very much put the entire case in jeopardy, which is exactly what Donald Trump's attorneys and the other co-defendants' attorneys are trying to do.
And as you're taking a look right now, this is a live view, by the way, inside the courtroom, still in recess, but you could see what appears to be the court reporter sitting down, and off to the side a couple other members. We just saw the bailiff pass on by, I believe. Talking about the financial part of this, and that was a big part of yesterday's conversation with Willis, saying that in no point did she lend her security team to Wade, and all these other questions that the attorneys brought up to almost explore how funds were used here. She said that she paid him back in cash for any times that they spent together, also calling Wade a world traveler, but herself saying that she never, there was never some sort of questionable exchange of funds involved in their travel together. So refuting a lot of the statements and clearly getting very passionate about some of the questions that were thrown at her involving her financial transactions and her financial spending throughout that timeline.
And it is sort of like a Rorschach test, we all watched the same testimony, but I think that different people could walk away with different opinions, different views of what they had just watched and listened to, depending on their own personal background. I think that for a lot of women, and I'm obviously I don't speak for any women, but I could imagine a lot of women watching and feeling a sense of compassion and solidarity with Fani Willis. Here is this woman who is very bright and successful, who has climbed the ladder in her profession and worked very, very hard. And here she is having to answer very embarrassing personal questions about her love life, about her finances, and the like. And so, I think that there were a lot of people watching, and I'm sure perhaps some men as well, who walked away thinking, wow, Fani Willis did a really good job standing up for herself and defending her honor and reputation. And then there are other people who might have watched it and said to themselves, wow, here is this angry woman who is obviously, reckless in her behavior, who created this opening that allows, these attorneys to go after her reputation, to call it into question. Here she was pursuing one of the most powerful people in the world, former President Donald Trump, pursuing criminal charges against him. How could she allow anything to get in the way? How could she? You have to be beyond reproach to be able to stand up and try to pursue somebody at that level. And clearly, she made mistakes in deciding to work with somebody who she was having a relationship with of some kind. And there is some question as to the timeline. Did that relationship start before she hired Nathan Wade? Did it start after he was already hired and they were already working together? But again, it's just it creates this sort of sticky situation that really, I'm sure a lot of people watching and listening were thinking to themselves, why would she let this happen? Just completely unnecessary, like in tennis, an unforced error that she committed here by even opening the door to these kinds of allegations, when clearly she could have hired, just about anybody to take that job. For her to have hired somebody either that she was very, very close with or that she was having a relationship with, it just sort of looks bad. The optics of it are bad. And so, I think that watching her testimony yesterday was very, very interesting. And I know that talking to people about it, because everybody's talking about it, you really do hear people, sort of viewing it through their own personal lens. And so, that's, I think, partly what makes it so compelling and so interesting that this story is playing out. And it's being watched all over the world, and it's playing out right here in our backyard.
Yeah, certainly. And I do want to play some of her testimony for you from yesterday, just so you can hear some of the remarks that were made.
These people are on trial for trying to steal an election in 2020. I'm not on trial, no matter how hard you try to put me on trial. But I didn't give him money out in a contract. What happened? No, we're going to answer it since you said it. He worked. He worked more hours than he was paid, and the county paid him for the work that he did. So don't be cute with me and then think that you're not going to get an answer. I don't need anybody to foot my bills. The only man who's ever foot my bills completely is my daddy.
And again, some words from the Fulton County District Attorney herself as we take you back out here live to this courtroom, still in recess. Judge Scott McAfee saying he's waiting for parties to arrive in this evidence hearing, and that really is his focus today, is hearing evidence before making a decision on whether the Fulton County District Attorney will be allowed to stay on the case or if she's determined to be disqualified. All right, just stepping away momentarily to get some additional details, maybe a time when court is expected to resume. Right now, no word yet, as the judge is waiting for parties involved in this evidence hearing to appear before he proceeds with the day. As soon as that happens, we will take you back out live full. For those of you watching on our YouTube Live, I am seeing all of your comments. Please, if you have any questions, any additional thoughts, comments of your own, drop them there. We will try to address and flag some of them, maybe answer some questions right here as we're waiting for court to resume. But taking you back out full here, you can see a rather empty courtroom, different from what it was 25 minutes ago, as Judge Scott McAfee sat down, started the hearing at 9 o'clock sharp, and then quickly realized that not all parties were in the courtroom, and deciding that they would not proceed until all parties did arrive. So we are waiting for court to resume any minute now. Again, I just want to take you through some of the details that both transpired yesterday and also have just been developing. Fulton County Attorney Fani Willis accused of misusing taxpayer money and crossing ethical boundaries. Again, that is the center focus of this hearing here, to determine whether that will disqualify her from pursuing former President Donald Trump in his Georgia RICO case. Again, the Fulton County District Attorney saying that that allegation is false, being very passionate in her response to attorneys yesterday who were questioning her about financial transactions, about her relationship with Special Prosecutor Nathan Wade. This stemming from a motion filed by one of Trump's attorneys claiming that Fani Willis and Nathan Wade took lavish vacations together using Wade's $650,000 salary that he's made over working on the Trump case from the district attorney's office. He also said that Willis didn't have the legal authority to appoint Wade as a special prosecutor, making the investigation invalid. That also an allegation filed in this motion. And then the motion calling to dismiss the indictment altogether, along with Willis and Wade's involvement in prosecuting the case. Now, a lot of people had questions about whether that would throw out the case altogether. What would happen is it would be reassigned to another prosecutor, and then from there, that prosecutor would determine how they want to go about it and whether they want to pursue it to the fullest extent that Fani Willis is pursuing the case. So it is not an end-all from this disqualification hearing. This would just determine Fani Willis and Nathan Wade's involvement in the future RICO case that we expect to play out involving former President Donald Trump. Now, a lot of people wondering, of course, what the former president himself thinks of all of this. The former president taking to Truth Social to lay out his thoughts on Thursday's hearing, saying, quote, Fani never paid cash. She got free trips and other things from her lover with the exorbitant amount of money she authorized to be paid to him, a giant scam and a witch hunt, end quote. Again, former President Donald Trump obviously very invested in how this plays out. I want to take you back out live to this courtroom as we wait again for court to resume really any moment now. I do believe they took a recess about 15 minutes ago. They did not clarify what time court would resume, but that they were waiting for all parties in this evidence hearing to arrive. But from former President Donald Trump's side of things, again, taking to Truth Social to talk about this, he also wrote, by going after the most high-level person and the Republican nominee, she, referring to Fani Willis, was able to get her lover much more money, almost $1 million, than she would be able to get for the prosecution of any other person or individual. That directly from former President Donald Trump. Again, Special Prosecutor, Nathan Wade, was paid more than $650,000 by the District Attorney's Office for his work on the Trump RICO case. That is according to county records. Now, Trump's Georgia attorney claimed that Willis failed to provide full transparency in her response and accused her of inappropriately speaking about the case in public. He also cited a speech that she had made earlier at Big Bethel shortly after those allegations did surface, saying, quote, apparently the DA believes she can make public out-of-court statements about race, this case, and the defendants whenever she wants, and the court is powerless to punish her by disqualification. And he went on to say, quote, our requested remedy remains clear. Dismiss the case and disqualify the DA together with her team and office from any related matters. And of course, if you wanting to follow the full timeline of all of these events, you can go to our website, atlantanewsfirst.com. Also available in the Atlanta News First app. As you can see right here, will take you through all of the key moments, the hearing highlights, and everything that has led up to today. This moment going back really the past couple of years and all of the key players involved in all of this. So we laid it out for you. You can hear the infamous phone call between former President Donald Trump and the Secretary of State, as well as the moments that Fani Willis and the District Attorney's Office began pursuing this case, brought down the indictments, that arrest that a lot of us remember happening right here at Fulton County Jail. Again, leading up to today, the disqualification hearing from a motion filed by Trump attorneys to dismiss Fani Willis, Nathan Wade, and her office from this case. Should that happen, which Judge Scott McAfee has said he is not making a decision today. He is only hearing evidence in this disqualification hearing. But should a disqualification happen, that case would just go to another prosecutor. And from there, it would be up to that prosecutor to decide how to proceed in pursuing former President Donald Trump and 18 co-defendants in a RICO case that really has rocked all of Georgia and captured the nation's attention. And again, our team here at Atlanta News First really keeping all eyes on this hearing, on any information that comes in. We have our reporter Rebecca Schramm outside the courthouse following closely what's happening both outside of the courtroom and inside. But I do want to play for you a piece of this interview. We spoke with an Atlanta attorney right here on how Thursday's hearing will impact the Fulton County District Attorney in whether she does face disqualification or not. Here is what Attorney Josh Schiffer had to say.
Both her performance and Mr. Wade's were easily considered evasive. I don't believe they answered the questions forthrightly and straightforward in a way that you would expect from people charged with such an important job. And I think it will be very hard for Judge McAfee to ignore that when he considers whether to disqualify or not.
And again, taking you back out to the courtroom, still in recess, still waiting for Judge Scott McAfee to return and resume the court hearing that would ultimately decide whether Fulton County District Attorney Fani Willis and Special Prosecutor on the Trump case, Nathan Wade, would face disqualification in Trump and 18 others, RICO and related charges, again, stemming from what the district attorney has said were allegations that the former president and co-conspirators tried to overthrow the 2020 election, or at least change the results here in Georgia. So again, a lot of people invested in how this disqualification hearing plays out from both sides of the aisle, but attorney that filed the motion, again, Michael Roman, still staying firm in his belief that taxpayer money, that financial conflicts of interest took place. That was the motion that set all of this off. By the way, Fani Willis, accused of not only having a romantic relationship with Special Prosecutor Nathan Wade, which she has since acknowledged in a 176-page document responding to Michael Roman's allegations and the motion that he filed on January 8th. But Michael Roman claiming, and this is really the center of what these hearings are about, Michael Roman really inquiring with the Fulton County District Attorney about the financial aspect of how that relationship played out, claiming in the motion, quote, the two have been engaged in an improper, clandestine, personal relationship during the pendency of this case, which has resulted in the special prosecutor and in turn the district attorney profiting significantly from this prosecution at the expense of the taxpayers. Now, in particular, Roman did claim in his motion that the two took lavish vacations together, something that was talked about in yesterday's hearing, with Fani Willis calling Nathan Wade a world traveler, that he had been to at least 6 out of 7 continents, that she was not as much a traveler, but that the two did vacation together, both domestically and abroad. And Roman claiming all the while that that the two used Wade's salary from the district attorney's office, the $650,000 payment for his work on the Trump case, he said that Willis didn't have the legal authority to appoint Wade as a special prosecutor, making ultimately this investigation invalid, and the motion then calling to dismiss the whole indictment involving former President Donald Trump and 18 others, as well as disqualify Willis, Wade, and the district attorney's office from prosecuting the case. Now, again, Judge Scott McAfee has had quite a passionate courtroom that he had to deal with yesterday. He ended up striking Fani Willis's testimony, at least giving her 2 warnings, I should clarify, about answering attorney questions within the context that they are presented. Of course, Fani Willis agreeing to those terms, but also pointing out that the questions are worded in falsehoods, and that is something that she remains strong in her stance, that the allegations are false, that the ideas that the attorneys are presenting in their line of questioning are not in line with the truth. So you have 2 sides of the story here, and ultimately it will come down to the Fulton County Judge Scott McAfee to decide whether Fani Willis, whether Nathan Wade will remain on this case. So we will continue to keep you updated, bring you live updates. Again, I just want to show you here our website, atlantanewsfirst.com. If you have the Atlanta News First app, it's a really good tool for big, complex stories like this. We really break it down and lay it out for you, the timelines, the key moments, the highlights from yesterday if you weren't able to tune in to this hearing that, by the way, began at 9:30 in the morning and ended at 5:15. Several hours, expected to continue into today, but a good resource for you, the Atlanta News First app to have. And of course, any major developments, the disqualification decision that comes down, we will ping your phone directly so that you can tune into that live coverage and get updated as soon as anything happens. And also just a fantastic tool, again, for breaking news and local news in your specific community. So Atlanta News First, the news app, it's free. It's a reliable source for news here locally, especially as we're following this case closely and new developments seem to be coming in left and right here. As we continue to take you back out to this courtroom, you can see the court reporter sitting there below, still waiting for Judge Scott McAfee and parties to arrive. If you missed the beginning portion of this live stream, we took you out to the hearing, which resumed at 9 a.m. It was suddenly paused at about 9:20, a little before 9:20, when Judge Scott McAfee said that not all parties were present in the evidence hearing, day 2 of this disqualification hearing, and that he was going to call a recess until all parties were present and in the courtroom. And that, as far as when that is going to happen, really any moment now, we can expect the judge to return, the parties to all be in the courtroom, attorneys and those involved in the evidence, the people giving testimony, the people weighing in. Again, Judge Scott McAfee making it very clear he wanted to hear from the innermost circle of both Fani Willis and Nathan Wade, and that has included subpoenas to Fani Willis's father, her ex-law partners, her former friends and current friends. Again, same with Nathan Wade. People who know their character, who know their professional work the best and their relationship to each other. That is all going to play out today as it played out yesterday. Now, no word on whether Fani Willis will return to the stand as of yet. We did not see her in the courtroom earlier today. However, that all still remains to be seen, and it really is up to the judge on how this is going to go and how he will ultimately make his disqualification decision. All right, continuing to take you to this live look inside Judge Scott McAfee's courtroom as court remains in recess in day 2 of a disqualification hearing for Fulton County District Attorney Fani Willis. Now, as we continue to bring you some context into what all has transpired in the past day and the full timeline of events, the motion leading up to today's hearing, and ultimately what will be a decision on whether Fani Willis and Nathan Wade will be allowed to stay on the case. We are going to take you out here in a couple minutes to our Atlanta News First reporter, Rebecca Schramm. She has been outside of this courtroom and often inside the courtroom throughout this morning, following closely, speaking with some of the people involved in this hearing. We're going to touch base with her and just check in on the latest of what's going on here. Let's try to get her online now. Rebecca, can you hear us all right?
Now, well, technical difficulty there.
All right, Rebecca, I think we have you here. Now, court still in recess. We're monitoring closely on when Judge Scott McAfee is going to be returning, but I wanted to talk to you a little bit. You have been standing outside of this courtroom following closely, minute by minute, all of the events that are happening in just the first 20 minutes of day 2.
Yes, and Maria, here's what happened. We were live on our broadcast channel at the very, very top of the hearing, so we missed the part where the judge was interacting with the attorneys to talk about what was next in the case. So now that I've had time to review that, let me explain what has happened here. We were initially expecting District Attorney Fani Willis to return to the witness stand because we were under the impression that the state would have its own questions for her under cross-examination, and that didn't happen. The state Representative Ms. Cross, who is with the district attorney's office, stood up at the very beginning of this hearing and told the judge, we have no further questions for Fani Willis. So that's the end of that. She will not have to return to the stand. Everybody just knew that she would have time to explain herself, some of the questions that the defense attorney asked her yesterday. But now it's starting to make sense because if you'll recall, the district attorney, Fani Willis, would often answer questions with an explanation, and that was beginning to annoy the judge. He said, answer the question, and then you can explain yourself. But in a lot of cases, she got combative and would basically expand on the question even when she was not prompted to do so. So perhaps this has been the plan all along, for there to be no cross-examination and for her to just try to explain herself as best she could on day 1. Well, you have to consider that's not a bad strategy, because how awkward would it be for Anna Cross and the others on that prosecutorial team to have to question their boss about her personal romantic relationship with someone else who works on their very team? So that would have just been a very awkward thing to happen. So it makes sense that the state would waive any cross-examination of Ms. Wade. Here's what's happening right now, Maria. We have a situation where yesterday early on, I know you were paying attention, and some of you at home watching were paying attention to this as well. A man by the name of Terrence Bradley briefly took the stand yesterday. He at one point was the divorce attorney for Nathan Wade. They at one point were business partners. They were both practicing law together, and he decided to take on the divorce case for Nathan Wade. And when he was asked specific questions about Ms. Willis, that is when he stopped answering questions. And he basically told the judge, look, I've been in touch with the bar, the Georgia Bar Association, and I've been instructed that I should not answer questions like this because it would violate attorney-client privilege. Well, that kind of posed a concern, and so he ended up being told by the judge, look, you may be called later, but for now, your testimony has ended. So, sure enough, what has happened is the judge returned to the bench this morning and said, now that I've had time to review this, here's what I'm going to do. I'm going to compel Terrence Bradley to answer questions that are outside attorney-client privilege, things that he has observed, things that he knows to be fact. I will not allow him to answer questions that would violate attorney-client privilege. So now we are waiting for Bradley to return to the courthouse. He's the only one left. The defense attorney, Michael Roman's attorney, Ashley Merchant, has no one else. She told the judge that is her last witness. That's the last person she wants to question. And so an attorney for him told the judge, Your Honor, he is at a doctor appointment right now. He's right in the middle of a doctor's appointment. The earliest he can get here is 10 or 10:30. So within the next hour, we should have a situation where Terrence Bradley walks back into the courtroom and continues his testimony. If he does not answer questions under the judge's order, the judge will have no choice but to hold him in contempt of court, and that would be a problem. So this is going to be very interesting to see how all of this plays out. Clearly, the defense and all the attorneys for Trump and the co-defendants would like to hear his testimony that the relationship between Fani Willis and Nathan Wade happened before Wade was brought onto the case. That would show perhaps more impropriety. But as we were talking earlier, Maria, you know, the situation here is looking pretty dark for the prosecution in the Trump case here because of all of this. And a lot of that has to do with the mere fact that I don't think anybody would disagree that Willis has made some serious misjudgments in this case. She has taken some missteps here. Now, whether she was trying to deceive anyone or take money that, you know, from these vacations and that sort of thing, that's unclear, but surely this is going to be a situation where it just doesn't look good for Fani Willis. So we'll send it back to you, but a lot to watch as this case continues to unfold.
Rebecca, thank you so much. And again, we will look to you for our Atlanta News First News at noon, where I know you'll have a live report and an update for us into this hearing. All right, thank you. So taking you back out to this courtroom here, as you can see, still in recess, still waiting for Judge Scott McAfee to return and resume court. We really did not expect a recess this soon. We were talking about a court hearing that started at 9 o'clock on the dot and then went into recess less than 20 minutes later. But of course, the explanation there is that not all parties were present, as we just took you out right outside of the Fulton County Courthouse, where this courtroom, this court hearing is going to continue underway today, expected to continue underway today, as our Rebecca Schramm following closely at every development to stem out of this. Now, really, it is anyone's guess when court will resume. However, we are told that they are just waiting on one person to arrive to this courtroom, and then we can expect to take you back live out to that hearing, back to Judge Scott McAfee and attorneys as they continue to present evidence in this hearing that will ultimately decide whether Fulton County DA Fani Willis and Special Prosecutor Nathan Wade remain on this the Trump RICO case and the prosecution of former President Donald Trump and 18 co-defendants, or whether it will go to another prosecutor that will ultimately have to decide how they want to and whether they want to proceed with this case altogether. So a lot on the line here, but all eyes right now on Fulton County District Attorney Fani Willis. I am seeing a lot of your comments and questions here. As we work to get those answered, you can also go to our website, atlantanewsfirst.com. All of the timeline, the key figures and highlights that have stemmed through all of this, including yesterday's hearing, if you missed it, lasting several hours into the day from 9:30 in the morning all the way to 5:15 today. Not expected to be as long, but still a very heated evidence hearing, as you can imagine, as attorneys continue to push their argument that there was a financial conflict of interest and ethical boundaries that were crossed that should ultimately disqualify Fulton County District Attorney Fani Willis and Special Prosecutor Nathan Wade, both Wade and Willis saying that those allegations are not true, that they are a lie, that while they acknowledge the personal relationship that took place, Fani Willis responding to the Trump attorney Michael Roman's motion filed on January 8th with a 176-page document herself, Fani Willis saying that the allegations presented, the line of questioning that attorneys have presented in Thursday's hearing, are false. They are, in her own words, a lie. She says that she did not cross any ethical boundaries or misuse taxpayer funds or have a otherwise questionable financial expenditure of district attorney's office funds in connection to her relationship with the special prosecutor on the case. So there is a lot still up in the air right now, and ultimately it will be on Judge Scott McAfee to decide whose argument is presented best and what the decision would be, whether to keep Fulton County District Attorney Fani Willis and Special Prosecutor Nathan Wade on the Trump RICO case, or whether to disqualify them and send that entire case to another prosecutor. And as we continue to wait for court to resume, I did just step away to talk offline with our reporter on the ground, Rebecca Schramm, just to get as much notice of when we can expect court to resume, or at least when that last party will arrive in the courtroom. That will be the best indication for us on when Judge Scott McAfee will resume day 2 of the disqualification hearing. I see some of your comments here on YouTube. I wanted to take this time to just answer some of them, mostly around the allegations against Fani Willis. A lot of people asking, why does the romantic relationship matter? And it is less so about the personal relationship that Willis has acknowledged with Special Prosecutor Nathan Wade, and more about the motion filed by Michael Roman, one of Trump's attorneys in the RICO case, out of Fulton County. That was filed on January 8th, and in which Michael Roman has claimed that both Fani Willis and Nathan Wade have been engaged in an improper, clandestine personal relationship, as I'm reading directly off of the motion, during the pendency of this case. That has resulted in the special prosecutor, that's Nathan Wade, and in turn the district attorney, Fani Willis, profiting significantly from this prosecution at the expense of the taxpayers. So, if you are going to take away anything from this, the allegation here isn't whether Fani Willis and Nathan Wade had a romantic relationship. The allegation being discussed here is whether Fani Willis and Nathan Wade misused taxpayer money and crossed ethical boundaries in pursuing Trump's RICO case, and that involving 18 others. Again, if other defendants were to join Wade's motion, the judge's decision on the case would still have to be whether to keep Fulton County District Attorney Fani Willis and Nathan Wade on this case, or whether to send this to another prosecutor altogether. Now, Fani Willis, in the meantime, has been very outspoken about this situation. she responded with a 176-page court filing directly in response to that motion filed on January 8th. Her response coming on February 2nd that basically said that the two were in a personal relationship. She has acknowledged that. That is has been confirmed by Fani Willis herself, but she argues that it is not grounds for disqualification and that funds were never misused at any point from the district attorney's office. Now, Willis has also said that she and Wade were not in a relationship when Willis hired him as a special prosecutor in the case against former President Donald Trump. That was back in 2021. Now, on January 18th, just 10 days after Michael Roman's filing, Willis filed a motion of her own to toss her subpoena in Wade's divorce case. The motion arguing that Wade's estranged wife, Jocelyn Wade, was conspiring with, quote, interested parties like Roman and using the subpoena to interfere with Willis's investigation against Trump. So as you can imagine, a lot of drama has stemmed from that motion, from these allegations against Willis. Now, Willis claiming and addressing Wade's marriage and his divorce proceedings, that Wade's marriage was ultimately an irretrievably broken as far back as 2017, before Willis and Wade had even met. So in that case, Willis's testimony would be irrelevant, and the subpoena is only meant to embarrass her. Those were her words, her arguments herself, as she faces, again, from all sides, questions about her role and her intentions in pursuing former President Donald Trump in a very highly publicized and national, almost, at least capturing national attention in her RICO indictments of the former president. Now, meanwhile, I want to make sure we talk about both parties here. Former President Donald Trump and his attorneys have been watching this hearing closely. I mean, former President Donald Trump taking to Truth Social himself to say, quote, Fani never paid cash. She got free trips and other things from her lover with the exorbitant amount of money she authorized to be paid to him. A giant scam, a witch hunt. That directly, again, posted last night, or yesterday evening, I should say, from former president onto his media platform, Truth Social. He also went on to say that by going after the most high-level person and the Republican nominee, referring to himself, of course, she was able to get her lover much more money, almost $1 million, than she would have been able to get for the prosecution of any other person or individual. So former President Donald Trump's argument here is that he is being prosecuted and pursued by Fani Willis just as an attention grab or a career grab, essentially. But ultimately weighing in that he believes she deserves to be disqualified, of course, because that impacts whether she pursues him or whether another prosecutor will take on the case, and ultimately whether the case will see trial. Now, talking a little bit about Special Prosecutor Nathan Wade, he was paid more than $650,000 by the district attorney's office for his work on the Trump case. That began all the way back in 2021. That is directly, according to county records. Trump's Georgia attorney, meanwhile, said that Willis has failed time and time again to, quote, provide full transparency in her response regarding the relationship, regarding the financial transactions. That was center focus for yesterday's hearing, was how the district attorney's office was using funds and how those funds and the spending of those funds played out throughout the timeline of Fani Willis and Nathan Wade's personal relationship. Take a listen to some of what she said.
You think I'm on trial? These people are on trial for trying to steal an election in 2020. I'm not on trial, no matter how hard you try to put me on trial. But I didn't give him money out in a contract. What happened? No, we're going to answer it since you said it. He worked more hours than he was paid, and the county paid him for the work that he did. So don't be cute with me and then think that you're not going to get an answer. I don't need anybody to foot my bills. The only man who's ever foot my bills completely is my daddy.
And again, Fulton County District Attorney Fani Willis speaking out about the financial aspect of these allegations and questions about whether any ethical boundaries were crossed in the vacations that Fani Willis and Nathan Wade took together, in how district attorney funds were used, how taxpayer funds were used. That is what attorneys in this hearing are trying to prove. All the while, we talked to Atlanta attorney Josh Schiffer on what he thought of Thursday's hearing and how it could ultimately impact the disqualification decision. Take a listen.
Both her performance and Mr. Wade's were easily considered evasive. I don't believe they answered the questions forthrightly and straightforward in a way that you would expect from people charged with such an important job. And I think it will be very hard for Judge McAfee to ignore that when he considers whether to disqualify or not.
And again, taking you back out live to this courtroom as we are still waiting, now 10:16, for the return of Judge Scott McAfee and all parties that he said were missing from this evidence hearing. As soon as that last person really returns, we do expect that court will resume. I have been talking to our reporter, Rebecca Schramm, who you just heard from moments ago, standing outside of the Fulton County Courthouse, just weighing in on the moment right now that everyone's waiting for this hearing to get underway, to hear from that last person who heavily tied to and involved in Nathan Wade's divorce, and to ultimately speak on the relationship between Fulton County District Attorney Fani Willis and the special prosecutor and any financial actions that have come out of that. I think, again, making sure that we clarify for you the center focus of these allegations from attorneys is the financial allegations. The attorneys arguing that the two took lavish vacations together and used Wade's salary from the district attorney's office in their relationship, misused taxpayer money, and crossed ethical boundaries. That is what attorneys today are going to be working tirelessly to prove to the judge. That is what Fani Willis and Nathan Wade have said is false and have refuted in their testimony yesterday. For those of you asking if Fani Willis will be returning to the stand, we did not see her in the courtroom earlier this morning. However, that is still to be seen. We have heard from Judge Scott McAfee that he wants to focus today on the evidence side of all of this, that he wants to hear from the innermost circle for both the special prosecutor and district attorney. So it could very well be that the two are not heard from today, but that remains to be seen as we continue to hear evidence in what will ultimately be a very difficult decision for the judge presiding over this case, Judge Scott McAfee, to determine whether Fulton County District Attorney Fani Willis should remain on a case like this or whether to move it along to another prosecutor. And again, still waiting for that final party to arrive into this courtroom. If you're with us earlier, we took you out to reporter Rebecca Schramm, who has been outside of this courthouse, following closely every development as we bring that to you. That last party, by the way, Terrence Bradley, whose testimony is being compelled by the Fulton County judge presiding over this case, Scott McAfee. Bradley declined earlier to answer any questions about the relationship between District Attorney Fani Willis and Special Prosecutor Nathan Wade. Now he is being compelled. So it is a matter of getting him back into the courtroom to testify, to answer questions. Again, we heard a little bit from Terrence Bradley on Thursday that he said he'd been advised by the state bar to not testify about the couple's relationship. But the judge, of course, compelling him, not having that answer, and now it is a matter of waiting for Terrence Bradley to return to day 2 of this disqualification hearing, and we will expect to take you live out there as soon as court resumes. Now, earlier there was speculation that court would resume at about 10 o'clock after taking an abrupt recess just before 9:20 a.m. It is now 10:21, so really momentarily, any minute now, we can expect to take you back out live to this court hearing. However, it could be several more minutes. It really is anyone's guess on the arrival of Terrence Bradley. That is what we are following closely. We are standing outside of this courtroom, so as soon as we see him, we will let you know. And of course, as soon as we see Judge Scott McAfee again returning into this courtroom, you can expect we will bring you those live remarks and the resuming of this court proceeding and the hearing that will ultimately decide whether Fani Willis, Nathan Wade will remain on the investigation and the case pursuing former President Donald Trump on racketeering charges. Court again, remaining in recess. Willis has not been called back to testify for day 2 of the hearing, so it is unlikely she will appear. However, she could make an appearance. It is, again, anyone's guess, but she has not been called back for testimony. Earlier, at about 9:02, a little after 9, we did see former Georgia GOP Chair David Schaefer in attendance. We also saw former Atlanta Mayor Shirley Franklin, former DeKalb County CEO Vernon Jones, Steve Sato, of course, in the courtroom representing former President Donald Trump, Ashley Merchant, who, as you heard from questioning Fani Willis throughout her testimony, the district attorney and the attorney, Ashley Merchant, and John Merchant presiding for Trump co-defendant Michael Roman. Again, a very fiery discussion, very passionate line of questioning, and Fani Willis's response. The attorneys, again, representing co-defendant Michael Roman, are really at the center of this. This stems from a motion filed on behalf of Michael Roman that ultimately alleged that Fani Willis and Nathan Wade had some sort of financial conflict of interest and misused taxpayer funds in their investigation into former President Donald Trump, leading today to this hearing to determine whether those allegations are true, whether the motion from Michael Roman's attorneys have merit, and in terms of how that will play out today, that is what Judge Scott McAfee said he is focused on, is the evidence in this case, in this hearing, is hearing out the testimonies and the evidence presented, and then ultimately making his decision after that. So many players in the courtroom today still waiting on that last person, Terrence Bradley, and his testimony, which has now been compelled by Fulton County Superior Judge Scott McAfee.
You want me to look at?
All right, and as we continue, court remaining in recess, but we just want to bring in some context, background, and continue this conversation as a lot of details have stemmed. I want to now bring in Atlanta News First reporter Adam Murphy. Adam, you have covered court proceedings, court hearings, this one being historic all on its own, but watching this from a journalistic perspective, from being in Atlanta for so long, I mean, what comes to your mind?
Stunning. I mean, like most people, I think, that saw the testimony yesterday, they were glued to it. I was glued to it. It was actually difficult to kind of do what I needed to do yesterday. I was working on a completely different story, but was just enamored by what was going on. I mean, this is really historic. I mean, it's historic in itself that a RICO case has been brought against a former president, and then now this, and this is just one big giant mess, quite honestly. I think it's really interesting that we heard the testimony, obviously, of the lead prosecutor, Nathan Wade, and then out of the blue, we weren't expecting the district attorney herself, Fani Willis, to actually come into the courtroom, but I think she was so disturbed and upset by some of the things that have been said, she just marched into the courtroom and took the stand, asked to take the stand. She came in, she was visibly upset, frustrated, somewhat at times, I think I would say a little bit defensive, but yet she wanted to make a point. And what's interesting about all of this is it's going to be a difficult decision for the judge. And I know the judge has said, well, we're not going to decide in the courtroom. I'm not going to come down with a ruling in the courtroom. But really what this all boils down to, it seems like, and there's a lot of, details about the personal relationship that, it became center stage, I think, with a lot of the testimony yesterday. But at the end of the day, this is really all about whether the money that they received, that Nathan Wade received, obviously, to do his job, was used for them to go on lavish trips. And what their story is between Nathan Wade and Fani Willis is that this money was reimbursed in cash. So what makes this interesting is there's really no proof. That's their story. They're sticking to it. One might argue, well, gosh, if you were in a relationship, you guys were going on these trips and you're prosecuting a former president, you would want to have some sort of receipts or documentation to show that you did reimburse money and there was no use of these tax dollars. But at the same time, we're talking about cash, and it's very possible that, she could have paid back the cash, and if she did pay back the cash, well, then it's this thing is not as big of a deal as one might think, and I think she continues with the case if that's true. But we just don't know. And that's what's so interesting about this, Maria. It's going to be a 50-50 call by the judge, I think, based on whether he believes their testimony.
It really is. I think we were talking to Atlanta attorney Josh Schiffer, who said this is going to be a difficult decision for Scott McAfee to make. But some of what's been playing out both yesterday and going into today really starts to paint a picture for you. And I want to answer some Atlanta News First YouTube comments that we're getting. By the way, if you are watching this, we are streaming out across all of our digital platforms. So we got Roku TV, Apple TV, Amazon Fire TV. Of course, you can join the conversation on YouTube Live. But some people were asking, what are we waiting on? It sounded like court was starting, and now we don't see anybody in the courtroom. Just to take you back out here, still very empty, as you can see. We are waiting on all, and this is Judge Scott McAfee's, words directly. We are waiting for all parties needed in this evidence hearing, in day 2 of the disqualification hearing, to arrive, and that last person still outstanding is Terrence Bradley, whose testimony is now being compelled after he said that he was advised by the State Bar of Georgia to not testify about the relationship of Special Prosecutor Nathan Wade and Fulton County District Attorney Fani Willis. The judge presiding over this case now saying, that's not good enough. You are now being compelled to appear and to testify and to answer questions as we continue to hear evidence in all of this. And that has really been the theme here, is getting an idea from the innermost circle of both Fani Willis and Nathan Wade, and getting an understanding of what their relationship was and the timeline in line with the accusations made by attorneys on the mishandling of taxpayer money and any ethical boundaries that were possibly crossed.
Well, Maria, also, too, you talk about what we're waiting on. Yeah, that's right. I mean, there was some anticipation that Fani Willis might actually return to the stand today. I was listening this morning to you here on ANF Plus and heard everything in the courtroom. They talked about the fact that the state had said no further questions. She wasn't coming back. And then it was a matter of this next witness arriving at the courthouse and coming in and testifying. And that individual was not there, so they've been waiting, and they went into recess. I think it was interesting, too. This may be a factor, and should be, I think, in the judge's overall decision here at the end of the day, and that is the former employee in the DA's office that testified, I believe, early on yesterday via Zoom, and talked about this relationship between Fani Willis and Nathan Wade, her noticing a relationship of some sort taking place around the office, I believe dating back to 2019. Am I right about that, Maria?
I do believe in her response to the motion filed by attorneys for Michael Roman. She quoted 2021, but they might have had met back in 2019.
Yeah, I think that, you know, if you go back and listen to that, she talked about she felt like there was some relationship going on even prior to what the DA and the lead prosecutor had said about them, you know, having a relationship beginning around 2022. Mm-hmm. It's really critical because it's like we need to know whether, you know, there was some sort of preferential selection made by the district attorney with Nathan Wade based on their relationship. And so we have, you know, two different accounts there. So I think that, you know, these additional witnesses that may be able to kind of give us a better sense of how long this relationship had been going on and when it began will be very important for the judge to decide, because it's a big factor in the overall decision as well. So it's going to be, I'm sure, some more interesting testimony that we'll see throughout the day. It's just a holding process at the moment.
Yeah, certainly. And I just want to point out some of the interesting parties that were in attendance for this. You obviously are going to have the attorneys, the people who are testifying, but we also saw former Georgia GOP Chair David Schaefer. We saw former Atlanta Mayor Shirley Franklin, former DeKalb County CEO Vernon Jones. This has captured a lot of interest, of course, locally, but also on the national stage, as you see many of these characters. And I think we were talking to another attorney here in Atlanta, Suri Chada Jimenez, who said, it's just good TV.
It certainly is, you know, and it's the classic, although this is not like a criminal trial, you know, you think back to some of the big trials in history and people stop what they're doing and they watch, and it's fascinating. And this has caught the attention not just of residents in Fulton County, the state of Georgia, but across the country. And obviously with the use of social media platforms, it's everywhere. I mean, no matter where you go, the national network news, you know, is carrying this story, talking about it, dissecting it, and it's all over the social media platforms. It is the story across the country, and it's happening right here in Atlanta, Georgia, in a Fulton County courthouse.
So I got to ask you, you've been really Atlanta's favorite community journalist. You've covered so many stories here locally. There's a profound uniqueness to what we're following today, but does this spark any memories for you?
Well, I have to say this. Back in 2021, I believe it was, when Fani Willis was then running for district attorney, and we were still in the midst of COVID restrictions and things like that, I did an interview with her. And I did that via Zoom, and she was obviously, she's a politician, so she was running for this position in this seat. And she came across very sharp and kind of a bulldog, which is exactly what, you know, a district attorney needs to be. So I have to say, just from a personal standpoint, I'm a bit surprised by this turn of events in this particular case. I mean, this is, you know, no doubt in her career really the biggest case. I mean, and it could be considered one of the biggest cases in American history against a former president. It's just unprecedented, right? So for this to all unfold, was a stunner, and it's a stunner regardless. But just based on my interview with her and talking to her, I would have never imagined we'd be talking about this today, and this is where we are at. And I think what's interesting here, if she is disqualified, Maria, there's a number of things that could happen. It doesn't mean this case goes away. It could be turned over to the Attorney General, and the Attorney General could appoint another DA to take it on. It could then the judge could assign somebody else, I presume, as well, another district attorney. And that could mean the case goes on, but then it also could mean that if another, district attorney gets a hold of it, they might say there is no case here, or there is no RICO case. Maybe there's a different way to go about it. But this is a significant hearing that is happening right now and can change the outcome of this case potentially. So we'll see how it goes.
Yeah, certainly. And I just want to play some of what we saw play out yesterday from the district attorney herself, some of her words and reactions to the line of questioning she was receiving during her testimony.
You think I'm on trial? These people are on trial for trying to steal an election in 2020. I'm not on trial, no matter how hard you try to put me on trial. But I didn't give him money out in a contract. What happened? No, we're going to answer it since you said it. He worked more hours than he was paid, and the county paid him for the work that he did. So don't be cute with me and then think that you're not going to get an answer. I don't need anybody to foot my bills. The only man who's ever foot my bills completely is my daddy.
So, again, some sharp responses and, again, fiery testimony from Fulton County District Attorney Fani Willis. We were all glued in here at the newsroom to all this. I mean, it was hard not to watch every single moment as it happened over the course of several hours. Just talking a little bit about her response. Of course, she is defending this allegation that she misused taxpayer funds, that she had crossed ethical boundaries in her relationship that she has acknowledged happened with Nathan Wade. But she is standing firm in saying that at no point was she unethical or had misused those funds. The only thing that had happened was that there was a personal relationship, which is not illegal or grounds in her mind for disqualification. Well,
this is, obviously has serious implications for the RICO case that her team, her DA squad is working on. But it's also this hearing, has an impact on her credibility. And so that's why I think, you see her coming into the courtroom like she did, and she's firm, and that is her style. I mean, like I said, going back to my interview with her before she took office when she was running for the seat, 2021, she was firm, she was feisty, in my words, she was a bulldog. And so she had that tone and that approach yesterday. Some might see it, though, as a bit defensive on certain things, but she is herself, and she was firm. And it was really kind of, in my opinion, a bit of a contrast to that of the lead prosecutor, Nathan Wade. I saw him a little bit differently than I saw her. I mean, I think, he, at times, just his body language and everything, he was, looked maybe a little more nervous. She seemed pretty confident. I don't know at the end of the day if that really matters. It's all about, the judge cares about the facts of the case, and is there evidence here that is worthy of disqualification and moving this case to another courtroom. And I think today will be instrumental in kind of helping the judge finalize those thoughts and make a decision.
And I do want to point out the judge has already come out and said, hey, don't expect that decision to come down today. He wants to hear evidence, but he has said himself at the very start of this and a little yesterday, he does not expect to come to a disqualification decision. And so the implications to come out of that, the question of who's going to be prosecuting former President Donald Trump and the 18 co-defendants in this RICO case. What Fani Willis's involvement will or won't look like, that remains to be seen, and that is an answer that we might not be getting today.
Yeah, and I think another thing that's really significant here, too, depending on what happens with this hearing and whether the Fulton County DA's office continues on this case or not, you have to remember we have an election in November. We have a presidential election in November. And you'll recall DA Fani Willis talk about how she wanted to get this thing rolling and in historic proportions. I mean, she talked about having all these, 19 different co-defendants, right, in this RICO case, and she wanted to have all of them tried before the election. And this does not bode well at the moment for accomplishing that goal. And so if this case, if she's disqualified and it's moved somewhere else, the likelihood of this being tried before the November election is slim to none.
Well, let me ask you this. Hearing Nathan Wade's testimony, hearing Fani Willis, hearing some of their friends and innermost circle, what are you looking for out of today, or what do you expect will happen as really all of us tune in and nationally the country tunes in to this if just fiery and passionate testimony that's going to continue to play out now in the evidence portion of this disqualification hearing?
My feeling is it's like there needs to be a little more investigation into the money trail, because that's going to be the determining factor here. And right now, without a trail, and we're talking about the testimony yesterday from Mr. Wade and Mrs. Willis about reimbursing Mr. Wade in cash, there's no trail. And so I feel like we need, some more evidence, a little more investigating into the payment part of it. I would say the judge would need that to make a thoughtful decision. And I think another part of it, too, is, how long was this relationship going on? Was it going on again? Do we believe it was going on prior to Mr. Wade being selected as the lead prosecutor? Now, there's been a lot of pushback from some saying, well, Mr. Wade has never tried. He was never, a lead prosecutor before and had never tried a felony case. And some, had concerns about that. And then all of a sudden he's dealing with perhaps the largest RICO case in our country's history. So it's, that date of that timeline of, the relationship beginning and, some more evidence, in my opinion, about the financial part of this is significant. And that's what I would be digging for. That's what I would be looking for. That's what I would be asking about.
And, of course, we have a hardworking team of Atlanta News First reporters, our Doug Reardon and Rebecca Schramm, out there following this minute by minute. Our team here in the newsroom also keeping an eye on the people providing testimony, the characters that we've seen in this courtroom and the timeline and how that's all tying into today, the evidence hearing and ultimately the decision. I do believe we have some movement in the courtroom. So I do see attorneys returning. I think Terrence Bradley might actually have arrived. So we should be seeing court picking up here really any moment now. It was quite an empty site for the past hour, but we're seeing some bodies, some movement, and hopefully Judge Scott McAfee returning to resume court and continuing into day 2 of this disqualification hearing. Adam, before I let you go, any final thoughts?
Well, hopefully we get more answers today and more concrete evidence. That's what we need. I think the judge needs that. Because, like I said, I go back to the money, and that's what, in my opinion, this seems to be all about. Because if we're talking about, misuse of funds and unethical behavior from the DA's office, that it's all about the money trail. Yep. And so hopefully whatever witnesses are brought today, whatever evidence is presented today, will give us a little bit better look into that and maybe some more answers. And you're right, you can see they're gathering in the courtroom right now. There's some discussions going on. I think that the judge will probably, looks like the judge is probably going to hit the gavel here in a moment and bring the court back into order, Maria.
Awesome. Adam, thank you so much. We will be taking you out live now into this courtroom here as we continue to bring you live coverage both on air, online, right here on Atlanta News First Plus. And it does appear that Judge Scott McAfee is now re-entering the courtroom. You should hear his remarks here in a moment as he brings court back to session, and we continue to bring you live coverage of day 2 into this disqualification hearing.
Is still not with us in person. However, there's a proposal to potentially move on to other witnesses. Why don't we start with the state? Ms. Cross.
Thank you, Your Honor. Yes, in order to be efficient with the court's time, we have a witness here that I'm prepared to take out of order, and it sounds as though there's no objection from the defense, so we can do that at the court's convenience.
We don't have any problem taking him out of order, but it's our understanding it's Governor Barnes that he's here to establish that he was the first choice of Ms. Willis, and she testified to that, so I think she's cumulative. Why we can't call him to establish the fact that's already been established. We're not refuting that fact. We're impeach her on that fact.
Ms. Cross, I think did she say it was her first choice? Did she not say who was her first choice?
I think I don't believe that the governor's name was mentioned. I think there are some facts and circumstances surrounding the search for someone to take over the lead of this investigation at that time. Now prosecution is something that, given the allegations in the case, is certainly relevant.
All right, and it doesn't sound like it would be all that long a witness.
I don't think
anyhow. All right, so in that case, we can transition over, and Ms. Cross, I'd like to call your witness.
Thank you. The state would call Governor Roy Barnes.
And Judge, just so I'm clear, so you had told us not to ask questions about qualifications, so we did not ask any of our witnesses about qualifications, so the state's now going to bring in evidence of that. We would just ask permission to now be able to go into that.
Sounds to me, well, Ms. Cross?
If you want to ask Governor Barnes about his qualifications, I mean, that's certainly something he'd have knowledge of. I don't know what his basis of knowledge for anyone else's qualifications might be, but I also don't think that opens the door to anything other than what my understanding of what the testimony will be.
As I hear it, the issue of qualifications versus who was her first choice is going to be relevant to her intent, maybe, and perhaps that issue of the case in whole. I don't think that necessarily opens the door. We'll see how it goes.
I believe he's being brought up, Your Honor.
All right. Ms. Cross, assuming this may be a 10 to 15 minute witness, does the state have other witnesses on deck that they'd like to go forward with as well?
Yes, we called to gather everyone we could, so we can go forward with another witness, I believe, after this one.
All right, appreciate it.
I do. Roy Eugene Barnes, Royeugene, Barnes, Barnes.
Say, good morning, Mr. Barnes. Can you tell the court a little bit about your background as it relates to your service in public service?
I was first elected to the state senate in 1974 from Cobb County, and I served 16 years there. And then in 1990, I ran for governor and was defeated. And 2 years later, I went back to the House of Representatives. I was elected to the House of Representatives and served 6 years until I was elected governor in 1998, and I served in that position until January of 2003.
And after serving in the position of governor, can you tell the court a little bit about what you transitioned into after your public service?
I did exactly what I was doing before I was elected. I went back to practicing law in Marietta, Georgia, with my daughter, who's now judge of the state court, and my son-in-law. And now we have I think 6 or 7 lawyers. Charlie Bailey back there was one of them at one time.
Okay. And Governor Barnes, would you consider yourself to be a trial lawyer?
Yes.
Okay.
We don't write contracts or we don't write wills. All we do is try cases.
And I want to direct your attention back to 2021, where you were approached by the District Attorney of Fulton County, Fani Willis, about being a special prosecutor.
I was. I don't recall the exact date, but I know it was sometime in 2021. And she asked me to come down, and I met with her and Nathan Wade, and there were several other in the meeting. She asked me, said they were beginning this investigation, and she asked me if I'd be interested in being special prosecutor, to which I replied that I had mouths to feed at a law office, and that I would not do that. And also, I just had a bad, well, I won't say bad because it happens from time to time, but I just had the FBI to report a fella, militia trainer, to me that said they were concerned that he was making threats against me, and because I thought it was because of the flag, but I asked him and he said no, it was because I was too close to the Jews, quote unquote. And I told DA Willis I'd lived with bodyguards for 4 years, and I didn't like it. And I wasn't going to live with bodyguards for the rest of my life.
Ultimately, you turned down.
Yes. Yeah, I told her. I said, I'm not interested.
Nothing further from the state.
Ms. Merchant.
Morning, Governor Barnes. How are you?
Just fine. How are you?
Good to see you.
Good to see you.
You said it was sometime in 2021. Do you remember?
I think
if it was
was. I don't remember the dates. They all go. I could look it up on my calendar at the office, but I don't have that.
Well, I want to ask you about some statements that Ms. Willis made March 28th, 2021. She was talking about assembling a team for this case. Are you familiar with her work assembling a team for this case?
Well, I assume that's what she was talking to me about. But besides that, I don't know.
And I know you had said you had a meeting with some folks, and Mr. Wade was at that meeting?
Correct.
Okay. So he was with the district attorney interviewing you about taking this case?
Well, he, of course, I know Nathan very well, as you do.
Yes.
And I exchanged pleasantries with him, but the conversation was with Ms. Willis.
Okay, with Ms. Willis. Were you aware at the time that her team consisted of Brian Watkins, Megan Vargas, Sonia Allen, Shannon Trotty, Sal Chan, and John Floyd? She had reported that was her team on this case.
I know John Floyd was involved, and she probably told me the others, but listen, I barely remember what case I tried last year, much less every word that was said in the conversation.
I understand, fair enough. But she said she was looking to hire more lawyers and investigators to work on this case?
She told me, it was to me, she said, would you be interested in being special prosecutor in this case? And I gave the reply that I've already known. I mean, about hiring other lawyers or whatever, I don't know. All I can testify to is what she told me.
Did she tell you at all why she wanted to hire special counsel and not use someone who was an ADA, not have an actual employee?
No, she did not. I mean, we did not discuss that, and but I would assume it was because in a case as big as this that you'd have to have some decision help. I know John Floyd has been in some cases over the years out in Cobb County, for example, and others.
Would you agree that an employee of her office, someone who was paid a state salary or a county salary as an ADA, could handle a case like this?
I couldn't tell you that unless I knew the person, knew their experience, and really had been with them in a courtroom.
All right.
Has an opinion on that.
Thank you.
Yes, ma'am.
Say no.
Hello, Mr. Sadow.
It's been a while.
It has been a while.
I hope you're well.
I'm doing fine, just getting older, but that beats all time.
That's true, but that applies to all of us, I believe.
Yes.
I think you indicated that if you had your calendar, you'd be able to pinpoint a date for us.
I would.
Is there a way for you, for example, at a break, before you actually leave, to contact your folks to see if you can get a date?
I guess I could. I don't know how far back we archived those, but I assume I could.
Would you be willing to give that a shot for us?
I mean, I'll do whatever the court instructs.
So if I ask the court and the court says, go ahead and you could do it, that's all right?
I'll do whatever the court instructs.
I hear you.
And you should too.
I try to live by those words. I'm not always successful, but I try. If I pinpoint a date, for example, I think the record is clear that Mr. Wade was hired for the position on November 1 of 2021. Does that help you at all?
No, it does not.
Okay. Then let's go to the meeting. It sounds like it was just one meeting.
Yes.
And could you tell us where that meeting took place, if you remember?
It was in the conference room adjacent to the district attorney's office.
So was it in this, or the adjoining building?
It was in the Lewis Slayton building.
And District Attorney Willis was there, obviously, right?
Yes. Yes.
And Mr. Wade was there?
The best I recall, now I could be mistaken about that, it's like anything that far away, but that's my recollection.
Do you have a recollection of anyone else being present?
Yeah, there were some other folks, but I don't remember.
Do you remember, were you introduced to Mr. Wade by anything other than you already knew him? Was he given a title or anything? So at least as you're there, if I heard you correctly, Ms. Willis did all the talking, Mr. Wade did not.
I mean, we exchanged pleasantries, but as far as the basis of the conversation, the reason I was there, Ms. Willis did the talk.
And would you be able to give us an estimate of how long this meeting lasted?
Probably,
just rough.
Probably an hour.
And during the meeting, you made it clear, but it was the thanks for the offer, but no thank you.
Oh, yes, I did.
Who is now on the witness stand taking questions in the Fani Willis disqualification hearing at the Fulton County Courthouse. The former governor is there because apparently he was asked by Fani Willis, the DA, to be the lead prosecutor. He declined. That's a job that eventually went to Nathan Wade and leads us to where we are today. So we're going to continue streaming this coverage of this hearing live in its entirety on ANF Plus. You can find ANF Plus streaming through Roku TV, Apple TV Plus, and YouTube, or anywhere else you stream. Again, this hearing is airing live in its entirety right now on our various streaming platforms, and we'll have a complete wrap-up of the hearing coming up on the Atlanta News First News at noon. We'll see you then.
Syria one time for beheading a client of mine, recovered $82 million. I guess that's the best high profile, but that was in D.C. I tried that up in D.C.
And what would be considered complex cases, you've handled those as well, correct?
Yes. I mean, we regularly do mass torts, class actions, business torts, breach of contract, and most of those are complex, requiring many experts. We also do malpractice. I did malpractice defense for about 25 years, but since I've returned from the governor's office, I try not to represent an insurance company anymore, and I just tried a malpractice case before Judge Edlin in November. And those are complex cases because of the type of, medical knowledge and that you have to have, and also because of the many experts that you have.
Thank you. Did Ms. Willis, and this is the last question, did Ms. Willis tell you why she had sought you, why you had been her choice?
No, I hadn't, but, I get consulted fairly often on major cases.
Would you believe, based on circumstances in which you were given the offer, that it had to do with the fact that you had handled complex and high-profile cases in the past?
It could have been. I know her very well. I tried a case against her. She worked for the JQC, and I represented Judge Robert Crawford, Mac Crawford, and she prosecuted him, and I defended him. She beat me at the trial. I turned it around at the Supreme Court.
So you had some experience with
it? Oh, I had plenty of experience with it. She's a very qualified young. Well, everybody's young to me, but she's a very qualified young woman.
After that one occasion, did you have any other contact with her in reference to the position itself or who she might be considering?
I had some conversations with her or Jeff DeSantis or some of those, but not really an in-depth, about who she should hire or anything like that.
Did the name Nathan Wade come up in those conversations with her? No. Right?
No. Nathan was there, I thought. Now, I could be mistaken, but I thought Nathan was there when I...
For the conference?
Think Nathan was... I'm positive Nathan was there when I met with him.
Right. And my question was probably poorly worded, but what I was asking is after the conference and whatever consulting you might have done,
yes,
did Ms. Willis or Mr. DeSantis bring up the name Nathan Wade as a special prosecutor?
I don't think so. I don't recall one. I mean, Nathan is a good organizer. Nathan can organize stuff. I've watched him over the years. So I wasn't surprised that he was acting as a special prosecutor.
And Mr. DeSantis, for the record, who was that? Jeff DeSantis?
Jeff DeSantis.
Do you know who he is?
Oh, yes.
Could you tell us who he is for the record?
Jeff works in the DA's office. I knew him when he worked for Thurber Baker.
You know what his role in the DA's office is?
I have no earthly idea.
Is he in media? Does that sound familiar?
He has done media in the past. Jeff has generally been, I like Jeff, and I'm very close to him, but he's generally been on the other side of my campaigns.
All right, so we're talking, the best of your recollection, conference, we don't have the date, I'm asking if you could possibly get it, but the conference you have, Mr. Wade could have been there.
Yes, I'm almost sure he was there.
And Ms. Willis, obviously, and Mr. DeSantis was there.
I think Mr. DeSantis was too.
And as far as whether there was anyone else there, you don't have a present recollection?
No.
Okay,
Next time I'll take a picture so I'll have an exact.
Next time, hopefully, you won't have to be here.
Well, hopefully not.
Thank you, sir.
All right, Mr. Stockton.
No questions, Judge.
Thank you.
Mr. Durham.
No questions, Your Honor.
Mr. McDougall.
No questions from the governor, Your Honor.
Mr. Rice.
No questions, Judge.
Mr. Gillen.
I've been waiting for this for years.
I couldn't give up the chance getting up here, Governor. Good to see you again.
Good to see you, Craig.
We've done some work in the past together, haven't we?
I consider you to be one of my best friends and a crackerjack lawyer.
Well, I will say to you on the record that I can understand why they came to see you, because you're the finest lawyer that I've ever worked with.
Thank you. I need to put you in the next day.
Yeah, there we go. We'll get that. But one or two more questions.
Okay.
You and I working together when it's appropriate. We've had no qualms about filing motions to disqualify the DA, have we?
No.
Matter of fact, you and I successfully disqualified the DA out in Cobb County in the Brown case, didn't we?
We did.
So whatever needs to be done should be done.
You represent your client.
You got that. Thank you so much.
Mr. Coturo, are you still with us by Zoom?
I am, Your Honor.
All right. Any questions?
No, sir.
All right. And Mr. Cromwell for Ms. Latham?
No questions, Your Honor.
All right. Any redirect, Mr. Abadi?
I got it.
Can this witness be excused?
Yes, Your Honor.
Your Honor, is there a way that we could potentially ask through you for that date if you can get it?
The question is, you want the exact date that the meeting occurred?
Yes, if we can get that, please.
And I'm wondering if we can, if it's really material, the exact date rather than just its proximity to the November 1st hiring. Is that fair? If he knows whether it was far earlier in the year versus maybe closer, would that obviate the need for the exact date?
If you can't get the exact date, of course, we'll take the best we can get.
Okay, let's start there.
All right. Let me
think, well, he may take care of it for us just if we hold in place here.
I'm not sure of this.
Well, let me try this first, Governor Barnes, before you do a deep dive in the email there. Do you recall what time of year it was when this meeting occurred?
I'm afraid not.
Okay.
I mean, you know how this is. The cases and the days moved together. I had a fellow a few years ago that said I represented him in 1978, and I told him I'd take his word for it.
Now, I got to ask, though, you wouldn't do that if it was a question of him saying he just paid you.
No, I would not. I will tell you, I believe lawyers should be well paid, Mr. Senator.
All right, so sir, is that something
I'll have to look. It didn't come up right.
Okay. All right, we'll ask this witness to step down subject to recall. And that might be something the state can present with stipulation as well. All right, thank you, sir. Do we have an update on Mr. Bradley?
His lawyer. His lawyer should be here. He's probably outside. The last estimation I heard was about 11:30.
Okay. If that's still the case, then Ms. Cross, did you have another witness available?
But having brought over, it's Mr. John Floyd, not the special prosecutor John Floyd. John Floyd is District Attorney Willis's father.
Okay. And is he heading this way?
Yes.
All right. Mr. Ward, we're just holding in place for taking witnesses out of order. Do you have any updates on Mr. Bradley?
Yes, so he was given this appointment in May last, a few more hours. However, he's going to make himself available for Zoom if that's possible. I think it's the easiest way to provide his testimony.
All right. Ms. Merchant?
I was outside looking for them.
Sure. We found it.
I'm sorry?
So he is asked whether the defendants would accept his testimony by Zoom.
As long as I can show him documents if he needs his memory refreshed, then that's fine.
It is not with us.
It is
With all
not.
due respect.
Yeah, the state would have an objection to this witness not appearing in person.
Understood. All right. Mr. Ward, I think we're going to need continual updates from you and also some kind of expectation of what this afternoon is going to look like. I was never informed of a medical appointment, and I think the notice in this hearing indicated it would last at least 2 days. So right now, I think he's in violation of his subpoena.
Again, Your Honor, I believe that the counsel's giving notice of his doctor's appointment. He missed one yesterday. He took a stand yesterday and he was hoping to be with his testimony yesterday. As he stayed here all day. This appointment started at 9, and it's kind of out of his control with regards to, again, the issues involved with it, as well as
I'm just trying to get more. I mean, we initially been told maybe it was going to be 9:30 and 10. Do we have any better idea to get a realistic expectation of when we think we can have him here?
If it's Your Honor's will, which is tell him to come on in and we have to go back to this point.
Is he, without getting too much into the particulars, has he already been seen by the doctor and he's waiting for results, or is he still waiting to be seen by a doctor? I'm just,
Both. He's been consulting with the doctor and they're waiting for it.
And after he gets those results, he was supposed to have another meeting with them today as well. But potentially that meeting could occur later.
After they're able to figure out the purpose of the actual appointment.
Okay. If you can get any kind of an update on how much time they think that those results are going to take. If it's more than an hour or two, I think we would want to start bringing him here, and he can have that follow-up consultation later. All right. Thank you, sir.
Did Your Honor want to take up the 1.6 motion?
At this point, I think we've got something else that can occupy our time, and I think we need to move forward with that. All right. Of course. Yeah, absolutely.
And I didn't learn about the equipment.
Right. Okay. Understood. Ms. Cross.
Yes, Your Honor. Mr. Abate will...
Mr. John Floyd.
Mr. Floyd, if you could have a seat, sir.
May I approach the witness quickly?
Thank you. I do.
Please state the spell your full name for the court.
My name is John Clifford Floyd III.
Say, good morning, sir.
Good morning.
Can you tell the court, are you currently retired?
Yes, I am.
And prior to being retired, can you tell the court a little bit about, did you work in the legal career? Were you a lawyer?
I was an attorney. I practiced law. I've probably tried 1,000 cases. About 50% of my practice was criminal law. 25% of it was family law, and the rest was whatever walked through the front door could pay for it.
Okay. And
Could we wait 1 second? The governor's come back. He might
I
have
do. My calendar shows it was October 26, 2021.
All right. And would defense counsel accept it as a stipulation, or is there any follow-up questioning needed on that? Mr. Barnes is still considered under oath on this point. All right. I'll just look for a show of hands or for someone to speak now on Zoom, and hearing none. Thank you, sir. You're excused.
And, sir, can you tell the court, are you from Atlanta?
No, I grew up in South Central Los Angeles. I spent most of my legal career. I would say in Washington, D.C. was kind of the circle, but I've tried cases all over the country, and I tried the longest. I was the first lawyer to try an international criminal court. I was with the International Criminal Tribunal for Rwanda. I was in trial there for 4.5 years in Arusha, Tanzania, and Hague in the Netherlands.
Okay. And when you weren't there, it sounds like your kind of center of gravity was Washington, D.C.
Correct, but I've tried cases in West Virginia, Maryland, Florida, California.
All over.
Yes.
And do you, sir, can you tell the court, do you have any children?
I have one daughter, Fani Willis.
Okay. And I want to direct your attention back to 2019, okay?
Yes.
Back in 2019, can you tell the court, did you move here to Atlanta?
I was living in Johannesburg, South Africa, and unfortunately, for some reasons, I could not get an extended visa. When I retired from the practice of law in 2018, I moved to South Africa, and I had to leave South Africa, and I did then come to Atlanta.
Okay, and do you, sir, remember about the time period in 2019 when you moved in with your daughter here in Atlanta?
It would have been the spring or summer of 2019.
And after you moved here, did you get a driver's license to kind of confirm your residency in Atlanta?
Well, my driver's license for the District of Columbia was going to expire on my birthday, which is in October. And yes, I did get a license here in the state of Georgia.
Your Honor, may I approach the witness?
Good.
If you could just take a look at what's been marked as Stacey's.
Okay, Your Honor, would you, if you don't mind, my eyes are very bad, which is one of the reasons I retired, and so I need a magnifying glass, so I'll be constantly playing. Thank you. Yes, I see it was issued on 9/28/2019.
Okay, so before we get there, do you recognize State's Exhibit 2?
Yes, just my driver's license.
And is State's Exhibit 2 a fair and accurate copy of your physical driver's license?
Absolutely.
This time, Your Honor, the State would tender what's been marked as State's Exhibit 2 into evidence.
No.
Seeing no other objections, it's submitted. State's Exhibit 2 is submitted for the record.
Now, and for the record, Your Honor, the State is going to supplement State's Exhibit 2 with a redacted copy of the license. The current copy is not redacted with the address and things of that nature.
Right, and do we need to mark that differently in any way?
I will mark it as State's Exhibit 2A.
Perfect.
Now, you talked about when your driver's license was issued. Can you tell the court when was that driver's license here, your Georgia driver's license issued?
It was on 9/28/2019.
Okay, so September 28, 2019. Now, when you moved into District Attorney Willis's home, who lived there?
Well, my daughter lived there. I lived there, and from time to time, my grandchildren would come.
Okay, and did your grandchildren, were they at school coming and going?
Exactly. I think they were in school in various jurisdictions.
And during the time, how long did you live at or with Miss Willis and at her home here in Fulton County?
She was forced to move after she was elected. I don't know if you want me to go through the whole thing, but that, Your Honor, if Your Honor will indulge me. After she was sworn in on January 1 of 2021, and on or about the 3rd of February, at probably 5:30 a.m. in the morning, there were people outside her house cursing and yelling and calling her the B word and the N word, and just, it was bizarre, okay? It just...
Sorry? Pause, sir. Mr. Abadi. Here's the objection to you.
I would say it's a effect on the listener. He was present while all of these things were occurring. But I can...
No, that's... And he's saying he was personally present to hear these things?
Yes.
Okay, overruled.
Okay, and fortunately, the neighbors called the police and disbanded, disbanded the group, and, it was just, it was just, I hadn't seen anything exactly like it before.
Okay, and after that happened, can you tell the court, did Ms. Willis have to move from her home?
Yes, she was forced to leave.
Okay, and can you tell the court, after she was forced to leave, shortly after she was sworn in, did you remain at her home in Fulton County?
Yes, I stayed there really until 2022, I guess.
And from what you described, did you fear for her safety?
Absolutely. I mean, not only did I do that, I mean, the South Fulton police, they brought somebody, a man with a dog, because there have been so many death threats. And they said they were going to blow up the house. They were going to kill her. They were going to kill me. They were going to kill my grandchildren. I mean, on and on and on. It just, it became, and I was concerned for her safety.
And after those concerns came to your attention, and after what you heard and saw that day, you remained at the house?
Yes.
And can you tell the court, with what you just described, why did you remain living at the district attorney's home here in Fulton County?
Mr. Buck?
I believe it's relevant based on a lot of the questions that were asked yesterday of Ms. Willis as to about the security threat and the fact that it was implied that those threats were not necessarily real, in the sense that Mr. Floyd remained in the home. There were many questions about the fact that he remained and her children could still come and go to the house. I think it's relevant based to the testimony that was elicited from defense counsels yesterday.
Overruled.
Well, these South Fulton police, first they put a car in front of the house that was there permanently, a police car. That was thing one. Thing two, they brought a person with a dog, sometimes more than once a day, twice a day, and they would circle the house to look for bombs. I knew that was a house that my daughter had worked for. It was a brand new house. She's the only one who had ever lived there. It's a 4-bedroom, brand new house, and somebody needed to protect the house, and I stayed there to basically take care of the house, to take care of the yard, to take care of that. Also, somebody sprayed, again, the B word and the N word on the house, and I don't think my daughter even knew that. I cleaned it off and called the police, and South Fulton police, they have, I'm sure, all the records of all the things that happened. And all of the neighbors, I notified all the neighbors to look out and to watch out. And it was so crazy. I mean, it was just so crazy. We'd have people would show up and park car. There was a guy parked for probably 8 hours out in front of the house. It was just, and we'd call the police, and,
Now, at the time that you lived there with Ms. Willis, and I guess even when you remained, so during the time period of 2019 to the end of 2020, are you aware if Ms. Willis was dating someone?
Yeah, she did. She had a boyfriend when I first got there.
Okay. And did you meet her boyfriend?
Yeah, I met him often.
Okay, and did you know him by any specific nickname?
Yeah, Deuce.
Okay, and can you tell the court while you were living there, how often would you see him?
Sometimes every day, sometimes, every other day. He was a disc jockey or something, and he had all this paraphernalia that I'd have to move out. There was a thing with the keyboard, things that play music and so forth. So
now, when you moved in 2019, and then throughout the years in year 2020, 2021, had you ever met someone named Nathan Wade?
I did not meet Nathan Wade until 2023, about a year ago, when a reporter by the name of Issakoff interviewed me. I met him. That was the first time I had met him.
You said that was in 2023?
2023, right.
And I know you said you hadn't met him until 2023, but when you were living at Ms. Willis's house in Fulton County, did you ever meet Mr. Wade in the year 2019?
Absolutely not.
How about in the year 2020?
Absolutely not.
Did you ever see Mr. Wade at Ms. Willis's Fulton County house in the year 2021?
Never.
And is it your testimony that the only time or the first time that you met Mr. Wade was in 2023?
Let me say something. Mr. Wade said that he remembers seeing me, and I do remember some banter. I'm a member of Kappa Alpha Psi fraternity, and there's kind of this thing that goes on between fraternities, and Mr. Wade is a member of Alpha Phi Alpha, and they, I do remember there was some kind of banter when my daughter was sworn in to be district attorney between me and a couple of guys, and he said he remembers me. I don't remember him.
And prior to that experience that you're talking about, as well as, I guess, your official meeting in 2023, had you ever even heard his name?
No, never.
I don't think I have any further questions, Your Honor.
Ms. Merchant.
Yes, thank you, Judge.
How are you?
Fine. How are you, counsel?
Good, thank you. Just got a couple questions. On Monday, we heard you were in California. Do you have a place in California?
People always ask me about where do I live. I guess I live right here, sitting in this seat right now. But yes, the answer is I have a place in Los Angeles.
Okay, you do. All right. So do you share time or split time between Los Angeles and Georgia?
Actually, I'm working on a documentary film, and I'm supposed to be being filmed not for this trial, but I'm supposed to be being filmed right now. It was planned, and we had to stop it because they asked me to come here. But the answer is I'm working on a documentary, and I'll be in California until I finish the documentary if we don't have another actor strike and we don't have another writer strike.
So do you own property in California?
No, I don't. I live with a friend of mine.
Live with a friend of yours. Okay.
Yeah.
And when did you first move? Well, let me qualify with the dates. Did you spend any time in 2019 in California?
No, and the reason I didn't is that when I first came here, the answer is no, I did not. What happened was COVID. Once COVID hit, I was just paralyzed. I couldn't go any place. I couldn't go anything. I mean, I'm a theater buff. I used to go to theater at least once a week. But when COVID hit, I just couldn't. I couldn't go to the dentist, which I need to do. Or, it was just a thing. So I was just stuck. I was just stuck there.
I may be wrong, but I believe COVID hit in 2020. So I was asking about 2019. In 2019, did you spend any time in California?
Before COVID was even here in the United States, remember I lived in South Africa and I've traveled the world. I knew COVID was coming before. I knew COVID was around before. They may have announced it in 20, but in fact, I knew about it and I knew what was happening in 19.
Okay, so let's walk through 2019 then. You said you moved here in September. So
no, I didn't say that. I moved here probably prior to September. In September is when I got the driver's license. I probably moved in the springtime.
I'm sorry, you did. You said spring, summer. I see that in my notes. So spring, summer 2019 is when you moved here. So up until spring, summer 2019, where did you live?
I lived in Johannesburg. Well, I lived in Washington, D.C., 2018. I had planned to retire for the rest of my life in South Africa. I had worked for Nelson Mandela and the Free Mandela and get that. And someone I'd gone to law school, he had located there after Mandela was freed from prison and became president. I was going to live there for the rest of my life, but unfortunately, because of political reasons, I could not stay in South Africa, and I was forced, in a sense, to come back to the United States.
Okay. So let's just focus in on the period from, let's just start with October 2019, okay? We'll call that the relevant period. October 2019 until the end of 2019. Were you in Georgia every single day of that year?
Absolutely.
Okay. So now let's move to 2020, okay? And every single day, before I move on, every single day in 2019, you slept at your daughter's house, correct?
That's correct.
Okay. So let's start in 2020, all right? So 2020, the entire year, did you travel anywhere?
No.
Okay. You didn't travel at all that year?
No.
So,
and I didn't go to the movies, which upset me also.
So that entire year, 2020, you remained here in Georgia?
Right.
Okay. In 2021, did you do any traveling?
No.
So when did you move back, or when did you start this documentary film in Los Angeles?
What I had been doing to occupy time as I was writing my own memoir. As I delved into my family background, I discovered something, and that's what got me to working on the documentary. So I want you to understand what was going on in my life. I pitched I have a movie script called Bad Blood. I have a movie script trying to sell. So I tried to sell that, and I just happened to mention something that happened during the civil rights movement. SNCC, it's called the SNCC 5. The legendary Peter Fitzsimmons was interested, and so with Peter Fitzsimmons and Leah Smith, we're now doing the documentary. So
I don't want to interrupt you, but what I was asking was when you moved to Los Angeles, not what you moved there for.
Well, you keep saying moved. I haven't moved to Los Angeles. I spent more time in California, in Oakland, if you really want to just be, because Peter is basically San Francisco based. So we're working on the documentary.
Okay.
I was in Los Angeles because I was going to the Pan-African Film Festival, and that's why we were there. And the way Hollywood works is, you know, when you make connections, and film festivals are a place to try to sell ideas and meet people and organize things.
You still own property in Washington, D.C., correct?
No, I don't.
You don't own property at 1467 Roxana Road, Northwest?
That's where I used to live.
That's where you used to live. Did you own that property?
Yes.
Okay. And you owned that property when you moved here in 2019?
Yes.
And you owned it in 2020, correct?
Well, you talk about a very complicated issue. I left the property. There was a dispute between me, and I had gotten a reverse mortgage company, and there was a dispute between me and that, and I just I walked away from it.
Okay, you walked away from it with almost $300,000.
Yeah, what is the relevance of that?
Where he lived and registered to vote. That's what they brought in. So that's.
Why is the money he got from the sale relevant at all?
It's the only proof I have of that he owned that address. So I can move on though. Right. Okay. When did you sell that property?
I didn't. The reverse mortgage company took it.
Oh, okay. So in 2019, when you got your driver's license here,
yes.
The next day you registered to vote, correct?
I think it may have been the same day, but maybe it was the next day. I don't remember.
But you didn't own property here in Georgia that day?
No, I was living with my daughter.
Okay. You said that you met Mr. Wade, that you remember you met in 2023, right? That was the first time you
Correct.
remember? Okay. And I wasn't really clear. You said something about meeting him. Was it with Mr. Isikoff, or did Mr. Isikoff tell you?
No, I was being interviewed by Mr. Isikoff.
Okay.
And he walked in, and I met him. That was the first time. He walked into the office. And
where were you being interviewed?
At the district attorney's office.
And Mr. Wade walked into that interview?
Yes.
And so Ms. Willis had not told you about Mr. Wade prior to that?
Absolutely not.
So she didn't tell you anything about their relationship before you met him that day?
No.
But Mr. Wade remembers meeting you in 2020?
He said that at my daughter's swearing in. I do remember that we having some banner about fraternities, but other than that.
Oh, at your daughter swearing in. Okay.
Right.
That's all I have. Just one moment, Judge. Nothing else. Thank you.
Morning, sir.
Good morning. How are you, counsel?
I'm fine. I'll try to ask you some specific questions if we could, okay?
And I'll give specific answers if I can.
Perfect.
Okay.
The driver's license address, I'm not going to publish. That is State's Exhibit number 2. But is the address on that driver's license the home that you're referring to as your daughter's in South Fulton?
Absolutely.
Okay. It was unclear to me, maybe no one else, but it's unclear to me, when did you stop living at what I would call your daughter's home in South Fulton?
Things got so bad and threats got so many, even against me, that the house became basically uninhabitable. I got tired of sleeping in one room one day and no one that. I would say December of 2022, something like that.
December of 2022.
Right. That's about right. Yeah.
Now, let me change and go back for another date. You had indicated, and I didn't hear it, when was your daughter, Miss Willis, when was she sworn in as district attorney?
On January 1, 2021.
Okay. And did you indicate that there was an incident, and I know you've described it, was that incident on February the 3rd, 2021?
That's my best recollection.
Okay. So my question then is, after February 3rd of 2021, how much longer did Miss Willis stay at the house before she moved somewhere else?
Very short period of time, and I cannot be precise, but I would bet all the money I ever made, it wasn't more than a month and a half, if that long.
Okay, so we're talking about, best of your recollection, end of February into the beginning of March, give or take, of 2021, when Miss Willis would have moved to a different location.
Exactly.
Okay. And did Miss Willis return to the house, that is, the house that you were in, at any point in time that you can remember?
From time to time, she and her security might show up for her to pick something up or take something or something, okay. But she always would come with her security.
Okay. My question was poorly worded, I apologize. Did she come back permanently to her house?
Oh, absolutely not. Okay, absolutely not.
So as far as you're aware, that once Miss Willis left the house, her house, South Fulton House, so the record's clear, in either late February or into March of 2021, best of your recollection, she's not returned to that home to live.
No, it became uninhabitable. It just,
that's okay.
I would have to walk around that house looking out of every window. I made a habit of having to walk around the whole house. I got lights so that if somebody would come at night in the back, so that those kinds of reflecting lights, I had those put up.
I don't mean to cut you off.
Okay.
All I was interested in is whether she had ever returned.
No, the answer is no.
Okay. Now, when Miss Willis, when your daughter left the home, time period, end of February, beginning of March, give or take, 2021, do you know where she moved to?
No, and I didn't want to know. I intentionally did not want to know, because I was not, if somebody stuck a gun to my head and I could tell them, I wasn't going to tell them anyway, or I'd have made up something, but I didn't want to know.
Okay, so would it be fair to say that if you didn't want to know, you never visited her at the place that she moved to?
Oh, I never did.
Never did?
Never did.
Okay. Do you know how long she stayed at the first place that she went to after she left her house before she moved to a second place?
What I know, and this is hearsay, counsel, is that my daughter has had to move something like 4 times.
But do you know any potential?
No, I don't know any place. I was taken one time for Christmas Day. I've only seen my daughter, and this is very hard for me to say, but during the period my daughter left, I've only seen my daughter 13 times because I can't, and we've never seen each other more than maybe 3 hours because of, you know, the nightmare threats against her and me.
And I understand that, and from the perspective of being a father myself, I understand what that means. So I'm going to move away from that. I was just trying to get an idea of date-wise, okay? So let me try to get one more date. In 2023, when you were being interviewed by one of the gentlemen that wrote the book at the DA's office, and Mr. Wade came in, can you give us, other than 2023, what the date would be?
I'm sorry, I can't, Counsel.
How about spring, summer, any idea?
I would guess spring or summer, but I can't. Okay. I don't. I'm sorry.
And you've already indicated, at least to your recollection, that was the first time that you'd met Mr. Wade.
Oh, absolutely.
Okay, I'm not arguing with you about that. I want to go to Ms. Willis's boyfriend that you referenced. Okay, you met Ms. Willis's boyfriend, as you've characterized it, when you came here in 2019.
Correct.
And you met him on one occasion, several occasions?
Oh, no, I saw him often.
Oh, so you mean there was no secret that she was dating this man?
Not from me.
Not from you.
And he was a disc jockey of some kind. I think he had a government job during the day. I don't know what it was, but apparently he would do weddings and so forth and so on. He was a disc jockey, play music. So he had all his stuff was always in the way, and I was always having to try to push it aside. And anyway.
But Ms. Willis, your daughter didn't keep him from you, correct?
No.
No, I mean, there was no doubt he...
I mean, we lived in, my daughter and I lived in the same house. I mean, he came and went,
Right. Now, when did you learn that your daughter had a romantic, personal relationship with Mr. Wade?
Well, about 7 weeks ago when as a matter of fact, I just found out when other folks found out. Okay.
That is, your daughter, as I understand it, never told you one time in the year of 2022 that she was dating Mr. Wade, correct?
That's correct.
And until recently, you didn't know from anyone, including your daughter, that she dated Mr. Wade, correct?
That's correct.
That is, whatever the relationship is between father and daughter, she kept that a secret from you, correct?
Correct.
That's all I need to know. Mr. Stockton.
No.
Good morning, Mr.
Good morning.
Correct.
Good morning, Counsel.
When your daughter moved or left the house that she owned, did she say anything to you about having a large savings of cash?
Oh, no, no. See, maybe, excuse me, and Your Honor, I'm not trying to be racist, okay? But it's a black thing, okay? I was trained, and most black folks, they hide cash or they keep cash. And I trained, you always keep some cash because I've been places, and just because of the color of my skin, for example, I took a fellowship at Harvard when my daughter was just, if I might, Your Honor, when I was just, she was just, maybe 3 years old. And I remember going to a restaurant in Cambridge, Massachusetts, and I had a American Express credit card and maybe a Visa or whatever. And I had a lot of what they call traveler's checks. I don't even know if they still have traveler's checks, but traveler's checks. And there was a sign said, with the credit card. For whatever reasons, the man would not take my American Express credit card. So I pulled out my Visa card, and he wouldn't take my Visa card. So then I pulled out my traveler's checks. He said, we don't take checks. Now, these were traveler's checks. This was money. I had a $10 bill. I'll never forget this as long as I live. And he said, the bill for my wife at the time, Fani's mother, Fani, and myself was like $9.95, and I had a $10 bill. That was all that. And I always remember that. But even before that, I've always kept cash, and I've told my daughter, you keep 6 months worth of cash always. For example, I had 3 safes in my house. I put some of my clients' stuff there too, things I didn't want other lawyers to be, because you're always in a firm, and I knew that there were special conditions, so some of my clients' things I would bring home, put them in the safe. But I've always kept safes, and as a matter of fact, I gave my daughter her first cash box and told her, always keep some cash.
So is that a yes?
Yeah. Oh, absolutely.
That's all I got, Judge.
Mr. Durham.
No questions.
Mr. McDougald.
No questions, Your Honor.
Thank you. Mr. Rice.
No questions, Your Honor.
Mr. Gillen.
It's still morning. Good morning, sir.
Good morning, counsel. How are you?
Just fine. Just a few questions following up. When you were talking about when you learned about Mr. Wade and your daughter, correct?
Correct.
Now, did your daughter tell you in around October of 2022 that she had gone on a Caribbean cruise with Mr. Wade to the Bahamas?
The answer is I knew that my daughter had gone, but I did not know who she went with or what the circumstances were. So I knew that she had gone out of town, but I didn't know with whom.
I see. And did she tell you in November of 2022 that she had gone to Aruba and stayed at the Hyatt Regency Resort there in Aruba for 3 days with Mr. Wade? Did she tell you that?
The answer was, again, I knew she went out of town. I didn't even know where she went. I knew she was going out of town. She told me she was going out of town. I think she might have said she was going out of the country or something. She'd be gone. But other than that, that was all.
Okay. And did she tell you in March of 2023 that she was going to Belize for several days with Mr. Wade?
The same answer, that I knew she would tell me she was going out of town, and she may or may not have told me where she was going, but she'd be gone for a couple of days.
Okay. Now, in 2023, you were in many days you would be out in California, correct?
Some days I'd be in California, correct.
Okay. Well, did she tell you in May of 2023 that she was traveling to Napa Valley with Mr. Wade, so maybe y'all could see each other when she visited California with Mr. Wade?
The answer is no.
And so the first time that you ever met Mr. Wade or learned about Mr. Wade, to your recollection, was in 2023?
That's correct.
That's all I have, Your Honor. Thank you.
Mr. Kachuroff. On Zoom.
Yes, Ron, just a couple quick questions. Good morning, sir. I know I can't see you.
I can't see you either, but
we can take a moment.
Good morning, counsel.
We can take a moment. Let's just pause, see if we can change the screens to show Mr. Kachuroff. Sorry.
Your Honor, I'm on a phone, so it's kind of difficult.
Can you turn your screen on, though?
I'm trying to. Does that work?
Just to hold one more moment? All right, there we go. You can proceed, Mr. Kachuroff.
Sir, you seem to know about the issue of cash in this transaction. You said it was a black thing. How did you know that the cash was going to be an issue in this testimony?
Because I was asked for it, and I was prepped by the lawyers, and they asked me about it. What else?
And did you speak with Mr. Wade about your testimony?
No.
Did you speak with your daughter about your testimony?
She may have been present when the lawyers were. I really don't remember.
If Mr. Wade and your daughter were dating, you wouldn't have known that unless your daughter told you.
What do you? Maybe I'm not understanding your question, counsel. So maybe you want to restate. What is it that you're asking me?
Yeah, if it wasn't clear, I can re-ask the question. I'll rephrase it.
Yeah, right. Yeah,
Mr. Wade. If Mr. Wade and your daughter were dating, you wouldn't have known that unless your daughter told you.
I did not know that they were dating. And when you're talking about the cash, I didn't know that. I don't know what you're asking me. What I told my child from the time she was a child is always have some money. Always have some money. If you go on a date so that people don't try to stick you and you want to leave whoever, always keep some cash, okay?
Mr. Floyd, you answered the question that the attorneys prepped you for that, so that's all I wanted to know.
Anything else, Mr. Sheriff?
That's it, Your Honor.
All right, Mr. Cromwell.
No questions, Your Honor.
Mr. Abadi?
Your Honor. Mr. Floyd, now, it wasn't common for your daughter to confide in you about her romantic life at all.
No, and I haven't confided in her about mine before when I had one, okay?
And you wouldn't have known about her boyfriend, the disc jockey.
Hey, Debs.
An objection?
I think that might have just been still off mute.
Okay.
Let's keep going.
Now, you wouldn't have known about her boyfriend, the disc jockey, had you not been living with her, correct?
That's correct.
I'll allow. Overruled.
I have nothing further.
Did he answer the question?
He did. He said that's correct.
All right. By show of hands, any redirect on those points only. Ms. Merchant.
Yes. I just want to know when you were prepped by the lawyers, when this prep session was.
I just got off the plane on, what was it, Tuesday night? I think I was probably drooling at the mouth. I was so tired. So it must have been, I got in Wednesday. It must have been Wednesday.
Okay. And did you talk about any of the testimony from yesterday or watch any news reports or anything like that?
Oh, absolutely. Google, you can't cut the TV on without seeing this. The first thing, and I listen to conservative radio a lot, and, you know, last night for 5 hours, all they talked about was this case.
So you were aware of what the testimony your daughter gave yesterday was?
Yeah, unless you don't cut the radio on, unless you don't cut the television on, unless you don't read the AJC or any other, the New York Times or whatever, which I do every day, yeah, of course.
So is it fair to say nobody instructed you that you were under the rule of sequestration?
Right, and I'm not under subpoena either.
Thank you.
All right, anything else? Seeing and hearing none, thank you, Mr. Floyd.
Thank you very much, Your Honor. It's a pleasure to appear in front of you, Your Honor.
Thank you. All right, Ms. Cross, let me check in. Was the state planning to call additional witnesses?
Not at this time, Your Honor. We're again trying to accommodate if there's a lapse in schedule to be able to this afternoon, but right now that was our last witness.
Okay, so even if Mr. Bradley testifies to some extent, it's still the potential that the state has no further witnesses?
I anticipate at least one more will be available this afternoon, but that would be it.
Okay, so there are potentially more state's witnesses. All right.
Judge, before we move on, I'd move to strike the last witness's testimony by violation of the rule.
All right, so I think the rule is invoked and the instruction was for the parties to tell all witnesses subpoenaed or expected to appear about the rule. I don't think the remedy is necessarily striking. I think it can go also to this credibility as well. So to that extent, unless Ms. Cross, you want something else to be heard on that, point is made. All right. Do we have an update for Mr. Bradley?
Yes, Your Honor. Yeah, he should be here at 12:20, 12:25.
Okay. Then what I think we should do is have these preliminary conversations about privilege, see if we can make any headway, and then take our afternoon break. So to that end, counselors, I don't know if you just want to argue in place there or go to the table, whatever makes you comfortable. But Mr. Chopra, I think maybe it was relayed to you since you weren't in the court earlier this morning. We'd had some initial conversations about the distinction between the privilege and Rule 1.6, and it sounded like you wanted to be heard on that.
Your Honor, it was brought to my attention, and I apologize because I don't have things.
What do you need?
Well, a copy of the case in front of me would be helpful, but it's not necessary. It would just take me a second to keep looking at my phone and responding to the court.
Whatever you need to do.
Your Honor, I believe the case for in anticipation of piercing the rule 1.6 is owns Corning Fiberglass versus American Centennial. Is that correct?
Pardon, it's difficult here in council. Could you?
There's a microphone there at the jury box. You can try to
hear what he's saying. Thank you.
either try to lift that microphone up and speak in the jury box, or make your way over to the podium or table. Sorry.
Is that any better?
All right, and no, that was authority provided by Mr. Sadow over our morning recess, and I think that was indicated to go more towards a potential crime fraud argument. I don't think we've really gotten there yet.
It's not crime fraud per se. It's the same notion. It's fraud on the court, different proposition.
Okay.
But yes, as to attorney-client privilege waiver,
right.
1.6 confidential and secret waiver.
The case that I had cited to this morning, showing the distinction between the two, was tenant health care. So that's where we were on the threshold issue. Did you have something that you wanted to address on that?
I have not been able to review that, Your Honor. I was unfortunately unaware.
All right, Mr. Ward, you're co-counsel with Mr. Bradley?
I'm not here in that capacity.
Remind me why you are here.
I'm here in this case assisting. You're just assisting. Bradley. Counsel.
Okay, so you are co-counsel on this.
Well, this morning when you were asking where he was, I had to make sure everybody knew that he was here. That's what I was doing this morning.
Okay.
Oh, this is, the judge is saying it's tenant.
Right, and the citation for that is 273 Georgia 206.
Judge,
and I'll give you time to review that. In the meantime, what other things did you want me to know? And perhaps at this point we just take our break now, unless you also want to talk about the questionings that were provided by Ms. Merchant, seeing if there's anything we can achieve.
So that I can be clear, it is apparent that at this point we're going to go into whether or not 1.6 provides privilege for Mr. Wade, even though he has specifically stated that he does not waive that privilege. Therefore, it would be incumbent upon the court to issue an order to demand that Mr. Bradley, over and above the privilege afforded in 1.6, is required to testify. Is that correct?
That's right. That's what we covered this morning.
And so I would ask the court, is the court then going to travel under the fraud exception?
We haven't quite gotten there. We haven't decided whether attorney-client privilege applies. I think there are some other things that we would have to do to, I think we got held up yesterday on 1.6. As I understood it, I was waiting to hear from you whether we are now beyond that. And then if we're in the land of attorney-client privilege and only attorney-client privilege, so Rule 505, then I think Mr. Sadow has some arguments on crime fraud, and I think there's also just the general arguments of, does it exist? Were certain statements in furtherance? Does Mr. Bradley have any knowledge independent of those?
Certainly,
right?
And in order to keep the court abreast, yes, we are still traveling under, there should be a privilege afforded to Mr. Wade under 1.6, and we are aware of how they will try to convince the court that that should be overcome. So hopefully I can read this case in less than 5 minutes.
All right, that's fine. Anything, I guess, as he reads that, let's do this. Assuming we do get beyond 1.6, if you can work with me here, anything we want to add to that?
I'm afraid I would have to hear what the arguments were that got us past 1.6,
Okay.
Judge. I'm not here to insinuate to the court that we would do something else. I don't know.
But there was a line of questioning that Ms. Merchant decided to write out and share with the parties. Were there any initial thoughts, comments, reactions to that? Again, just trying to make sure we make the best use of Mr. Bradley's time once he arrives.
Your Honor, I just want to say that that might just reiterate that my client is not waived the attorney-client privilege. The questions that we reviewed this morning, Mr. Bradley is not able to testify about anything relating to Wade's marriage or dating history after December 2018. That's going to be the operative date. Nor does any of the questions does Mr. Bradley cite to any external knowledge or sources. Anything he will say would be derived entirely from privileged communications with our clients, so we just want to renew our objection.
Okay. So certainly the assertion of privilege is confirmed and for the record. And I think, again, this is where we got held up yesterday, is that I know you're asserting that certain answers to these questions would be covered by privilege. I think there's still some boxes we would need to check before we can confirm that. And we'd have to check those boxes with Mr. Bradley before we can get there. Okay. If there's nothing else, then let's break until 1 o'clock. All right. Thank you all.
All right, so you just heard as our shot goes down. Right now, court in recess until the 1 o'clock hour. Again, we will continue to bring you live coverage right here from where you're watching, whether it is on your Roku TV, Apple TV, Amazon Fire TV, or maybe you're joining the conversation on YouTube Live. We will continue to bring you this coverage throughout the day. Right now, court in recess until 1 o'clock. I do want to just preview some of what was said and some of what we can expect to come. Still a few more testimonies and witnesses in this evidence hearing expected as court picks back up after the 1 o'clock hour. Now, the key person in all of this, as we mentioned to you earlier, that caused over an hour long delay in this court hearing, day 2 of the Fulton County District Attorney Fani Willis and Special Prosecutor Nathan Wade's possible disqualification hearing, or the hearing to determine whether the two will be disqualified from pursuing former President Donald Trump and others. Again, that was delayed just 20 minutes into the hearing because, as the judge said, not all parties had arrived or were present. So there was a lot of back and forth about pausing the court proceeding and then waiting for all those parties and picking back up. Ultimately, the judge deciding to move on with the other testimonies and evidence that they were going to hear. But Terrence Bradley, now expected after this recess period to take the stand, to testify, despite not wanting to speak on the relationship between Nathan Wade and Fani Willis. Now he has been compelled by Judge Scott McAfee to take the stand and testify in this evidence hearing. Again, we will continue to keep you updated. Just a reminder for you, AtlantaNewsFirst.com is a fantastic resource for you to explore the timeline of both the Trump investigation and everything that stemmed out from Fani Willis. I'm just taking you through our website here. As you can see, we have key figures, key moments, the highlights, if you were following yesterday, just laid out for you, including live updates, which we will continue to bring to you on AtlantaNewsFirst.com and in the free Atlanta News First app. In the meantime, we will join you back here at 1 o'clock with continuing coverage of day 2 of the disqualification hearing for Fulton County District Attorney Fani Willis and Special Prosecutor Nathan Wade.
I will say that I do remember at some point it was myself, you, BC, and Bert there, but people were coming in and out of the courtroom, so I cannot sit here and accurately say that somebody else wasn't there at the time.
We talked, I mean, and people could have come and gone, but essentially
Correct.
we talked for about half an hour.
No, it wasn't an hour.
And that's the only time we spoke in person about anything related to this matter, correct?
Correct.
And based on that phone conversation, I told you I had been submitting open records requests and I was going to continue to submit open records requests, correct?
Based off what phone conversation?
Based upon our conversation in court.
Oh, okay. Correct. You said that you were doing some open records requests, correct?
And then based on our conversation, I told you I was going to do some additional open records requests.
Which open records request are you talking about?
Just any. I'm just asking if we talked about that I was going to be doing some follow-up in Fulton County.
Okay. Because I recall open records requests being made for other things, and so I don't know which one that you're referring to.
At that time we talked about getting, I guess it's called a county card and getting access cards and things like that for coming in and out of Fulton County for you, Mr. Wade.
Okay.
And all of the access that you all have.
Yes. And you asked me, did I have an access card?
And you are the one that told me that you and Mr. Wade, or that Mr. Wade at least had an access card.
I told you that the three of us had an access card because we had a contract with the DA's office or the county. I told you what those contracts were and that we had an access card that will allow us to pick up the documents, go into a specific office, and leave out.
Right. Okay. And so we talked about that badge access card and asking for that I was going to ask for that, right?
Correct.
And then a couple days later, I sent you a text. And then when I say a couple days, so that was on September 12th when we had that conversation.
Do you mind if I pull out my phone?
Not at all.
Okay.
On September 14th at 6:38 p.m.
And what day was this?
It was September 14th.
September 14th, correct.
And I sent you a screenshot of a Fulton County opening records request I did.
Yes, and I said, wow.
And then, we continued to text.
Wait. And then you sent another text about a badge, and I did not respond. You sent another text about an entrance card. I did not respond. You sent another text about some other badges and with a circle around it, and I did not respond.
Your Honor.
Okay.
I'm sorry, thank you.
All right. Mr. Bradley, if you could just respond to the question asked and only the question asked.
That was
Thank you,
actually, I have an additional
Okay.
Thing I want to raise. Ms. Merchant provided some text messages that she let us know that she was going to refer to. The text messages are inconsistent with Mr. Bradley's exchange as he apparently is reading it off of his phone. So if I could ask Ms. Merchant, is this it is true, accurate, and complete, and perhaps we can see what's on Mr. Bradley's phone. But more importantly, I am going to object. I understand the court's leeway about Ms. Merchant being able to establish contact based on previous statements made. But I'm concerned about going into the content of the statements without putting things in the buckets that I've done.
Sure, and so am I, Ms. Merchant. I'm not seeing so much the relevance of it back and forth. I'm allowing you to establish, the contact that was made and line with the outline you provided me, and I think we're on track with that. Were you planning to tender these text messages?
I was planning on discussing them with him. Now, if yesterday he said we didn't text about this case, so if that was his testimony again today, then yes, I would show them to him to refresh his recollection or to impeach him. But Judge, their first part of their argument is foundation, is what I'm assuming. They're saying all of these. They're not all relevant. I can give you all of my texts, but they're not all relevant. And so they asked for screenshots, and so I took screenshots. If there's a way to submit my entire text history with Mr. Bradley, then that's fine. If they want us to read every single text, that's fine. I just don't want to be in a position where people are saying that I'm not.
Well, I also want to avoid the situation where you as counsel of record are having to lay the foundation and do that sort of thing yourself. So I don't know how much further we can go with this before we get into that. So.
Well, I'm not sure what their objection is. So I asked him about one question, and he read out
Sure.
several.
Why don't we just go with your next question, and we'll see where we go from there.
All right, let's see.
But so
Bradley, when she wait for her to ask a question.
And I understand that, Judge, and I'm not
Well,
trying
apparently
to.
you don't, sir. Wait for her to ask a question, and you'll have a chance.
So I think what the last thing I asked you was about September 14th. So those texts that you're talking about, those refer to the issue that we're here today about them.
Some text did, yes.
Yes, okay. And then you called me again on September 15th, 2023, and you spoke on the phone.
I do not recall that.
Well, I texted you and said I needed to call you back, and then I later called you back.
I'm not sure. I do not recall.
You don't recall that? Okay. And do you recall the following Monday,
Your Honor, I appreciate the question as it is on the form. And if the question is what she's going to read, I object to it even being asked out loud without knowing, number one, the relevance of it. If the witness is going to answer the source of information, and I feel like it is so inflammatory as to say out loud, without knowing where Mr. Bradley falls on that, then I do have an objection to the question.
Okay. All right.
With all due respect, if I'm not just a moment, why is it that we're not allowed to ask a question, and then when the question is asked, there's an objection made either by the state or the lawyers for this particular witness? It appears that what the state would like to do is force us to tell you in advance every question we're going to ask before there's an objection raised. And I don't understand why they get to do that when we are obviously in the same position to say to them, tell us every question you're going to ask first. I realize it's a privilege, but that can be the questions asked, state objects, Chopra objects, in the court rules, but not being able to put it on the record because it's inflammatory or it's somehow prejudicial, I don't think that, I'm just suggesting.
Sure. So, Mr. State, I'd agree with you in the general sense of things, but in this situation, Ms. Merchant offered to provide essentially her list of questions in advance, giving us a preview of what she's going to say, and that puts us in kind of a different posture in that respect, where we can actually have some sense of what's going to come out. But Ms. Merchant, I think knowing what your next question may be, since usually we don't have that opportunity, does it presuppose some knowledge on his part that we have yet to establish is inside or outside of privilege?
Well, the first thing, Judge, is I gave these questions so that you wouldn't be in a situation
Sure.
where we were objecting and having 4 different lawyers talk about privilege, confidentiality, every single question. So I was hoping that we would ferret that out ahead of time. So this is the first that I've heard that objection to question 18. I think the state copies of it as well, trying to be completely transparent. I also, I have to establish that his information, there have been statements in this court that I lied, multiple statements yesterday. I can't even tell you how many times that was said under oath yesterday, and that I did not get this information. And so I have a right to
Which I've already said we can do and we can go over, but and we've already started doing that. But the next question, as you plan to ask it, may presuppose, again, some information that he has that we need to determine whether it's inside or outside of privilege. Is that right?
No. Well, I don't believe so, no. I mean, if we're going to talk about the privilege, I wanted to talk about it beforehand, which is why I gave all of these. I didn't know the state had objections on these questions to privilege. If we're going to talk about the privilege, I'm happy to ask him the substance of the question, but that is what I'm getting objections for. So I'm trying very carefully to craft something to avoid that. But I'm happy to just ask outright the question.
Right. I don't see a way around that, Ms. Cross.
I understand, Your Honor. I'm going to do what I'm trying to do. The problem in the context that Ms. Merchant is posing the question is, this was our communication, this is what I asked you, this is what you told me, and here are these texts that are supporting it. I understand the court's ruling that based on how things have gone, if Ms. Merchant feels like she needs to establish there was contact and communication, then I don't have an objection to that. However, number one, the text message that exchange that Ms. Merchant gave me is apparently not complete. And so I don't know, without making her a witness, how the state can, we're entitled to, if you can refer to text messages, we're entitled to an accurate representation of what those are. Mr. Bradley's looking at his phone, and that's what he's got. He is under no obligation. Ms. Merchant provided this to us, and I appreciate it. But I can't tell as I'm sitting here to object to an incomplete or an inaccurate recitation if what she gave me isn't complete.
So a couple things come to mind. One would be that anything the witness is referring to on the stand, counsel at any point has the right to inspect. And so if that's what you're asking for, Ms. Cross, then I think you have a right to do that if you decided to do that. The other is as I've seen it so far, I don't think these texts are coming in as substantive evidence, but more for impeachment, in which case extrinsic evidence would never be coming in to prove them up, and he either takes her answer or he doesn't. And that's how it works. So I don't see the foundation issue or the completeness issue really playing into it as it comes to impeachment.
And Judge, they asked me for the relevant screenshots. I took them. He doesn't have an iPhone. I can't download the entire text message history. I told him they could go through my phone. Like, I'm hiding something.
All right, Ms. Merchant. I think at this point, again, I don't see anything extravagant about the next question on his face. I think we need to deal with it as it goes, so you can proceed.
I asked you where I could get an affidavit from about the affair, and you responded no, because you didn't think anybody would freely burn that bridge. Isn't that true?
If you say so. I mean, I don't.
You have your text if you need to refresh your memory. September 18th at 3:11 p.m. in YouTube.
Can you repeat the question?
The question is, did I text you asking you if you knew who I could get an affidavit from about the affair? And you responded no. No one would freely burn that bridge.
Yes, I do see that.
Then I asked you if Chris Campbell knew, correct?
No, you asked me if under oath he would testify.
Your Honor, again, I'm going to object to the source of the witness's information about that, whether that's first-hand information or not. And Mr. Campbell, of course, has a privilege too.
Well, since Mr. Campbell hadn't even been brought in to this proceeding at all, I'm also wondering about just the relevance of asking questions about Mr. Campbell.
It's been objected that I'm not asking about all the texts, and I'm selectively asking, so I'm trying to go through all of them. I would much rather just ask the very relevant ones.
Well, I have an objection to her asking. I can't tell if the statements or the testimony provided is consistent or inconsistent without a complete set of this text exchange. And it's not clear in the text exchange what the source of Mr. Bradley's information that he's providing is. And so that is, I'm struggling,
Sure.
And I know everybody else
And again, I think you're focusing more on the merits than the impeachment value, right? If the sole purpose this is coming in is under those grounds, then you being able to match them up word for word, I don't see that as being a necessary prerequisite. But as it relates to Mr. Campbell, he's not a witness yet. He hasn't come in. I don't think he's come up really at all other than passing and maybe the firm. So why don't we skip ahead to the next questions, and you could always come back to that if somehow he has made an issue in this case.
That's great, Judge. I needed some clarity because the state is objecting that it's not full and accurate. I'm keeping things out, and then they're objecting that I'm putting too much in. So I'm just trying to avoid every question having an objection, Judge. So on January 5th, 2024, we had a text exchange where we talked about that I had discovered that Nathan took Fani on a cruise and a trip and paid for it with the business card. You told me you were on a plane home from Dubai, but you would call me as soon as you got home. Do you remember that?
So what I have is a text message from you saying, "Oh my God, Nathan took Funny on a trip to Napa and paid for it with his firm."
Okay, continue reading.
And you said, "Is he that dumb?" And I said, "Wow, I'm on a plane from Dubai, land at 3. We'll call you as soon as I land."
So that is accurate. That's what you told me.
That I will call you as soon as I land, and wow?
Yes.
Yes, that is accurate.
And then you told me that you weren't surprised because they took many trips to Florida, Texas, and California.
Okay, so I don't have that, and I can show my phone, but I don't have that in my phone.
So the question is just, do you recall?
I do not recall.
Communicating that to me?
I do not recall.
All right.
Do you recall telling me that it was when she had to move her daughter, a trip to California?
I do not recall that.
And Judge, may I approach the witness?
You may.
Thank you. It's in the packet I gave you. Oh, I see it. See if that refreshes your memory.
Yes, I see this.
Okay. Does that look like, does it refresh your memory?
It does not. I mean, I see what's on the text chain, but you said this happened January 5th?
I can tell you exactly when it happened. Because there's no date and time stamp on that. Let's see. It was, let's see, it was I believe it was January 5th, but just give me one
Judge,
second.
I just want to, on behalf of Mr. Wade, just to review the objection again. We still don't
To which question?
To the current question, we still don't know the source of this information, whether it was privileged or how he obtained it.
I'm wondering now if there's a timeliness issue on your objection, since he already, well, he said he doesn't recall.
Right.
So there's.
He just gave the date. He didn't.
Sure. Well, his question or his answer was he doesn't recall, and his memory has not been refreshed. So I think it's time for the next question.
May I approach the witness, Judge?
Okay.
Can I see what you're approaching the witness with? So is this the complete text chain?
Yeah, it's the complete text chain. While they're looking at that, can I just ask you, did you delete any text messages?
I have several messages in the phone with you. I've never deleted. I mean, there are messages about family and my health and things like that. You asked me to be on some panel.
Yes.
And so I think it's complete, but.
Well, no, my question was, did you delete any
No,
text?
I haven't deleted anything. No,
Okay.
I have not.
And I offered them to look through my phone earlier if they are welcome to.
You never provided it to us.
I said you
The physical phone, you never provided it to us.
It's the only phone I have, Judge.
Yeah. I understand, and I don't want to keep popping up, but my concern, of course, is that these exchanges are just two lawyers gossiping about information. And I'm concerned about it coming into the record in this way. I understand impeachment is a thing, but if we could do it in a way that the substance of this gossip is not, that part is not impeaching, the contact is impeaching. So
I don't think we've gotten to that point quite yet, Ms. Cross, but you can renew your objection if you think we have. So right now, the sole thing that Ms. Merchant is trying to do is hand him an object to refresh his recollection again. So we'll see where we get with that.
And I don't have any way to download it. He doesn't have mine.
Mr. Zeta.
The court is a trier of fact. you're going to be able to determine whether something that has come in, if you choose to, is hearsay, whether it's admissible, whether it's relevant, whether it's impeachment. You're in a position that if it all comes in, but you reserve the right, or all parties reserve the right to object, we can deal with it. But this is not a jury. We don't have to worry about the jury hearing something that it will no longer consider. All we're doing now, with all due respect, and I understand there's a process, the state doesn't want something to be heard.
I object to that.
They've repeatedly attempted to stop questioning. Your Honor can hear it all and then decide what is and is not relevant or admissible. We don't have to go through every single one of these. The only time you have to go through this is if it is in fact a communication, and it's a privileged communication, and an argument has to be made at that point as to whether or not it should be elicited or it is subject to being stated in open court. Otherwise, all of this could come to the court, and the court can then decide how it wants to treat it. That's
all right. I appreciate that, Mr. Sadown. I think it's certainly accurate that we could have an approach where if it's a close toss-up on an evidentiary question, we can have it all come in and sort it out later on the record. I don't think we've quite reached the point where I need to do that. I think we still have time to get into these, and it'd be my preference to keep the record as clean as possible and without questionable evidentiary issues. But we may get to that point. So the question from Ms. Merchant was to approach the witness and with an object to see if that would refresh his recollection to the last question asked.
Yes. Now, I'm sorry, the state scrolled through it, so not right there again. No, I mean like it was on the screen. Now I can't find it. So I'm going to move on to the next question that I actually can find, and then I'll find that and come back to it. I sent you a statement and said, upon information and belief, Willis and Wade met while both were serving as a magistrate judge and began a romantic relationship at that time, and you corrected me and say, no, it was in municipal court. Is that correct?
I think that's pretty accurate.
And is that based on your personal knowledge?
But what question, was it municipal court or when they first met, or?
My question was, is this accurate? Upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And you wrote, no, that it was municipal court.
Okay.
So I answered.
Bradley, just a second. Mr. Chopra has risen.
All right. Your Honor, I do have one purpose here, and that purpose has now been met. Any information that Mr. Bradley may possess would in fact have come from his representation of Mr. Wade. This falls within the purview of his divorce proceedings, which, as we testified earlier, commenced in December of 2018. There's no pierce or shield associated with it, and so we would say that under Rule 1.6 we should not be compelled to give any further information.
Okay, and as we discussed about before the break, Mr. Chopra, if I ruled earlier this morning that this witness is going to be directed to respond to any question to the extent it falls outside of attorney-client privilege and only attorney-client privilege, meaning 1.6 is not going to bar his testimony in this case. What would be your response then?
Then Mr. Bradley would have to consistently assess on his own, unless I'm jumping up and objecting for him, whether or not this came within his knowledge based on his representation. Now, I can say based on the phrasing of the question from Ms. Merchant, it would in fact come within information obtained from his partner client at the time associated with the activity in question.
All right, Mr. Evans, same issue.
I just want to reiterate that it's a compound question anyways. so it needs to be separated out. But it's still based, we just renew the objection that it's still based on gossip, either gossip or privileged communication. He doesn't ever cite the source of where any of this information is coming from, so I just wanted to make that objection.
Okay.
Judge, as far as privilege, any privilege objection, it's been waived, particularly for this issue because Mr. Wade
You did testify on this subject.
testified on this subject.
Well, he didn't testify as a communication with his attorney about any subject. He testified factually about what trips he took and events that occurred. He didn't testify, to my recollection, about any communication with his attorney.
But he testified about the subject matter of the question that was just asked, which was when apparently they first met.
Furthermore, Judge, my client wasn't privy to that testimony. We have been under subpoena and therefore under the rules, so we do not know what was or was not testified to. Everything he says would be a violation of that privilege unless we know specifically what all has been waived.
Sure, unless I make a finding that there was an express waiver on behalf of the client.
Yes.
Per question.
Right? Okay. Sure, got it.
So
all
for
right.
this question particularly, Judge, we would ask that you find that there has been a waiver of the attorney-client privilege because Mr. Wade testified to something directly different than what this witness, we believe, has knowledge of.
Ms. Cross?
Yeah, so Mr. Wade testified as to when they met. That is not the entire substance of the text message that
And began a romantic relationship.
Yes. He did not testify that they were serving as magistrate judges when they began a romantic relationship.
All right.
He testified differently.
Okay, Ms. Merchant, I think you're going to need to establish whether this witness ever gained that knowledge independently or during the course of a attorney-client relationship.
Did you have any, thinking back to the source of your knowledge, and let me just, before I do that, let me remind you of what is covered by attorney-client privilege. It's communications that relate to matters in which legal advice is sought, and communications that have been maintained in confidence, and no exceptions to the privilege. So it's communications that are in furtherance of legal advice. Your knowledge that their affair began, that their romantic relationship, began while they were both serving as municipal court judges. Is that from your personal information, your personal knowledge, or is that from?
I'm going to overrule that objection, Mr. Chopra. He can answer that question.
State that question again.
Your knowledge?
Is any knowledge, if any
knowledge, of Nathan Wade and Fani Willis's relationship, romantic relationship beginning while they were both serving as judges, is any knowledge that you have from your own personal knowledge or something that was told to you in furtherance of legal advice?
I have no personal knowledge of when it actually happened. I was not there. I do not have any personal knowledge, so I would choose not to answer that question under 1.6.
Mr. Bradley, we made a distinction earlier.
Yes, sir.
That it's a bit narrower than that.
Okay.
1.6 is
I have no personal knowledge, Judge. I apologize.
Okay.
If you were,
that's not a problem. The issue is attorney-client privilege, and so whether what you learned, if anything, was during communications with a client.
It was.
Okay, Ms. Merchant.
and was it that any knowledge that you had as to the truth of that statement, was it told to you in furtherance of legal advice?
I'm going to object to it. If that statement is true.
That's how
And the witness has already testified he has no personal knowledge about that. So whether he represented at one point it was true or not true, he has no personal knowledge about that, so could not testify.
Prior inconsistent statement, Judge. Do it all the time. That is what the state does regularly. They bring in, if it's a prior inconsistent statement of another witness, Judge. Mr. Wade
Which
testified.
other witness?
I'm sorry.
Okay, Mr. Wade testified.
That their relationship did not start.
But you can't impeach him with a prior inconsistent statement that's privileged. And so we haven't gotten over the privilege hurdle.
The privilege hurdle we've gotten over with fraud on this instance.
Well, that's the first time you use that word. So if you want to make the argument of why that applies, you can do that now.
Yes, Judge. The crime fraud exception, it applies because of the crime fraud exception.
Which crime and or fraud was committed here?
So there's a couple different things, and I want to just address them both because he's raised 1.6 and also raised attorney-client privilege. For the crime fraud exception says the privilege doesn't apply if it's if the existence of it essentially if he has to keep something secret to allow a fraud upon the court to continue. So we've got that. We've also got
no, it has to. The legal communications have to have done in furtherance of a crime or fraud. How has that been established? And what crime or fraud are we talking about?
We're talking about perjury, lying to the court.
In the affidavit filed last month.
Yes.
And so what have you done to link the communications that he made maybe, I don't know, years ago to the affidavit filed last month?
The communications he made years ago, it's proof of the affidavit being incorrect, being false. He's given a prior inconsistent statement.
But the legal communication has to be in furtherance of a crime or fraud.
Right, but he also can't protect. So, and I think it's more under.
But if he had no idea, an affidavit wasn't even going to need to be filed until a month ago.
Right.
And these communications and everything happened well before that. How is anything that they communicated in furtherance of that affidavit that they didn't even know would have to be filed one day?
It's been waived. That part's been waived because he filed the affidavit. So you can't file something that's false and then your lawyer know that it's false and then say, oh, well, privilege, my lawyer can't correct that. When he waives the privilege, and he waived the privilege, he testified about this yesterday.
Okay, Ms. Cross.
I don't think that's even close to an accurate representation of what the law in this area is. And beyond the real kind of throwing out fraud and this and crimes, which what you have, Your Honor, is a conflict in the evidence at this point. I know which way the weight of the evidence appears to me that that's going to be for the court to judge. But a conflict in the evidence, that is not a crime. That is not a fraud. That is not perjury. That's a conflict in the evidence for the court to decide.
So I agree with you there that you would have to first establish a crime or fraud occurred by a preponderance. Got it. And anything else?
Just that she can't, under the guise of impeachment of this witness, number one, establish that. Number two, the witness has already said he doesn't have any personal knowledge of that. And there is the kind of specificity that is required to lay the predicate for a crime fraud exception to the attorney-client privilege is nowhere close to being met here.
Okay. Anyone else want to be heard? Mr. Sadow.
Yes, Your Honor. This is what I said to the court earlier. This is not crime fraud. The scenario in the case I said, you want me to cite it for the record?
Go for it.
Okay. It's Owens Corning Fiberglass Corporation versus American Centennial Insurance Company et al. And it is 660 Northeast 2nd, 812, out of the state of Ohio, Lucas County, Court of Common Pleas of Ohio. And it references, let me make sure I get the right page here. I think it's page 256. The point in the case, or the holding in the case, if the party or witness chooses to testify falsely, and our position is that Mr. Wade testified falsely when he claimed the relationship would not begin until 2022, that if there are attorney-client communications in which the same individual witness has told his attorney something contrary to that, inconsistent with that, here that the relationship, the personal romantic relationship between Mr. Wade and Ms. Willis began prior to November 1st of 2021, which would be the day that he was hired, that if that communication took place, that is the attorney communication, that the fraud upon the court is Mr. Wade lying under oath about the starting date, and the attorney-client privilege under those circumstances where that material fact is pierced and the attorney may be forced to testify to the contrary or inconsistent statement so that the fraud on the court no longer holds. In our situation, that is precisely what we are trying to do. If this witness's testimony, again, and the court may have to hear some of this ex parte in camera to determine, but if this witness is able to testify that Mr. Wade told him under whatever the circumstances may be, that the relationship with Fani Willis began before November 1st of 2021, then we know from what the witnesses testified to Mr. Wade that he lied under oath to the court, and that's a fraud upon the court, and the attorney-client communication to that specific matter is pierced and needs to go into the record. Now, how best to do that? The only way to do that, if it's not in writing, and apparently it's not, is for the court to hear in camera, ex parte, what the communications were that are sought to be kept privileged. If the court deems that it is not inconsistent or contrary to what's testified, then you wouldn't pierce the privilege. If, on the other hand, this witness honestly, that is, now we're talking about Mr. Bradley, actually testifies to what he has told in text messages to Ms. Merchant on behalf of Mr. Roman, that he absolutely knows that the relationship started before November 1st of 2021, then he's testifying that his client took the stand and lied under oath and therefore did a fraud upon the court. So my request is, in this regard, the court's going to have to hear from counsel, and that is counsel from Mr. Bradley, and from Mr. Bradley to determine whether or not he actually said what he said to Ms. Merchant, and whether or not it was based on communications, whenever it took place, with Mr. Wood.
All right, Mr. Sadow, I understand. Thank you for clarifying your argument there. So I understand this fraud upon the cart theory, and what I'd been going back and forth with Ms. Merchant on earlier was that, as I understood, crime fraud applied in Georgia was that the communications had to have been in furtherance of a crime. And to me, that presupposes the existence of a crime at the time, or the forming of one at the time of the communications. The theory you're putting forward is one where we go back in time and can reopen that box because it's now become relevant for something completely, potentially unconnected to the communications whatsoever. Is that fair?
That falsity has occurred now by the very person who is attempting to use the communications as a shield to protect his lives.
Okay.
And when I say crime fraud, it's a fraud waiver. That's what Millich calls it. Is essentially. Millich says that it doesn't offend the privilege to ask an attorney to testify to matters already freely discussed by the attorney and a client at another hearing or proceeding. Allowing a client to selectively waive and reassert the privilege as tactics dictates. Suggests that the client is using the privilege as a sword and not merely a shield.
Sure. So I think it was quite explicit that Mr. Wade never waived anything regarding to communications between him and Mr. Bradley. He was willing to discuss the subject matter, but he was never willing to get into communications that occurred between him and Mr. Bradley. So as to Mr. Sadow's point of this fraud upon the court theory, my question is going to be, has it ever been applied in Georgia?
And the answer to that is, it's not appears to have been applied in Georgia. I cannot find a case in which it has been applied. The cases that I have, the case that I gave you plus the cases cited in there, are the only thing I've been able to locate. Although I think that the bar rules, if we want to go back to those, and I don't have them in front of me, that a lawyer should not allow his client to commit a fraud upon the court. Okay. And I think that, along with this, gives the court the discretion to do that. And the only way to make the record, even if the court suggests that this is the law that the court should apply, but even if the court disagrees, there's no way for there to be a record about it unless Your Honor does it ex parte in camera to determine the nature of the privilege, which of course Your Honor knows, earlier raised, is how judges can do it with the Fifth Amendment privilege. They can do it with any privilege as long as it's ex parte in camera. So what I'm asking the court to do, because when I get up I'm going to ask you directly, I'm not going to go through this that's going on now, to find out whether or not Mr. Wade has ever told Mr. Bradley, in his capacity as his attorney or otherwise, that the relationship started earlier than what Mr. Wade testified to.
All right, understood. So the big takeaway I'm hearing from that, Mr. Sadow, is that once again we're hearing the words "a matter of first impression" here, and noted. Mr. Gillen.
Yeah, very quickly, Your Honor. Number one, he apparently, now he's claiming a privilege, which he certainly did not assert when he was communicating a text with Ms. Merchant.
Sure, but do we have any indication Mr. Wade waived it and allowed him to communicate by that text?
We know what he did. We know what he did.
So how's that an implied waiver?
And I would assume that as the attorney that he would know whether or not he should protect a communication.
That's a pretty big assumption, right?
Not all communications are protected, number one. Number two, let's not forget how we started on this journey with the state getting up and making very serious allegations against Ms. Birch, asking for sanctions, saying all of her representations were inaccurate. And now they are doing whatever they can to block access to that information, which shows exactly what she said was exactly the truth. What they're trying to do is they're trying to say to the court the 100% accuracy of Mr. Wade's declaration and of his testimony. And by the way, please, Judge, don't let Mr. Bradley tell you what he knows. Because what he knows is that this relationship, based upon what we see from the text and what we've seen in the context, we show that the relationship started before November 2021. So I think we have a waiver issue, and parenthetically on the issue of crime fraud, Your Honor, the issue about crime fraud is whether or not in any context the communication would be not in furtherance of a crime at that time, but it could be for any particular crime committed by the client in the future as well. It doesn't have to be something that's being committed at the time. I will also note that when you look at the attorney-client privilege, the law basically says, look, this is a privilege which blocks evidence from coming in. And so in order to have that, they have the crime fraud exception, which is a very low standard once a prima facie showing has been made, which I believe has been done by Ms. Birch.
All right, let me clarify one thing, Mr. Bradley. When you testify to personal knowledge, does that include anything you may have seen, heard, outside of communications with a client? When you say you lack personal knowledge, does that include anything you may have seen or heard outside of communications with a client? And you can tell me if that question is horribly phrased. Try again.
You try to rephrase it for me, Judge? I'm sorry.
Okay. When you say you lack any personal knowledge,
yes, sir.
Does that also mean that and include anything you may have seen or heard outside of communications?
Outside of communications with my client. Mm-hmm. That's correct.
Okay. And the communications that were made, if any, that relate to the subject that you were asked to, were there any other third parties present that may have resulted in a waiver of privilege?
Including texts.
Am I answering your question or her question? Okay.
Are there any other third parties ever present with you and a client that would have resulted in a waiver of these privileges?
No, Judge. I can't recall anybody being present. I mean, we ran an office. We had people around our office, but no, I can't say that there were other people present.
All right. And did you ever receive any kind of a waiver from your client at any point?
I have not received a waiver.
And anything that you learned regarding the subject matter at all, if anything, was it in the course of legal advice, of receiving or giving legal advice?
That's a broad question, Judge, to answer, because the advice was given, and then you have interaction. I mean, it wasn't, hey, this is for, to say specifically, this was for that, or, I can't sit here and say that. So I don't know how to answer that question, Judge.
Okay. All right. So
I was given a case that may reflect the same proposition I was arguing from its older case. It's Atlanta Coca-Cola Bottling Company versus Goss, G-O-S-S, 50 Georgia Appeals 637, appears to be a 1935 decision, has not had the benefit of jeopardizing it. So I can't say that certainly hasn't been limited or overruled. And it looks like it's in reference to maybe head note number 2, at least the one I'm looking at on the computer. And the language that is in the case, okay, is as to violations of law or commission of fraud, the protection extends only to communications after the act or transaction is finished. It does not cover communications respecting proposed infractions of the law in the commission of the crime or perpetration of the fraud. And then it cites some cases. And then it goes, the privileged communication may be a shield of defense as to crimes already committed, but it cannot be used as a sword or weapon of offense to enable persons to carry out contemplated crimes against society's frauds or perjuries. So our position, as I indicated before, is the witness, Mr. Wade, has committed perjury on the witness stand and called into question the statement.
All right, understood, Mr. State. Mr. McDougall.
Your Honor, this is adjacent Georgia law, perhaps not controlling it. I'll explain that in just a second. That's Rule of Professional Conduct 3.3A2. A lawyer shall not knowingly fail to disclose a material fact to a tribunal when disclosure is necessary to avoid assisting a criminal or fraudulent act by the client. A4, and the reason I would qualify that, since we're talking about candidate report, I need to do that. I believe this rule is regarding the conduct of advocates representing clients in court. It might not govern or control the situation where the lawyer has been put on the stand, but it's adjacent to the point Mr. Sadal made earlier.
All right, fair point. Okay, Ms. Trooper, anything you want to address on that?
Briefly, Judge, and clearly there's a lot of smarts in this room, but this whole thing is a deductive fallacy. It is suggested that the truth of the conclusion of the argument necessarily follows from the truth of the premises given, when in fact the conclusion does not necessarily follow the premises. They're, called him a perjurist. He has officially succeeded in saying the thing itself is true, therefore we must ask these other questions. And Judge, it's a fallacy. It does not exist as such, and the privilege should still apply.
All right. Thank you all. So I think here is what we need to do, as I understand the law. As I find it, the crime fraud exception only applies when by preponderance we found that communications made in the existence of a relationship were in furtherance of a crime, or the client at the time knew or reasonably should have known that a crime, that the attorney was being used to further a crime. I don't think that's been established here. Maybe something happened afterwards, and that's something that can be argued during closings, essentially. So I don't think the crime fraud exception covers this. The objection is preserved for the record. Mr. Bradley has indicated also that anything he learned about this subject occurred during those communications. There's some uncertainty on that point, and so in order to preserve the record, at the conclusion of the hearing, I think I can go in camera with Mr. Chopra and Mr. Bradley, and we can put in a sealed filing exactly what the extent of those communications were, if any were relevant. Or excuse me, not relevant, but just what they were, and those would remain sealed until some time if we're ever directed otherwise. However, at this point, the question, getting back to the question asked by Ms. Merchant, as asked, would be sustained on the issue of privilege, the premise. He may have told you something, but it does not appear that there's any evidence that the client ever waived and allowed that information to be conveyed to you. Next question.
Thank you, Judge. All right, let's see. So We talked about Ms. Willis and Mr. Wade coming to and from your office and security details following them. Do you recall that?
Do I need to look at my phone?
No.
Or can I?
Just asking if you
Oh,
recall.
do I recall? I think I did, yes.
Do you recall security taking Ms. Willis to your office?
I'm going to object to that.
Does he recall
Actually, I
Ms.
take that
Willis
back. No,
taking?
I don't object to that.
But you can answer the question, sir.
I do recall security detail bringing Ms. Willis to my office.
Okay. Do you recall approximately when that was?
I do not.
And was that on more than one occasion?
I remember 2 occasions.
Okay.
Yes.
Can you tell me about those?
I can't remember when they were.
Were they before she became DA?
So I don't know if she had security detail before she became DA. So, I mean, if she was sworn in, or I don't remember the dates, but I do remember. I think she was DA.
Maybe during her transition team period? Was that?
No, it wasn't. Trying to remember. She would have had to have been the DA, I think. And I don't want to go on, I think. But I do remember twice her coming to our office, correct?
And she had a security team both of those times.
There was yes, she has a security team with her.
Okay. And do you believe that it's a different security team than she has now?
I don't know her security team now.
Well, let me ask you-
however,
I'm sorry.
I don't know her security team now. I don't know her security team now.
Do you remember telling me that it changed at some point, her security team?
Yes, I think I recall saying that, yes.
And that the most likely people that could testify or had seen things about them having a romantic relationship early on would be the original security team.
I don't recall saying that, no, but
Do you recall talking to me about other people that might have known about their romantic relationship?
I recall.
Yeah, I mean, objection based on we don't know the source. I mean, this is either based on privileged information or it's hearsay. Neither one is.
It's neither. I asked if you recall.
You need to clarify it. If you're actually going to if you think that this draws on information from outside the relationship that he's already testified to, then you need to lay that foundation. Sustained.
Are you aware of other people that you believe would have known about when their relationship began?
I object to the relevance of that. Again, the witness has testified he has no firsthand information of it. Anything he knows about the topic came from representation. Who he thinks might have been able to say something else is speculation, not relevant to anything, and a backdoor to get in the gossip and innuendo that has been pretty much this entire.
All right. Okay, Ms. Merchant, I think we're getting to the point where, you know, the reason I thought this line of questioning was appropriate was to rebut certain inferences about why we were here in the first place.
Right.
But to go into it at the granular level, I'm not as wild about. So if maybe you can ask more overarching questions, and if you have anything else you think that's relevant, then you can get to those as well.
Isn't it true that I gave you a copy of the motion to disqualify in this case? I emailed it to you, and you read it, reviewed it, and emailed me back that everything in it was accurate, to your knowledge.
You emailed me, and
Objection.
Okay. All right. So there are things contained within that, Ms. Merchant, which he has now said fell within the privilege, and that he did not have the ability to waive.
Okay.
So think that's where we have to leave it there.
And I believe I still have to ask the questions, and then if he wants to assert the privilege.
Well, I think he's pretty much already established the privilege, and the objection has been made, and I think it's a valid one at this point based on the record. So the answer was he did acknowledge that you sent him the motion, and I think we leave it at that.
Let's see. And you had knowledge about an apartment, and I'm not asking what Mr. Wade told you in furtherance of legal advice, but you had knowledge about an apartment in East Point or a condo in East Point that was owned by someone, and Miss Willis was staying there.
Judge, privilege.
I think in the way the question's phrased, she qualified that, so.
I did not have knowledge.
You did not have knowledge.
I did not have personal knowledge at all. No.
So no knowledge outside of what is privileged.
That's correct.
Did you have texts between yourself, Miss Willis, and Mr. Wade?
Do I?
Have you ever?
I have. Maybe once or twice, but.
Did Mr. Wade ever ask to use your credit card to pay for trips?
Objection.
On
privilege. I mean, we're still the same thing.
just asking you to use your credit card, how's that in the nature of furthering a divorce proceeding?
I had a business card, and we would use my business card. The firm would use my business card.
For travel?
Are you asking if I use my business card for travel?
Would Mr. Wade use your business card for travel?
I recall I recall a trip, but I don't know if that trip has anything to do with this case. So I do recall him using my card once.
When was that?
I don't even know when that was, and that's the honest truth. I recall him using my card once, but I cannot remember what that was for. I do remember it was a trip, but I cannot actually state, where it was and who it was with or anything like that.
And he paid you back for that trip in cash?
I can't remember how he paid. I think it was. I mean, I'm not certain if it was cash or a check. We routinely would use my card for filings, for paper, for whatever stuff with the office. And so,
I'm sorry. We're done. Sorry.
And so he would, whether he paid me back in cash or whether he wrote a check, it was paid back to the business card.
But this was the only time he had used it for travel.
I cannot recall. I don't even have that business card anymore. But I do recall at least once for travel, yes.
And that was when you were still law partners with him, though, correct?
That is correct.
Do you recall approximately when that was?
I do not.
You did not go on that travel with him, though, correct?
I did not.
Okay. And so he asked you to use your card for the travel.
Yes, I'm assuming. We would use the card for firm stuff, and so it was a business card.
Your business card, though.
It was my business card, yes.
Right.
The law office of Terrence A. Bradley, correct.
Okay. So it showed up on your accounts.
That is correct.
Okay. Wouldn't show up on his account, is that correct?
That would be accurate, yes.
Do you know if this was before he became special DA in this case, special prosecutor?
I cannot recall.
Did you see he and Ms. Willis together? You said you were in and out of the office, in and out of the DA's office. You saw them together, correct?
In and out of my office or the DA's office?
The DA's office.
Correct.
You saw them together in and out of the DA's office?
Did I see them in and out?
Yes.
Well, if you preface it like that, no. I saw him in and out of the office when I would be there doing my filter work for the taint team.
Okay.
He would come by. I rarely saw Miss Willis and Mr. Wade together in the DA's office.
So you brought up the taint team. Let's talk about that for a minute. Tell me about, you did work as, you had a contract as a taint lawyer, correct?
That is correct.
Okay. And that was in the anti-corruption unit?
Yes, I think so. Yes, correct.
And how did you get that contract?
What do you mean, how did I get it?
How did you get the contract?
It was...
Bid? Did you apply online?
Oh, no. It was proposed.
By who?
We were... it was proposed by... I guess it came from the district attorney. I mean, I didn't speak directly with her.
Okay.
It was with Mr. Wade, and he asked if we would be interested in having a contract with the Fulton County.
Okay. He
and I
asked
said
you
I
and
would.
Mr. Campbell?
I think so. I mean, I can't recall if he asked us both together or not. Rarely. We all handled several, different things for the firm.
Okay.
Criminal, personal injury, things like that, family law. And so rarely were we together there at the same time, like for an abundance of time. So he may have called me and then he may have called Chris. I can't recall how we got the contract, but
Was Mr. Wade, to your knowledge, part of the transition team for Ms. Willis?
to my knowledge, he was part of the transition team.
Did he spend a lot of time at that office during this transition period?
He did.
So from when Ms. Willis took office to when you left the firm, did Mr. Wade spend most of his time at the DA's office?
When you say most of his time, are you saying just working business hours?
Yes,
or
working business hours.
I would say he spent I would probably say he spent majority of time. If you say over 51%, I would say yes, he spent over 51% of his time.
Okay. And that was the entire time from when she took office to when you left the firm?
I can't say that that was the entire time, but yes, it was majority of, it was I can't pinpoint specifically when the time that he would spend. I think if my memory serves correctly, getting to the majority of the time, it would have been whenever he started with this, maybe.
As a special prosecutor?
When you say majority of the time.
Right. Okay, so let's talk about the time before he became special prosecutor. Did he spend a lot of time at the DA's office then?
He spent time. I mean, it depends on what you say is a lot. He spent time at the DA's office, correct.
And so, just so we're clear, you were hired first on January 25th. Both you and Mr. Campbell were law partners, and you were both hired by the DA January 25th, 2021. Is that correct?
Repeat the question, I'm sorry.
You and Mr. Campbell
Yes.
both were hired on a contract basis by DA Willis January 25th, 2021, correct?
Which contract are you talking about?
The first one, the taint contract. Not the first appearance contract, the taint contract.
Well, you said the first one, and the taint contract wasn't the first contract, and so...
Okay, so what was the first contract?
To my knowledge, the first contract was the first appearance.
Okay, So let me just mark these. Let's see what number are we on. 23, 24, 25 for his contract. Judge, when they're done reviewing these contracts. This rally showing you what's been marked. We're going to fix it at 23, 24, and 25. If you could just take a look at those.
Okay, I see.
So on now that you've reviewed those, is it true that on January 25th, 2021, you got your first contract as a taint lawyer?
As a taint lawyer, yes, I see the date on that as a taint lawyer, but I'm also looking at this contract here for first appearance, and there must have been, I don't have it before me, but there must have been a contract before this.
Okay, so you think there's a fourth contract?
I can't say that there is or isn't. What I do know is that we did first appearance during COVID, and it was before 2021. So I don't know, if I had a written contract at that particular time or anything, but I do know, I think that you could look at the recordings because everything was recorded at that time as to when the first appearance contract started and the taint contract started.
So when the three of you were partners, you had at least 2 contracts to do taint work, which is filter work, and then at least 2 contracts to do first appearance work, pretty much throughout that entire 2 years, right?
Well, it renewed. So, it just renewed. So yes, if it was the same contract, but it was a renewal of the contract.
So how did you, and you said you got these contracts through, Ms. Willis gave them to you, but it was through her knowing Mr. Wade, correct?
Yes. I didn't have a meeting with Ms. Willis or anything. It was brought to the attention that a contract was going to be needed or awarded, and if I was interested, because this was off of mine, and I said yes, and so
Mr. Wade brought that to your attention?
He asked if I was interested in doing the contract, correct, and then after that is when Ms. Willis, would come in, or I think we actually came down here or something, and signed the contract.
And so that is how you were paid from Fulton County, these contracts.
From Fulton County government? Yes, ma'am.
And you shared, your partnership, you shared a third of all your profits with Mr. Wade?
At that time, yes.
And so his contracts, he got a contract that same year, 2021, and he shared a third of all his profits with you, correct?
Yes, that should be fairly accurate.
Okay. So during 2021, 2022, you all had 2 filter taint contracts. You had 2 first appearance contracts, and you had Mr. Wade's special counsel contracts, correct?
My firm had what I have here,
Okay.
correct?
But Mr. Campbell and Mr. Wade were part of your firm, correct?
So I don't think at this time we had established WBC.
Okay.
At this time, I think I had mine, Chris had his, Nathan had his, and we operated in the same building. But if you ask me, did we fee share or, without everything that came in, yes, that is correct.
So you weren't actually partners, you just fee shared?
At this time, well, yes, at this time, we were not. We were, at this time, I had Law Officer Terrence Bradley, Chris Campbell, PC, and whatever Nathan's was, if I'm not mistaken.
And all these, the taint contracts and the Nathan's special counsel contracts, all of those were under the anti-corruption unit, correct?
First appearance was not under that. The taint contract, if I recall, was under the. I don't think they called it. What are you calling it?
You can take a look at your contract if you need.
Okay.
And I'm not asking about the first appearance. I'm asking about the taint contracts,
Mm-hmm.
and then Mr. Wade's contract, which has already been admitted in evidence. If you need to look at that. Let me know when you're done reviewing.
Well, I see on the first page where it says taint attorney, and I'm trying to go through and I see where it continues says taint attorney, but it always says Fulton County District Attorney's Office. Your question was specific as to the anti-corruption unit, and I'm looking for the verbiage of anti-corruption unit, so I apologize.
Oh, no, take your time.
And see, on both pages, I mean, it starts out Fulton County District Attorney's Office, and then it just goes to initials FCDA, unless I'm overlooking where it says the anti-corruption unit, then the contract was with the FCDA. I mean, unless you want to show me something.
I'm just asking you, and I didn't know if that would refresh your memory. Those contracts were for the anti-corruption unit, right?
Well, they were for the district attorney. I worked for the DA.
Okay.
I worked for the DA.
Okay. So just in general, the DA.
Correct. I worked for Fulton County District Attorney's Office in as a contract person, as it says here.
And when you did the taint work, you had to report to Sonia Allen?
I did not.
You did not. Who did you report to then?
I can't remember his name. His first name was Brian.
Okay. And let's see. So I know you said you met with Ms. Willis when you signed those contracts, right?
Yes, I know I met at least one time to sign these contracts, or to sign when I signed the contracts, yes.
Did you meet with her any other times?
I did not personally meet with Ms. Willis any other time. When you say meet with, what do you mean meet with?
Talk with her, meet with her.
I mean, I would see Ms. Willis in passing if I'm walking through the office and something like that. But no, I didn't have any meetings with Ms. Willis.
Okay, so the only times you met with her were when you signed those contracts.
Clarify meet with. I mean, not.
Sat down and had a conversation with her.
I signed these contracts, so when I signed these, I met with her. To say that I sat down and spoke with Ms. Willis, are you saying in life, and you saying during this time? What are you asking me?
I mean, if it's voluminous, I can narrow down the times, but I wasn't.
Ms. Merchant, I haven't really heard a point in a while. Can we get along to something, or we're going to have to wrap it up?
So I had one more question about your texts. Have you ever been in any group text with anybody other than, with me, and somebody other than Mr. Chopra and Mr. Merchant?
You got to narrow that down. I'm sure you sent many texts.
I can look at my phone.
So with him, if there had been any other texts, and I think that the state had some thing in rebuttal they mentioned. So I was just trying to clean that up before it got there.
Can you try the question one more time for me?
Yeah. Isn't it true that the only texts that you and I have ever had have been between me, you, and Mr. Chopra, or me, you, and John Merchant, correct?
Can I look at my phone?
Sure.
And what's the relevance of that, Ms. Merchant?
They've said multiple times that there's this third party that we've talked to, and I'm trying to establish there's no third party. And I don't know why it was relevant, but the state's argued it, so.
Well, if Ms. Merchant doesn't know why it's relevant, then maybe it might become relevant later, but right now.
Ms. Merchant, I think you've been able to show what maybe launched this and answer the state's initial claims, and so let's get back to the core of what we were here for this hearing. Do you have anything else relevant to ask this witness?
Yes, just a few more questions. After it became known that you were placed under subpoena, did you get a call from Gabe Banks?
I did.
And was he trying to determine if you were going to be giving information in this case?
I don't know what he was trying to determine. He stated that it was an odd. I had not spoken to Gabe in a while. We are colleagues. We are friends. We are in the same fraternity, Gabe and I. And when he called, it was out of the blue. But he did call, yes, ma'am.
Okay. And you relayed that to me as well, correct?
I did.
And then you also got a call from your best friend who was relaying a message to you from Mr. Wade, correct?
No, I got a call saying that he got a call, not that a message that was supposed to be relayed to me. The call was...
I'm going to check if there's a hearsay, the response will call for hearsay. Thus far it hasn't, but
Sure. So hearsay objection as to the contents of the call, Ms. Merchant.
I believe the contents of the call were to remember your privilege. I took that as a threat. I think Mr. Bradley took it as a threat, and I think he would testify to that.
And
hasn't testified to it. And he also said there wasn't any message relayed by Mr. Wade or any party.
well, no, he didn't say it was by any
Right,
party.
Mr. Wade.
So assuming he did hear something from a party, what's the hearsay exception for that, Ms. Merchant?
I believe that it was a threat, so it's a statement against interest. I'm sorry, it's a if he took it as a threat to influence his testimony, then it's not hearsay, then it would be admissible.
All right, so
I did not take it as a threat.
if you're saying it's to the effect on the listener, perhaps,
yes,
then we'll go from there.
Were you told to remember your privilege?
Your Honor, the witness just testified he didn't take it as a threat.
Understood. I'll overrule the objection and the testimony given the weight it deserves.
Can you repeat the question?
Were you told to remember your privilege?
Your Honor, can we,
I was not.
the witness, there may be a potential witness now in the courtroom because the person that Ms. Merchant is referring to is sitting in the courtroom.
Well, if that witness hasn't been told to testify, then I don't see any sequestration issues.
I don't know who it is. I don't know his name.
Okay, and so were you told anything to that effect, Mr. Bradley?
Repeat the question one more time, but so I was not told, remember my privilege.
Something about privilege, remembering that.
I do recall privilege being mentioned, but it wasn't remember your privilege or, a threat of any sort.
But you immediately called me after.
No, I called someone else after.
You called me quickly thereafter then.
I talked to you that day, yes, ma'am.
Okay. Thank you.
Mr. Sadell.
Your Honor, because this is a defense witness, is it the state's first cross? I think that's how we had been doing it yesterday.
No, actually, we're doing it just this way.
Yeah, I've been.
Okay.
This is the first time he's gone, and then we go through all the defense, and then you'll have your chance.
Some foundation questions to begin with, please. Your testimony as you began representing Mr. Wade as his attorney on what date or what approximate date?
I didn't have an approximate date.
And give me an approximate date when you began acting as Mr. Wade's attorney.
I would say it was, if I'm speculating.
I really don't want you to speculate. I mean, you're the one that was the attorney and Mr. Wade was the client.
Correct.
So give us the ballpark figure of when it was that you began acting as his attorney.
Maybe 2017, 2018, I think, maybe.
And the purpose for which you were retained?
His divorce.
So, according to you, from that time period, your communications with Mr. Wade with regard to the divorce or any matters related to the divorce, it's your position are confidential, are privileged, correct?
Yes. Yes.
Okay, good. Now, did you ever meet with Ms. Willis and Mr. Wade prior to, and everything I'm asking you is prior to November of 2021, okay?
Okay.
Keep that in mind. That's.
Why are you yelling?
I don't think he's yelling, Mr. Bradley. He's just speaking up. All right, Mr. Sadell, let's go.
Okay, thank you. Prior to Mr. Wade getting his contract with Fulton County, which was November 1st of 2021, okay? Please keep that in mind.
November 1st of 2021.
Right. Did you ever socialize with Mr. Wade and Ms. Willis prior to November 1st of 2021?
I've never socialized with Mr. Wade or Ms. Willis in any setting. If you're asking, have I ever met with them, then I would say yes. But when you say socialize, what do you mean socialize?
Have you ever gone out to eat with both of them?
Before 2021, I do not
Or
think.
November 1st of 2021.
Out to eat with both of them before. When was she sworn in? I'm sorry. When was she sworn in? There was a dinner before. When she was sworn in that I attended. Shaquille O'Neal was there, so it was like her inauguration dinner. So I'm thinking that's before 2021, so I would say
Let's
yes.
assume for purposes of my question that
Yes, sir.
that's in early January of 2021.
Oh, that is early January 2021. So yes, I mean, it would be before November. So if it was January, yes, that dinner would have been in, I'm assuming, January.
Okay. And any other time that you socialized, went out to eat, went to anyone's home, you know what socialized is?
Exactly. So no, I did not socialize with Mr. Willis. With Miss Willis and Mr. Wade.
So prior to November 1st of 2021, did Miss Willis come to your offices? Your offices, I mean the offices that you shared with Mr. Wade.
I think she came once or twice to our office, correct?
And the purpose for which she came?
I don't know. We had separate offices. I do recall. I do recall some type of meeting happening at our office, and I don't know what that was about. I wasn't a part of those meetings. There was a meeting. There were other people there. There were other people from the, I want to say DA's office there, maybe.
Okay, let's go back to the basics. Ms. Willis came to your offices, together offices, on a couple different occasions.
I recall Ms. Willis coming to my office at least twice.
And on at least one of those occasions, or you tell us, did Ms. Willis meet privately with Mr. Wade in his office that you observed or heard?
I can't recall.
You can't recall?
No.
Did she ever meet with you in your office? Ms. Willis now.
Privately in my office? No. I've never met privately in any office with her outside of signing this contract.
Did Mr. Wade, prior to November 1st of 2021, ever talk to you about socializing with Ms. Willis?
I can't recall.
You can't recall?
You're asking me if he ever mentioned to me that he socialized
with Ms. Willis, correct?
And I'm saying I cannot recall if he socialized with Ms. Willis, if he ever mentioned to me that he socialized.
Did he ever mention to you that he ate or went out to dinner with Ms. Willis? Again, time period before November 1st of 2021.
Did he, repeat your question?
Mr. Wade ever tell you prior to November 1st of 2021 that he had socialized, gone out to eat, visited Miss Willis in anything other than a professional setting?
I'm sure he did, maybe. I don't recall any specifics of any dinners, any specific places. It's been 3 years ago, the time frame, but I do not recall at this time whether or not he ever mentioned any dinners or socializing.
Did Mr. Wade mention to you that he visited Miss Willis at Miss Willis's then current abode, which would have been a place, not her original house, but a place she was staying in the period of 2021 before November 1 of 2021? And his question is, did Mr. Wade ever tell you that he visited Miss Willis at her house?
I don't think I can answer that.
Yeah, privilege based on communication with my client.
All right. Mr. State, if you want to try and rephrase the question, you can, but otherwise that would be sustained.
On both grounds or just on the privilege ground?
Just Oh, I didn't hear a second ground.
There was a hearsay ground.
Oh, that would be on privilege alone.
Did you talk to Mr. Wade at all about his relationship with Miss Willis prior to November 1st of 2021?
I think he's just laying a record, Mr. Wade. It's okay. And so on those same grounds, Mr. Sadal, on all subsequent grounds, apparently the relationship with Miss Willis in any way is covered by privilege according to this witness.
Well, I think the key words, respectfully, Your Honor, are according to this witness. So I'm trying to drill down to see if there are communications that are not within the privilege.
Sure.
I can.
So then we need to acknowledge the privilege in the form of your question, right?
You're asking me to ask it as in a way of saying, are there any non-privileged?
Essentially.
Okay. Did you ever communicate with Mr. Wade prior to November 1st of 2021 about Miss Willis that was not privileged?
I mean, we discussed this contract, but
This contract doesn't help. You have to give me a exhibit number, please.
you said before November 2021?
Yeah, November 1st of 2021.
Before November, this contract for 1/25/21 is before that. So I mean, we discussed this contract.
Okay. And if I remember correctly, again, just give me that exhibit number so we can reference it.
Exhibit 23.
Okay, hold on 1 second. 1 second. On Exhibit 23, did I understand you to say that it was Mr. Wade that effect brought you and Miss Willis together for the contract?
That would be accurate, yes.
Okay. And what did you understand was a relationship at that point between Miss Willis and Mr. Wade, for Mr. Wade to be able to bring you to Miss Willis for the contract? It's not a hard question.
No, I'm just, state that again.
Mr. Wade is the one that basically says to you, go see Miss Willis about this contract, right?
Mm-hmm.
That's a yes, correct?
Yeah, yes.
So Mr. Wade had to have some knowledge, you would assume.
Yes.
Right? That you going to Miss Willis might bring you the contract.
I never went to Miss Willis. So I stated I never went to Miss Willis.
No.
I was told about that there was a potential contract, and that I was asked by Mr. Wade if I would be interested in doing that contract.
Okay, my question to you is, what was the basis that you understood Mr. Wade being able to potentially offer you that contract on Miss Willis's behalf?
I'm going to object to that. That's a mischaracterization. Mr. Wade offered it to him. I think he said he expressed interest. And also, I don't see the relevance of this at all.
So just in terms of relevance or phrasing, I'll overrule on those grounds. So the question is standing unobjected to. Mr. Bradley?
Can you repeat the question?
You've explained to us how the contract
Yes.
came to you, correct?
Yes.
And my question is, what was your understanding of the relationship of Mr. Wade and Miss Willis for it to have been offered, or whatever word you want to use, for him to have said, expressed to you whether you had an interest in the contract?
Privilege. Okay.
All right. Mr. Evans has invoked privilege on my question, so Mr. Sadal, I think you need to clarify whether...
Was it a privileged conversation that you had with Mr. Wade that let you know about the contract?
Or, it was the relationship was the question you're focused on.
Is the nature... No, I'm trying to do it in such a way, and I understand what the court said. Was the relationship that I asked you about just now between Mr. Wade and Miss Willis that gave rise to the contract? Did you know about that relationship as a result of an attorney-client communication?
No, I knew of that through whatever work they did together as municipal court judges.
And how did you know that? Who told you about the work that they did together as municipal court judges?
Mr. Wade told me that they did work at some conference.
Okay, now this would have been something that Mr. Wade said, according to your time period, at the time that you were representing Mr. Wade, correct?
Say that again? Ask that again?
Mr. Wade would have told you what you just told the court after you had established an attorney-client relationship with Mr. Wade, correct?
Yes, but when he told me of them being at a conference, I mean, I'm not understanding how relate. I'm trying to understand your question.
Well, my question is basically, you had communications with Mr. Wade directly that
Yes.
were not attorney-client privilege, right?
I've had conversations with Mr. Wade that were not attorney-client privileged, yes.
That involved Ms. Willis, correct?
I just stated that they were at a conference. I don't know whether or not that involved her or not.
Well, if he's talking about her, that is, if Mr. Wade is telling you about Ms. Willis and Mr. Wade having met at a conference, right, then he's talking about Ms. Willis, correct?
Yes, but he also told me about other people that he met at the conference.
But he told you about Ms. Willis as well, correct?
I think so, yes.
So there were communications in which Ms. Willis was at least a topic that was not covered by attorney-client privilege, correct?
This particular instance, I was told about a conference. And
when were you told this?
I can't remember the dates of the conference, but it was after. It would have been after the conference.
Okay, I'm trying to get just the time period here. After the conference, I want you to understand from the record, I believe we've shown that the conference was sometime in October of 2019.
Okay.
So could you give us an idea, that being a fact, when you would have had this communication about meeting with Ms. Willis at the conference, that is, Mr. Wade meeting Ms. Willis at the conference?
If that's the conference that they were at, yes, then, I don't know how many municipal court conferences there are. I do know that at the time that I was in the firm, Mr. Wade was, he had some position with the municipal court.
Yeah, right now my only question is time-wise, assuming it's October of 2019, when do you tend to remember? What's your best recollection of when Mr. Wade told you about?
I can't remember because I didn't even remember that it was October 2019 until you said that.
Okay. So you don't have a present recollection?
I do not remember that, no.
Had to be before the contract, though, in January of 2021, correct?
That they met?
No, that you were told about Mr. Wade and Ms. Willis meeting at the conference had to be before.
Oh, yes, right? It would have been before that, yes.
So what other communications did you have with Mr. Wade about Ms. Willis that are not privileged? We know of one, about the meeting at the conference. Are you suggesting that that's the only one you ever had about Ms. Willis that isn't?
I cannot recall any. I cannot recall.
You cannot recall whether there were any other communications that weren't privileged?
No.
Well, I'll be specific, and I understand there's probably going to be objections, but I want the record to reflect. Did you have a conversation with Mr. Wade prior to November 1st of 2021 about Mr. Wade dating Ms. Willis?
Mr. Wade has risen. An objection is sustained for the record. Excuse me, Mr. Evans.
Say that again?
You don't have to answer the question, Mr. Bradley. Next question, Mr. Sadon.
Well, I understand it's been objected to and the court has sustained the objection. Can you tell us the circumstances in which, that is, under which Mr. Wade may have told you about dating? What I want to do is try to figure out if we can, you tell me if you want me, if I can do this. I'd like to know how the communications themselves took place, where they took place, how they took place, under what circumstance, whether he was at the time providing advice or seeking advice. So those are the basics. If I can ask as to all those, but if the court's going to sustain the objection to those, then I don't want to waste your time.
And that's something I'll cover in camera. So I'll note the question and the your question for the record, and I'll sustain the privilege objection to that.
Okay. All of this prior to November 1st, 2021. Okay? I'm going to show you 2 text messages. I don't have hard copy.
You want to get into the content?
I'm going to set up a question.
Okay. So I'm going to have objections.
Of course you're going to have objections. I realize that. I want to be able to show it to him, and then I'm going to frame the appropriate question, and then you're going to object. We'll see where we are. May I approach?
You may, sir.
Look at this text message.
Oh, wait, look, can I read it first?
Of course, of course.
Okay.
Okay. Kind of hard to reject that, and that's the question. I know it's coming. Okay. Then you must be a soothsayer. Mr. Bradley, I showed you 2 text messages, correct? Both of those text messages occurred on January the 5th of 2024 at approximately 11:56 a.m. Am I correct?
I think so, yes.
Okay. And the text messages would have been between you and Miss Merchant, correct?
I didn't see it. Yes, it should be.
Okay. And I've shown the same 2 to prosecution, so we're talking about the same 2. In the text message to Miss Merchant, you indicated knowledge of some activity on the part of Mr. Wade, correct? I haven't asked him anything about what the...
Flag for the court that this is a topic and a specific exchange that Ms. Merchant went into, and there were objections that were sustained.
All right, understood.
Yes.
Okay. And it's your testimony that the information that you imparted to Ms. Merchant in these 2 text messages is based entirely on confidential communications between you and Mr. Wade, correct?
Objection. He's referencing specific knowledge. The specific knowledge comes from Mr. Wade, which is we've already established.
Well, no, the question, he didn't get into anything. He just said, are these 2 text messages about privileged communications? We haven't actually, I don't see an issue there.
Yes.
And is it your testimony that the knowledge that you have, which you imparted in these 2 text messages, came from Mr. Wade and Mr. Wade alone?
Yes.
Is that correct?
Yes.
Can you tell us when it was that Mr. Wade imparted this information to you?
Objection.
All right, and I think
that's what you're going to do.
Sure. So I'll sustain that on privilege.
And I'm going to introduce for the record when we finish these 2 text messages, so that Your Honor has those back there, so that you can.
Sure. What would they be marked as?
What do you have?
I have a whole set. Okay. We are up to
I'm going to go ahead and
The contract.
I think you were in place. And the new one will be 26.
once I put a staple in it, I think it'll be Defense Exhibit 26. All right. You have to give me a real pen.
All right, so this is marked and made part of the record as Defense Exhibit 26, but not necessarily for its
This is not admitted
evidentiary
26.
value.
This is for purposes of the court conducting the in-camera review. And put a staple in it to make sure that you see it. No charge?
Nope, it's free.
All right, Ms. Sadal, what else?
All right, so there was also reference, if I remember correctly, to some email correspondence in which Ms. Merchant sent you the motion that she was going to file to disqualify Ms. Willis and Mr. Wade for your review. Is that correct?
That's correct.
Okay. And that was sent to you in an email?
That was correct.
And did you respond to it in an email?
I don't think I responded to her in an email.
Ashley, do we know? You responded by text. I'm sorry, I mischaracterized it. You responded by text?
If I can look at my text, I can, but I'm assuming I did, but...
Okay, I'm going to get it for you because
Okay.
I don't want
All
there
right.
to be any assumption. As soon as we have it. Let me show you. This is the email.
Is that what you're...
I'm going to show you if I might approach. I made reference to an email that Ms. Merchant would have sent you about the motion she was going to file. If you look at this, does this appear to be the email that you received? It's dated January the 6th, 2024 at 10:25 a.m.
Yeah, I see it, the email, yes.
So that's the email that you received, correct? Along with, obviously, the attachment, which is referenced.
Yes.
Okay. And then, did you respond to that email within the text message that I've just placed before you?
Yes, I said looks good.
So the answer is yes.
Oh, yes, I did.
Okay. I'm going to mark this as another exhibit for Your Honor to look at. Since you love my tone, can I have a seat? Okay, I'm going to have these marked as 27. Okay? All right, so is it your position that what is reflected, let me hand it to you. Yeah. What's the court's rule? To ask or not to ask?
We'll take it case by case. I think he's doing all right, so we need to ask for this witness.
Is it your position that your response, which is the second page of Defense Exhibit 27, is based on a confidential or confidential communications that you had with Mr. Wade?
Do you want me to read the response?
No, I'm only asking you whether or not the response, you actually already said what it said. I don't want you to read it again. Is that response, based on confidential communications that you had with Mr. Wade?
Objection, this is privileged and cumulative.
All right, so now we're talking about the email, essentially referencing the motion as a whole. He hasn't been asked to actually confirm or deny any specifics, just to say whether his response is privileged. So I think we're just laying the foundation, just like we did with the text message. So you can answer that question, sir.
Was my response privileged?
No. Was your response to the email of Ms. Merchant, which is on page 1?
Mm-hmm.
Is your response, which is on page 2, is that based on knowledge that you received from Mr. Wade pursuant to confidential communications?
Yes.
Have you discussed with the district attorney's office this case, your purported testimony?
Of my testimony?
Yes.
No.
At all?
No.
No prep, no conversations, no nothing?
No.
Have you given your attorneys, for this matter, did you give them permission to speak with the district attorney's office?
Well, he can assert his own privilege, but that's kind of crazy.
Is there a objection to be heard?
Absolutely, this is privileged.
Okay, sustained. Stay down. Next question.
Do you know whether or not your attorneys shared privileged information with the district attorney's office?
No, I don't know what my attorneys shared or didn't share. I don't know if they even met.
Last question. Have you spoken to Mr. Wade prior to today? No, actually, withdraw that. You're no longer in the same partnership or fee-sharing arrangement with Mr. Wade, correct?
That's correct.
When did you leave that fee-sharing partnership, pseudo-partnership arrangement?
I don't remember the hard date, but maybe sometime like July, August of 2022, I think.
Okay. And what was the reason for the partnership or the fee-sharing arrangements? What caused the separation?
I wanted to leave and go out on my own.
And that's the only reason?
I wanted to leave and go out on my own, yes.
I understand, but that was the only reason. There wasn't any suggestions or allegations of any form of misconduct on either part, either on your part or Mr. Wade's part, correct?
Misconduct of what?
Trying not to get into specifics. Was there any allegations made of suspected misconduct on your part or on Mr. Wade's part? That's a fairly simple question. Did he accuse you of doing anything? Did you accuse him of doing anything? Without getting into what it is, were there any accusations made by you or him against each other?
We had a disagreement, yes.
And had that disagreement have anything to do with Ms. Willis?
Oh, no.
Okay. Did it have anything to do with your conduct?
No.
Did it have anything to do with his conduct?
Hold on, wait. So we had a disagreement. Whether the disagreement was, we disagreed, and so we dissolved. I left the firm.
And was the disagreement having anything to do with alleged or supposed misconduct by either one of you?
I don't. If you define misconduct, I'm telling you we had a disagreement, and we.
Just tell me what the disagreement was then.
The disagreement is mine to know. I mean, I don't see the relevance of the disagreement that I had. It had nothing to do with this Trump case or any other case.
I'm simply getting a question asked, what was the disagreement? It's not privileged, correct?
No, that is privileged.
Oh, it is privileged. Why is that privileged?
Because it's privileged. I can tell the court in camera, but it was privileged.
Ask a few questions further to see if this is actually something that does fall within that privilege. We can take it from there.
Did it have anything to do with you representing Mr. Wade in any capacity? Excuse me.
It would fall in that line, yes.
And But your testimony is that it has nothing to do with your representation of Mr. Wade in connection with Ms. Willis.
As a connection to Ms. Willis, that's correct.
It's connected to the matter for which you were hired by Mr. Wade?
I wasn't hired by Mr. Wade.
I thought you were the attorney representing him in the divorce.
Oh, I apologize. I thought you were saying something else. Oh, yes. So will it apply as to whether I was hired during the divorce? Yes, that's correct.
I'm not sure what this correct means under that. We kind of got lost on it.
Re-ask the question.
It did not relate to your representation.
It did relate to my representation.
In the marriage case.
It does.
And this was whose decision was it? At that point, did you stop representing Mr. Wade?
It wasn't at that point, no.
Was it before that?
No, it was after that.
Okay. And how much longer did you represent Mr. Wade in the divorce action?
I'll have to see the divorce proceeding to see Mr. Wade. I represented Mr. Wade for a time after that. He represented me in a construction case for a time after that. And I will have to look at the filings. I ended up hiring new counsel for my construction case. He ended up, but it wasn't right at that moment. It wasn't in a matter of weeks. It was, I don't know.
You continued representing him in connection with the divorce case after you had the separation that you've made reference to.
And he continued to, yes, and he continued to represent me on a construction case.
But the separation, at least in part, if I heard you correctly, and please tell me if I'm wrong, had something to do with your representation of him in the divorce case.
That is correct.
Okay. Now, Mr. Wade has testified that he did not have a relationship, a personal relationship, a romantic relationship with Ms. Willis until sometime early 2022. Okay? I'm leaving that as the premise for what I'm about to ask you. Do you possess information that counters that, that's inconsistent with that?
Any information Mr. Bradley has would be privileged, Your Honor.
Okay, Mr. Sada, I think we've...
Would such information be privileged in your mind?
I think this has already been asked during Ms. Merchant's direct, so we're covering the same ground. So I'll sustain that.
So I can't get an answer to whether he possesses information which is inconsistent without getting into the information itself.
I think the issue would be that we've already gotten an answer on that, and now we're asking the same question again. Ms. Merchant asked him variation of that, and he already answered.
I think the variation, Your Honor, is referencing whether or not he had what would be personal information, independent source information. Mine is not so limited. Mine is, I'm asking him point blank whether or not he has information from whatever source, including Mr. Wade, that is inconsistent with Mr. Wade's testimony.
Because if it includes Mr. Wade, it is privileged communication. So therefore, the answer is it's privileged. If it excluded Mr. Wade, that would be a different appropriate question.
And I just want to say, the answer is either it came from privileged information or it's hearsay. That's it. He's already testified that he has no personal knowledge.
Unless it's for impeachment at this point. But Mr. Sada, I think that might be too fine a distinction for me to see the need for the question. I think I'm failing to see the difference.
Well, I'm not asking, respectfully, I'm not asking you to see the difference. I'm asking whether I can ask that question and elicit a response which doesn't elicit the actual communications, which is what I'm attempting to do. And if Your Honor says I can't, then I'm finished.
And I think that this was another aspect of what came up before, which is, in my mind, even confirming the existence of the information goes into privileged communications, whether he does or does not possess information. If it came from that relationship, that's part of the privilege as well. So if I make that clear, then
so you're sustaining what the objection would be.
That's right. It'd be sustained on privilege.
And of course, all the questions that we're talking about as far as the foundation about when things are said and what is said, you're going to go into, if I understood correctly, ex parte in camera with the two exhibits we talked about.
That's right. My intent would be to make a record of the knowledge of when it was obtained and the extent of it and the different sources, and that'll be sealed.
And what was actually said?
That's right.
So I guess my question to the court before I sit down is, if hypothetically, you learn through this in-camera ex parte examination that the information that this gentleman has through the attorney-client privilege is in fact inconsistent with what Mr. Wade testified to under oath, then the court is going to then make a determination of whether it can be used here or whether it just remains in the record sealed.
So my intent would be to make the distinction of, from the in-camera hearing, if I still determine that everything is covered by privilege, then anything else that is said cannot go into the factual determinations or credibility determinations that need to be made. And so just the issue of whether the privilege did or did not exist is preserved.
So, again, just to follow through to make sure. So if the court knows that there's been a fraud upon the court through the lie of Mr. Wade, none of us are going to know that that in fact occurred, and the court's going to be in a position of making a determination on the motion, even though the court knows that it doesn't have all the information, truthful information.
I'll take a closer look at the case law he provided to see if that is actually a variation of the crime fraud exception. And I'll apply the crime fraud exception as I see it.
Right. And again, I'm not suggesting it is a variation. It is totally separate from crime fraud. It has nothing to do with using the legal advice of the attorney in order to commit a crime. It's you go ahead and commit fraud or lie to the court when you fully know that someone, your attorney, has information which is counter or inconsistent with what you've testified to.
And to that end, Mr. Sadout, that is something that you can, I mean, I've got this case from Ohio, but if you can find something more on point in Georgia before we schedule
Other
this
than
for
the one
argument.
I gave you,
The Coca-Cola one?
the 1935 case.
The Atlanta Bottling Company? I don't think I went that far. I think it just kind of said the sword and shield language, and it didn't go so far as to say that there's this alternative theory about fraud upon the court, but we can flesh that out in our research.
I appreciate it. Thank you.
Okay. Mr. Stockton.
No questions, Judge.
Mr. Durham.
No question, John.
Mr. McDougald.
No questions, Your Honor.
Mr. Rice.
And a few questions, Your Honor.
Mr. Bradley, you were counsel for Mr. Wade in the divorce case when the interrogatories were initially served on opposing counsel on or about December 27th of 2021, correct?
That's correct.
And you were also counsel for him when the amended interrogatories were served on May 30th of 2023, correct?
That's incorrect.
So you ceased representing him sometime before May 30th of 2023.
That's correct.
At any point during the divorce proceedings, was a pleading filed with the court or a paper served on opposing counsel that purported to have your signature that you were not the one that signed or authorized your signature on it?
Say that again?
Did anyone sign your signature without your authorization on any pleading or any other paperwork served on opposing counsel in the divorce proceeding?
I don't think so. If you have the documents, I can authenticate my signature.
And you have testified that you also practice criminal law and divorce law and perhaps other types of law as well?
That's correct.
And are you aware that OCG 16-6-19 defines adultery as a misdemeanor crime in the state of Georgia?
If you say so, yes, sir. Go ahead.
Okay. Judge, I would ask the court to take judicial notice of that.
For what relevance?
Judge, I think it does go directly to the crime fraud exception. Because if Mr. Wade was providing information to him, to his counsel about his intent to either commit adultery or that he was committing adultery, then that would be a misdemeanor crime. It would implicate the crime fraud exception. And additionally, As we know from yesterday's evidence,
let me pause you there. Isn't adultery, as a statute, just on its face, been found unconstitutional? You can't actually charge anyone with adultery anymore.
It is still current in the
Then it
state.
can't be a crime.
It is still a current charge.
Let's move on to that next argument.
Additionally, Judge, with regard to the interrogatories, we have 3 different sets of interrogatories that were filed that came into evidence yesterday, 21, May of 23, December of 23, that contain false information. We also have the January of 24 that contains the invocation of privilege. So to the extent that this witness has information, both with the original interrogatories that were filed in December of 2021, and frankly with regard to the later ones, even though he wasn't counsel, that would be a false swearing and fraud on the court, which again is a criminal offense, and therefore the crime fraud exception would apply as well.
Okay. Understood.
No further questions, Your Honor.
Okay, Mr. Gillen.
Good afternoon, Ms. Bradley.
Good afternoon.
Been a long day. When did you sign your engagement letter with Mr. Wade to represent him in divorce proceedings?
It would have to be 2017, 2018. Same time frame, 2017, 2018.
So did you sign or have signed an engagement letter to represent him, or are you just speculating?
I can't recall. I mean, we were in a, we shared space. I can't recall if there was a contract or if there is a contract. I think there is a contract, but right now it would be speculation.
Right now, sitting here, you do not know whether or not you had a signed engagement letter with Mr. Wade discussing the parameters of your legal representation of him. Isn't that correct?
That's not correct. I mean, I can't say. I don't have my files or anything with me.
Well, sitting here, you do not have specific recollection or knowledge that you even had an engagement letter to represent him. Isn't that right?
I think I had an engagement letter, but I do not know specifically if I had an engagement letter.
Well, when did you open a file? Did you open, when you represent someone, you open a file in your office? And when did you open the file on Mr. Wade?
I am going to object to the relevance of this line of questioning. There has been no dispute from either the attorney or the client that there was an attorney-client relationship. And so I object to the relevance of the circumstances under which that engagement began, because as Mr. Gillen knows, that's not a factor in determining whether there was a true attorney-client relationship.
Well, Your Honor, it's not just up to Mr. Wade and Mr. Bradley, it's up to the court.
I agree with you there, Mr. Gillen, and so I'll give you a little bit of leeway, but I don't think we could spend too much time on this.
No,
so
okay,
we'll see.
Your Honor. Now, did you or did you not open a file in your law practice with Mr. Wade's name on it, yes or no?
Yes, I had a file with Mr. Wade's name on it.
When did you open that file?
I'm assuming 2017, 2018. I can't tell you the exact date. I've said that 3 or 4 times.
Well, let's approach it from another angle. When is the first invoice that you sent to Mr. Wade for your legal representation?
I didn't send him an invoice in that capacity.
So what we have here is you're not knowing whether you even have an engagement letter. You don't know whether you actually even billed him, correct?
I represented Mr. Wade. I signed the documents that we filed. I filed the documents. There's depositions that I had with the divorce attorney that was representing his wife.
I'm sorry, sir, that's not my question.
Okay.
My question is, did you bill him in your capacity as the lawyer that you're telling him?
I don't recall.
As a matter of fact, did you have any invoices where you billed him on an hourly basis?
I don't recall.
And the answer really is no, isn't it, sir?
I don't recall.
And the reason why it's no, isn't it, is because what happened is that you and Mr. Wade were in a law practice together, and it was a very small work environment, correct?
It was a work environment, yes.
A work environment where you and him would meet and talk literally every day, correct?
Not every day, no.
Well, almost every day.
Not almost every day. I stated earlier that I ran one side of a practice. Mr. Wade did, and we rarely were there at the same time. I stated that earlier today.
So, well, just give us totally how much money you got for representing Mr. Wade in this since 2017 or whenever you told us, up until you dropped off the case in 2023.
I don't recall.
Would the answer be zero?
I do not recall.
Well, you would know whether he got paid or not, wouldn't you, sir?
I do not recall.
So you don't recall whether you as an attorney got a single dollar to represent Mr. Wade, correct?
That's correct.
Because you really did it as a friend, didn't you?
No, I did it as an attorney.
Well, an attorney that wasn't being paid. You were doing it pro bono for a friend, weren't you?
I'm going to have to ask me.
All right. So I'm going to sustain that, Mr. Gillen. I think the law is clear that money doesn't even have to change hands for that relationship. And I'm making a finding based on the evidence that's already been presented, namely the fact that he signed pleadings, attended depositions on Mr. Wade's behalf, that attorney-client relationship did exist at some point.
I was just laying the foundation of the circumstances in terms of the non-billing from the 2017 period and whether there was really an attorney-client privilege there. That's what I was trying to do.
Okay. If the dispute is just when it occurred, you can try to hone in on that. But the questions I've heard so far are more from you were never paid ever. It's from a overall angle.
Well, from 2017 until November of 2021, you didn't receive a dollar from Mr. Wade for your supposed or your representation of him, correct?
I don't have the file in front of me, and I do not recall.
Okay. And the reality of it is, as I mentioned or asked you a few minutes ago, is that it was a small firm, and you were doing him as essentially a favor as a friend and as a law partner, correct?
No, I was representing him as an attorney. Were we in the practice together? Yes. And were we, or are we friends? I mean, we were friends at the time, yes.
Well, you were friends and law partners, correct?
Yes.
And in a small firm, and I know because I'm in a small firm, people will sit around the office and talk about their social life and what they're doing, correct? Correct?
If that happens in your small firm, yes, yes.
Well, that doesn't happen, or did it happen in your small firm?
The witness has been asked very specific questions about conversations about socialization, and we've gone on through it, so I think this is asked and answered.
All right, I'll let him answer this one question. Overruled.
Repeat the question.
Well, did you in your small firm have occasion to where people would sit around and socialize and talk about what was going on in their lives as opposed to merely talking about the law?
Yes.
And you had those conversations with Mr. Wade as a friend on a social basis, didn't you?
I assume
Not yet, but it might.
I assume, yes, we talked about sports. We talked about, sports a whole lot.
You talked about life and about what was going on in your life and what was going on in his life, right? Right?
Sometimes, very rarely, yes, sometimes.
And that is what you do in a small work environment when you know people very well and you do favors for them, correct?
I'm going to object.
Yeah. All right. Sustain. Next question, Mr. Gillen.
Now, in that capacity, didn't you have discussions with Mr. Wade about what was going on in his social life that had nothing to do with him asking you legal advice?
Objection, to be more specific.
I think he's just asked whether he socializes outside of legal advice. So I think you can answer that question.
I did answer the question. I said we talked about sports a lot.
And I'm asking, you know, sports is one thing. The social life, did you talk about each other's social life, like Mr. Wade, and who he was dating?
All right, so that'll be sustained on privilege.
Your Honor, just for the record, I would state that my objection would be that the privilege only protects communications in furtherance of seeking out illegal advice, not talking about something that might be personal or confidential, and that's the distinction that I would draw.
I think that's an accurate legal point. However, I think the witness has already been questioned and testified on this point. So, next question.
Now, you got into the fact that you were the initial attorney on the divorce case, correct?
That is correct.
Now, did you and Mr. Wade, without getting into discussions, did you and Mr. Wade together prepare his responses to the interrogatories which were filed initially in the divorce case?
I'm assuming we...
Objection. He's asking about the interrogatory responses, preparation of the case in the divorce case. I mean, that's all covered under attorney-client law.
Mr. Gill?
Well, I don't think it's attorney-client. Did they meet together, and when the interrogatory answers were filed, did he file them, and did he do that in concert with his client? There's nothing privileged there.
Did they meet and work together, and that work taking the form of them talking back and forth to each other on the right responses?
I'll change it a little bit. Did you review yourself the interrogatory responses given in the divorce case?
I did.
And whatever knowledge that you had when you were involved in the interrogatory responses, you had the knowledge of all that material or information that you had without getting into the content. You had all of that knowledge and information. I'm sorry, let me get my question out before he objects. And when you filed those interrogatories, you had all the knowledge and information that you had obtained from Mr. Wade from 2017 up until the date the interrogatories were filed, didn't you, sir?
Okay, so that's the follow-up question to that is going to be incorporating knowledge learned during communication. So
no, I'm not going to have a follow-up question. I just want to know whether is that the case? When he filed the interrogatory forms, he had all of the information that he had discussed with Mr. Wade from 2017 up until the time. That's it. That's my final question.
Okay. In which case, without doing that extra assuming link that he based his answers on those communications, it has no relevance.
Well, it does in the sense that it shows what knowledge he may have had when he, the attorney, is filing interrogatory responses. That's what it shows.
Okay. I'm still not seeing the relevance of his knowledge as the attorney filing the responses, unless you're linking this back to Mr. Wade.
It gets back, Your Honor, to whether or not, if you're an attorney and you're filing an interrogatory response, which you have reason to believe, or specific information to know that certain responses are not accurate, then you shouldn't be filing them. And now, so that's where I was going with that. So if he's got a body of knowledge over here that's built up from his communications with Mr. Wade that everyone so dearly doesn't want everyone to know about, in spite of the allegations made against Ms. Merchant, now...
Okay. So what if the question was, did you, when you signed your name to the interrogatories, did you commit any knowing fraudulent statement and submitting those to the court at the time? Would there be a problem with that statement or that question?
Well, I mean, I think that is a conclusion that others could draw, like the court. I just want to know that he had all that information at the time that he, as the attorney, filed the interrogatories. That's it.
We would object. This does fall under attorney-client, and he is making presumptions about when information may have or not have been disseminated to Mr. Bradley in his capacity as attorney. He didn't have to know about anything at the time of, in the middle of, at the end of, or he may never have had that information. There's too much presumption associated with it. The whole matter is covered under privilege.
One comment on that, Your Honor. We have spent almost a day talking about trying to block the dissemination of what Mr. Wade said, either as an attorney or in any capacity, about his relationship with Ms. Willis prior to November the 1st, 2021. And questions about discussions in 2019, all objected to, claiming the privilege. And now to say, well, that doesn't mean that he learned something after. I'm talking about, what did you know at the time the interrogatories were filed? And everything that now they're claiming privilege, well, that's fine. The court will address that in chamber and in due course. What did you know?
I'm sorry, Mr. Gillen, I really don't see the distinction. So your question's noted for the record, and your objection as well.
All right, and I'll follow up with this. Now, you're leaving removing yourself from the case, the divorce case, correct? You withdrew from the divorce case, correct?
Correct.
Did you do that as a result of your concern about any of the accuracies or representations which had been made by your client in the divorce case?
No.
Okay, so that's going to cover communications during the relationship?
Well, Your Honor, hypothetically, not saying this is the case, hypothetically, if Mr. Bradley, knowing, let's say hypothetically, that he speaking with Mr. Wade, was aware that the intimate or personal relationship, romantic relationship, existed prior to November the 1st, 2021, and started in 2019 or 2020, if he's armed with that information that he's obtained from Mr. Wade, but Mr. Wade would want to insist on responding to interrogatories which were contrary to the information that Mr. Bradley would have, then I'm asking him whether he took steps as an attorney to say, I cannot be a part of that or countenance that, therefore I'm withdrawing from the case.
Sure. I still see that as covering their communications. So I'll sustain that objection.
All right. Well, thank you, Your Honor. That's all I had.
Okay. Thank you, Mr. Gill.
Thank you.
Mr. Kacherov, are you still with us? Anyone on behalf of Mr. Floyd still joining us? All right, moving on. Mr. Cromwell.
Just two brief questions, Your Honor. I think everybody's exhausted with this line of question, right?
We're going, Mr. Bradley. When did you withdraw from Mr. Wade's divorce case?
I don't have it in front of me. I don't have the file.
Was it sometime in 2023?
No, it would have probably been, 2023. See, I left in 2022. It could have been anywhere between July of 2022 and maybe December of, it wasn't, I don't have the accurate date, but it wasn't when I left, and it wasn't.
Make it easier for you.
Okay, all right.
You were not his divorce lawyer at the time the interrogatory responses were filed in May of 2023. Is that true?
Oh, no, I was not. Okay, yes.
And as of today's date, Mr. Wade is still a married man. Would you agree?
I haven't kept up with the divorce proceedings, but I think they're still open.
Okay. So, and if they're still open, that means he's still a married man.
Yes, that's correct.
So if the fact that in a pleading there is a reference to the marriage is irretrievably broken, that doesn't mean the marriage ends, does it?
I guess you have to ask the judge that's handling the case.
Well, it doesn't end until there's actually a divorce decree signed by a judge. Would you agree?
I would agree.
All right. Thank you.
Okay, Ms. Cross, were you taking?
I am, Your Honor. I'm going to have a minute. My cross-examination might be a long one, so we can go for about an hour and a half. Can I have just a 5-minute break?
Sure. All right, we'll be back in 5. Okay, we're back on the record, and maybe no, we're not. We can get Mr. Bradley back. While he's coming out, Ms. Merchant, for planning purposes, based on how Mr. Bradley's testimony was presented, do you anticipate calling any further witnesses? All right.
Mr. Sandow had a copy of the church speech that I think he was
Right. We'll handle that with housekeeping at the end.
Okay.
Okay. Ms. Cross.
Thank you, Mr. Bradley, have you still got the exhibits 23, 24, 25 there in front of you?
I do.
And 23, that's one of the contracts for, that was your personal LLC or PC, your personal legal entity, right? For the
That is correct.
attorney's office? Yes?
Yes, that's correct.
Okay. And I understood your testimony to be that any income that came into the partnership, when I say partnership, let me be more specific. You had an individual legal entity. Mr. Campbell had an individual legal entity. Mr. Wade had an individual legal entity. But y'all had a partnership agreement, right?
Yes, but we didn't have that the entire time.
There was
Yes.
a period of time that we've been talking, or that we had talked about in 2022 prior to leaving the firm, that there was an actual entity for the three of you, correct?
That is correct.
And that was roughly during the time period where y'all bought a building together.
Yes, correct.
And it made things simpler, or for whatever reason, you decided at that time that a joint entity made sense to own that building, right?
Correct.
Okay. All right, but those contracts there, they're not with the joint entity, correct?
No, they're not.
Those are all with you individually, is that right? Can you take a look at 23, 24, and 25?
Yes.
They're all with you individually?
Yes.
Okay. 23, what's the hourly rate that you were being compensated? That was it.
23 is the, I don't think, no, 23 is not the first appearance. 23 is the taint, it says.
What's the hourly rate on that contract?
$150 an hour.
$150 an hour? All right. So the $150 an hour, the way I understand you all shared profits was you get 50, Mr. Campbell get 50, Mr. Wade get 50, and then y'all pay expenses jointly as well, correct?
Correct.
All right. What about exhibit number 24?
It seems to be the same.
Same amount?
I don't know if it's the same amount.
I'm interested in the amount. Can you tell
Oh,
me?
no, the amount was $65 an hour.
$65 an hour?
Mhm.
All right. That's not a particularly high rate for an attorney in the Atlanta metro area, correct?
No, it's not.
All right. Was that a government rate that you were willing to accept at that time?
Yes, that is correct.
All right. And so the $60 you're getting for that contract, again, that's split three ways, you, Mr. Wade, and Mr. Campbell, correct?
That is correct.
So when you were
Minus
asked-
expenses and stuff like that, but yes.
Exactly. That was the income, and then expenses come from that, and then profits, whatever's at the end, correct?
Correct.
All right. So when you were being asked questions about Mr. Wade, I think the phrasing, and I object to, but I think you might recall the question, Mr. Wade brought you this contract, or Mr. Wade got you this contract. Do you remember those questions?
Yes, I do.
All right. So we're talking then about a split among the three of you of about $20 a piece, right, for that particular contract?
For this one, yes.
All right. What about 24? You got 24 there? I'm sorry, 25. You got that in front of you?
I do.
What's the hourly rate on that one?
It's $150.
$150 on that one too? All right. And the same sharing went through the business the way you handled that contract as well, right?
That's correct.
All right. Who is Austin Dabney?
He was a probation officer that passed the bar, and we hired him and another individual. The other person didn't stay long.
And did Mr. Dabney and the other legal associate that you all had working for you at that time, did they do some work on these first appearance contracts?
Yes.
And that was a pretty good position for a younger lawyer to be sent to get some courtroom experience, correct?
That is correct.
2020, you're aware that Mr. Wade had a serious illness during that time?
I'm aware.
And you and Mr. Wade, I think you described your relationship in a lot of details earlier about specific circumstances. But you were business partners in, let's say, up till the time you left in summer 2022, correct?
That is correct.
You were business partners up until that time?
Yes, I said yes, that is correct.
Okay. And while you didn't socialize together frequently, you considered yourself a friend of Mr. Wade at that time?
Yes, we were friends at the time, yes.
All right. You are no longer business partners.
That is correct.
You are no longer friends.
I mean, if he's saying that we're not friends, then
I
yeah.
want to know what you think, Mr. Bradley. Do you consider yourself a friend of Mr. Wade?
I'll consider.
Goes to potential bias. Ms. Cross.
Would I consider myself a friend of Mr. Wade?
Mm-hmm.
I would.
You were asked questions, Mr. Bradley, about the circumstances under which you left the firm. Do you recall those questions?
I do.
All right. And you left the firm. The firm remained the same as far as other employees, Mr. Wade, Mr. Campbell, as the named partners of the firm. You were the one who left, correct?
That is correct.
And you termed it as a disagreement. You recall answering questions as though you left due to a disagreement. Yes?
Yes.
And that disagreement was that there was an allegation of sexual assault by an employee made against you, correct?
That is incorrect.
There was not an allegation that you sexually assaulted one of the employees in the firm.
That is incorrect, but yes. Yes.
Yes, there was an allegation that you sexually assaulted a member of the firm, correct?
Yes, there was an allegation, yes.
And as a result of that allegation, you left.
I did.
You were no longer business partners with Mr. Wade.
That is correct.
The firm remained intact, and in fact, the employee involved remained with the firm, correct?
I'm not certain of that. They did leave the building, of course, and I don't know. Some of the employees did leave.
Mr. Bradley, you in fact paid that employee $20,000, correct?
That is incorrect as far as what was. No.
On or about the time that you left the firm, and on or about the time that the allegation of sexual assault was made against you, did you pay the person who had made the allegation of sexual assault any amount of money?
There was money left in an escrow that belonged to me. I don't know what that amount was.
And did that money that was left in the escrow that belonged to you, was that paid to the employee who said that you sexually assaulted her?
I never signed any, I never gave any money. I left the money in the escrow account. What happened to that money? I can't, I don't know what happened to it.
For what purpose did you leave the money in the escrow account when you left the firm?
I left the money in the escrow account.
For what purpose, sir?
There was no purpose.
You just left the money in the escrow account?
Yes.
If there's no connection to the money you left in the escrow account and the allegations of sexual assault that an employee of your firm made against you, why was it that you brought to my attention, or why did you respond the way you did about money in an escrow account when my question was, did you pay this employee any money?
I didn't hand any money It was money from an escrow account, to my knowledge.
To your knowledge, where did the money in the escrow account go?
To the employee.
To that employee. Was there one allegation or one incident of sexual assault with this employee, Mr. Bradley, or was there more than one?
It's one incident.
There were not two.
To my knowledge, there were not two incidents. No.
I'm asking for incidents that you have been involved in. Were there two incidents where you sexually assaulted this employee?
No, I didn't sexual assault anybody.
Was there another occasion where you paid any money as a result of an allegation of sexual assault against you?
No.
Did you sexually assault any clients of your firm?
No.
Never.
Never.
Who's Anna Rodriguez?
I don't even know that name.
You don't recall a client named Anna Rodriguez?
Anna Rodriguez? No, I do not.
Never met her?
I do not recall the name Anna Rodriguez.
Your Honor, I would object to this. I'm not sure what we're trying to do here. So I would object to this one as well.
All right, Ms. Cross.
Your Honor, this clearly goes to the bias that the witness has towards Mr. Wade and other individuals, his motive in involvement. And I believe it's an appropriate avenue to pursue based on exploring his credibility.
All right. At some point, though.
I'm not going to go much further.
Okay.
Judge, if this is allowed to continue in this way, it does appear a little bit harassing, then is Mr. Bradley going to be excused from his privilege because this is not...
That's what I was going to do. Don't do that yet.
Mr. Chopra.
Sit on it. I think she's already done that.
Your Honor, I'm asking in all seriousness, that privilege, although...
Based on the answer right now, I think now we've opened up a whole area. What he has just responded to, he previously said was privilege. That doesn't sound like privilege to me. We'll have to address that when we go back through the rundown. So, Ms. Cross.
I'm finished.
Okay. Mr. Saydown.
You were accused by Mr. Wade of misconduct in the course of your representation of Mr. Wade, correct?
I was not accused by Mr. Wade, no.
Who accused you? Did Mr. Wade not, based on the questions were just asked, did Mr. Wade not bring to your attention these sexual assault allegations?
Ask that again, please.
Mr. Wade brought to your attention the sexual assault allegations that you've been asked about by the prosecutor, correct?
Correct.
And at that time that Mr. Wade brought those allegations to your attention, you were still the attorney for Mr. Wade, correct?
Correct.
And therefore, your conduct as an attorney, and the attorney at that time for Mr. Wade, was called into question by Mr. Wade's passing along to you allegations of misconduct, correct?
I object to that. I don't think that's factually true. I don't know that that's not. I know that that is not legally true. The attorney-client relationship is of a matter. It is not vitiated by other instances or anything outside that matter.
I'm not sure that that's accurate. He was accused by Mr. Wade, his client. Do you mind if I speak? I allowed you to speak.
Mr. Saydown.
Mr. Wade accused this gentleman of misconduct in the performance of activity while he's an attorney working with Mr. Wade and representing Mr. Wade. Those allegations of misconduct open up the question of whether or not he can defend himself by now discussing his confidential communications with Mr. Wade in connection with the representation as well as the allegations. That's the position of the defense.
Understood. So what is the question you're putting?
My question I'm going to ask you now is, tell us what Mr. Wade told you about when he began his relationship with Ms. Willis.
All right. So where I think we are with this is that Mr. Bradley previously testified that the reason he left the firm was totally and completely covered by privilege. When asked by the state, he went into a factual scenario that, to my mind, I don't see how it relates to privilege at all. And so now I'm left wondering if Mr. Bradley has been properly interpreting privilege this entire time. And I think the only way I can cure that is by having that in-camera conversation with him.
May I suspend my redirect for you to have that conversation?
I think that makes sense. Is there anything else, though, that you were going to cover other than this issue?
No.
Okay. Ms. Cross, any reactions?
Only to, Your Honor, the premise of Mr. Sadow's question was that Mr. Wade accused Mr. Bradley of the sexual assault. That was not my question, and I don't believe that's factual. Though there was an employee who accused Mr. Bradley of sexual assault.
Okay. But regardless, though, the point is that the circumstances of his departure from the firm, from what I've now heard, had nothing whatsoever to do with his representation of a divorce. Is that fair?
My question, I believe the testimony has been that the circumstances of Mr. Bradley leaving the firm were related, I can't say how much, but certainly in a large part, based on the allegation of sexual assault that was made against him by an employer.
Sure. And his previous testimony was that was totally covered by privilege.
Yes, he lied.
Okay. All right. Other than this issue, which I think we've covered at length, was there any other questions based on Ms. Cross's examination from other defense counsel? Okay.
No, Your Honor.
All right. With that understanding, can this witness be excused, Ms. Merchant? All right. So, Mr. Bradley, I would ask, I don't know if we may be able to do it today. If we
I'm
could.
sorry, Judge, I forgot to excuse him. Mr. Sadow had reserved the rest of his cross for after you confirmed the privileges.
Right. What I'm about to say, just logistically, is what I'm trying to do is, if we can conclude this hearing with the exception of that in-camera hearing, we end for today. And if, as a result of that in-camera hearing, that I learn that we need to reopen the evidence, then that's what I'll do. So to that end, I can give Mr. Bradley instructions that he's to report back if upon order of the court, but otherwise, is there anything further the parties need from him today?
Not from him, but I wanted to get those set.
I know there's other housekeeping things and things we need to do.
And based on his testimony, we do have another witness, Your Honor. It doesn't involve Mr. Bradley requiring to be here.
Okay, so now the state does have another witness.
I do.
Okay. All right. In that instance, okay, Mr. Bradley, you can sit down, sir. However, I'm giving you the order to stay in touch with your attorney, and then we're going to have to find a time to meet again and go into an in-camera session. Do you understand, sir?
I do.
Okay. All right. Thank you, sir. You can step down. Ms. Chopra, do you have a card for me?
I do, Your Honor.
Okay.
At least I hope I do. I'm the worst lawyer on earth. I usually just tag bus stations with my
You can write down your contact information for us?
I will.
All right. Ms. Merchant, do you have any further witnesses?
No, Judge.
Okay.
Your Honor, on the issue of the Bill Selinsky, 1006 versus 611, we're not going to call him. We think the chart, the foundation of the source of the chart is sufficiently in evidence, and we can just use the chart during argument under 611 demonstrative.
Okay. And any objection to this entry as a demonstrative, Ms. Cross?
No, Your Honor. Given the parameters we discussed earlier.
Okay. Can we go ahead and mark that an exhibit and make it part of the record in advance of argument, since I don't know when we're going to be able to have that scheduled. I think this would be Defense Exhibit 28. But let me go down the order just so we're staying organized. Ms. Merchant does not have any further witness. Excuse me. Ms. Merchant, on behalf of Mr. Roman, has no further evidence. Mr. Sadow.
Your Honor, we are in the process, if the court will allow us, to obtain certain phone records
and we would like the record kept open for the introduction of those photographs. We have them in draft. I say draft, we have them informally, we do not have certification. And they would deal with, remember I asked Mr. Wade about certain activity down in Hapeville during the time period, and it deals with that specific time period. So we're talking about February to March of 2021 to November 1st of 2020.
And is it your intention that you would want to introduce these solely as an exhibit, or you think that this should reopen and bring us back for an entirely new evidentiary day with witnesses?
I think that we would want to, if what we believe is there, based on our preliminary research, is there, we'd like to reopen and be able to introduce the records and someone to explain what it means. But that's it.
State certainly, I'm sorry, were you finished, Mr. Sagal?
I believe so.
All right.
State would certainly have an objection to that. This hearing has been set. We haven't seen the records, so I don't know if I have any objection to what they are. But the day has been set for quite a while. We object to leaving the evidence open for any purpose.
Okay. And Mr. Sadon, when did you first go about trying to obtain these records?
I know it's also the Delta records. As soon as we got a hearing date and the state's response, so what happened was when the state responded, I think it was February 9th, and admitted to the relationship but put parameters on the timing, I sent some subpoenas out in response to that, so that was February 9th. Problem is, Delta, AT&T, all these folks aren't super fast about that. And so I know Delta, we're also waiting, I wanted to remind the board, waiting for those records to be submitted. And AT&T actually emailed me these phone records yesterday morning on the way to court.
Okay. All right. Any further exhibits that are self-authenticating? If counsel are able to provide those, obviously serve those on opposing counsel, and then before sending them over to us, let us know whether they would be tendered with or without objection, just purely on authentication or hearsay issues or relevance. We can make those part of the record, and I'll reserve whether this reopens a full hearing format. But the exhibits themselves, I'm willing to have come into the part of the record, but there will be a cutoff point very soon, as soon as we schedule argument. All right. Any other evidence, Mr. Sadow, then?
No, Your Honor.
So that would be cell records. Mr. Stockton, any evidence? All right. Mr. Durham, if you're still with us.
No, Your Honor.
All right. Mr. McDougald.
Certified copies I mentioned to Your Honor yesterday, Your Honor.
Okay. And why don't you lay those out for the record?
They are marked but not yet numbered. I believe our next exhibit would be 29.
28, I just said, was Mr. Gillen's demonstrative, just so I'm keeping it straight.
And so I'd previously provided these to the prosecution. 29 would be a certified copy of County Code Section 2-68.
Okay.
30 is a certified copy of County Code Section 2-69. 31 is a certified copy of County Code Section 2-79. 32 is certified copy of County Code Section 10-114. 33 is a certified copy of County Code Section 10-115. 34 is a certified copy of County Code Section 102-464. 35 is a certified copy of County Code Section 102-465. 36 is a certified copy of County Code Section 102-466. And 37 is a certified copy of a emergency motion by non-party deponent for protective order filed on behalf of DA Willis in the Wade divorce case.
Okay. Ms. Cross, objection to defense exhibits 32 through 37.
I object to their relevance, and I will take I will take opposing counsel's representation that the pleading is complete and accurate as it was filed, and object to the relevance of that as well, but not the authentication.
Okay. All right. We'll note the objection for the record, and we'll admit them for whatever weight they're due. So defense exhibits 32 through 37 are admitted. If you could hand those to Madam Court for. Any further evidence, Mr. McDougall?
No.
Okay. Mr. Rice?
No, Your Honor.
Mr. Gillen? The demonstrative 38 or 28? Okay. And do you have a physical copy for us already? Great. All right. Do we still have Mr. Kucherov with us on Zoom or anyone else on behalf of Mr. Floyd? He's not on any longer? All right. I'm being informed that he dropped off Zoom, and so I'll make a finding that he voluntarily has absented himself from this hearing. Mr. Cromwell?
No evidence, Your Honor.
Okay. Ms. Cross, back to you.
If the defense presentation of evidence is done, I'd ask that all of the witnesses who had been subpoenaed but not called now be released.
I think that's fair. Ms. Merchant, any reason to hold on any of those witnesses? Okay.
And the state has 2 short witnesses, and that is it.
Okay, you may call your next witness, Ms. Cross.
Next witness for the state is Austin Dabney.
Your Honor, these witnesses are going to be
Impeach the testimony of Mr. Bradley?
on a collateral matter. We'll wait and see.
Okay.
Yes, my name is Austin Dabney. That's AUSTIN DABNEY.
Good afternoon, Mr. Dabney.
Good afternoon.
I want to direct your attention. Well, first of all, how are you employed?
I am employed right now. I have my own firm.
You're a lawyer and you've got your own law firm?
That's correct.
All right. I want to direct your attention to 2021, 2022. What was your employment at that point?
Yes, I was employed with the Wade Bradley Campbell firm.
And that's Nathan Wade, Terrence Bradley, and Chris Campbell?
That's correct.
All right. And what did you do in that firm?
I was an associate attorney.
All right. And don't need a whole lot of detail, but generally speaking, who in the firm did you work for? What kind of matters did you handle?
Well, I believe I worked for all of them equally. They would all give me tasks to do, which court dates to go to, what cases to work on.
I want to direct now your attention, Mr. Dabney, to a particular instance. Did you have occasion at any time to go to a club with Mr. Bradley?
Could you repeat the question?
Yeah. Did you have any occasion to go to a club, a nightclub, or a bar situation with Mr. Bradley?
Yes, I have.
More than one time?
More than one time, yes.
The time that I'm going to direct your attention to, we spoke about a little earlier today. Do you recall any instance, Mr. Dabney, where Mr. Bradley, where you witnessed Mr. Bradley sexually assaulting him?
Your Honor, I object to this.
Okay.
Specific instance of
Sure.
impeachment is improper.
All right. How is this not extrinsic evidence of a collateral matter, Ms. Cross?
Maybe ask a better question. My question will be if this witness witnessed Mr. Bradley sexually assaulting another employee of the firm.
Exactly, but same subject matter. How is that not issue on a collateral matter for impeachment?
I think it's not a collateral matter. Your Honor, the witness denied it. I think it is highly relevant. I think that it goes to the witness's credibility and his denial here this afternoon that he committed the assault. There's a witness I will proffer to the court who has firsthand knowledge and witnessed the event. And so I think that's highly relevant to both Mr. Bradley's credibility and to the proceedings that we've had for the last 2 days.
Still object, Your Honor.
No, I understand, Mr.
Bradley, they have to live with whatever answer he gave. They can't have a sub-trial with the extrinsic evidence of the conduct here. So we would object.
Right? 24-608.
Ms. Cross, under 608, I don't see how this isn't well beyond the core facts at issue. I think you confronted with him. I think he answered them as he saw fit. An argument can be made as a result, but to go down a whole mini trial on whether he did or did not do this and circumstances of his leaving the firm, I don't see how that gets past 608.
I understand the ruling, Your Honor. Disagree, and just for my objection, I put a proffer on the record, not a detailed one, but that
I think you already have.
I'd like to, with the court's permission, I'd like to make it clear that the sexual assault I'm referring to was the same employee that I asked Mr. Bradley about. I just wanted that to be clear.
Okay. All right. Understood. Is there anything else that is relevant to this witness?
Given the court's ruling, no.
All right. Questions from defense counsel?
Good afternoon, sir.
Good afternoon.
When did you start working at the law firm?
I believe I started working, to my recollection, in March 2021.
Okay. And at that time, do I understand that there was what I would call a three-way partnership or sharing arrangement at the law firm?
I'm not aware of any sharing arrangements that they had, but there was the Wade, Bradley, and Campbell law firm.
And did you work in the law firm office on a daily basis?
I did.
And during the time period you were there for the remainder of 2001? That is, you worked from March of 2001 at least to the end of 2001, correct?
I didn't even have a bar license in 2001.
I'm sorry, 2021. It's a little late. From March of 2021 to the end of 2021, correct?
That's correct.
Okay. During the time period that you were working at the law firm, did you see Fani Willis?
During my time, could you repeat the question?
In that time period between March of 2021 and November 1st of 2021, did you see Miss Willis?
I may have recalled one instance where I saw her in passing.
And when you saw her, was she at the law firm?
That would be correct.
And do you know who she went to visit?
I do not know.
You didn't see her go to Mr. Wade's office?
I do not recall.
Did you ever talk to Mr. Wade about Fani Willis?
Could you repeat your question?
Did you ever talk to Mr. Wade about Fani Willis during the time period of March of 2021 to November 1st of 2021?
No.
Did you know they were dating?
No, I did not.
Did you see anything did you ever socialize with Mr. Wade?
As far as being an employee, yes.
Well, I don't know what that means exactly, but did you ever go out to eat with Mr. Wade?
On occasion, he would take the office out to lunch.
Beyond that, did you ever go to a nightclub or drinking or any of that with him?
No, I did not.
Okay, so whatever relationship Mr. Wade had with Miss Willis during this time period, you don't have personal knowledge, correct?
I do not have any personal knowledge.
Okay. Thank you very much for being here.
Thank you.
Any other questions from defense counsel? Mr. Stockton.
When you started in March of 21, was that just you gave them a resume and started working there?
I don't understand your question.
When you started working there, is it a situation where your first day on the job is the first day you may have met him or shortly before you met him?
Again, I don't understand what you're asking.
Let me back up. Did you know Mr. Wade or any of his partners prior to March of 21?
Yes, I did.
How did you know them?
In a professional capacity. I used to be a community supervision officer with the Georgia Department of Community Supervision.
And where would that have been out of? Fulton County?
Cobb County.
How long did you know Mr. Wade prior to that?
I didn't see Mr. Wade in my professional capacity. I thought you were asking about all partners, but if you're only asking about Mr. Wade, if you could please clarify.
Okay, so you went to work for Mr. Wade in March of 21, correct?
I went to work for the Wade Bradley Campbell firm.
Okay. Prior to that, how long did you know Mr. Wade?
I did not know Mr. Wade prior to that.
At all?
At all.
No further questions.
Any other counsel? All right, seeing and hearing none. Any redirect, Ms. Cross?
No, Your Honor, subject to the court's ruling.
All right, can this witness be excused?
May.
All right, thank you, sir.
Thank you, Your Honor.
Next witness, Ms. Cross.
I believe I know the court's ruling, so let me proffer that the next witness the state would call would be Anna Rodriguez. Question, Mr. Bradley, about the sexual assault of Ms. Rodriguez, a client of the firm. He denied knowing her or recognizing her name. I believe Ms. Rodriguez's testimony would be impeaching of Mr. Bradley. I believe it's appropriate, but want to present that before I call it.
All right, thank you, Ms. Cross. And so, based on that proffer and the subject matter proffered, I still believe that would fall under 608B as extrinsic evidence of a collateral matter. And so I don't think it's allowed under our rules of evidence.
Understanding that, I just make a proffer on the record that Ms. Rodriguez would testify that Mr. Bradley sexually assaulted her. She was a client at the time. And that would be impeaching of his testimony that he denied. So.
All right, understood. Any further evidence or witnesses, Ms. Cross?
No, sir.
Okay. All right, then at this time, for now, I'll consider the evidence closed, subject to any certified submissions by counsel, and subject to the results of the in-camera hearing. We will coordinate with all counsel to find a date to come back for summation. And to that end, again, using Ms. Merchant as kind of running lead on this, I'd like you to consult on whether that's going to be a collective response on behalf of the defendants. If not, then we're going to have to get into time allotment, and if it's more than a handful of counsel, it'd probably maybe be 10 to 15 minutes per side. And so, Mr. Sadon.
When did you say this might happen?
We'll follow up by email so we can coordinate with everyone's schedules. I want to make sure we have our same court reporter as well, so that the record is all in one place. And I know we have a lot of schedules to coordinate, but looking at either late next week, as in next Friday, or the following week.
And would we at least have the opportunity to get a transcript before we do that?
I think that's probably highly unlikely, but we'll see. It's just that would require a rush, and I know again we're at a shortage of court reporters, but I think there are other means you can refer to the evidence with confidence as to what was said.
All right.
Ms. Merchant. Okay. And like I said, we will. We're gonna follow up with scheduling. Mr. Gillen.
The argument would be on this hearing,
and
also on the forensic.
Yeah. Any other claims brought in any of the filings regarding forensic misconduct? This whole line of questioning. All right. Any other questions from defense counsel? Anything from the state?
Your Honor, we would just ask that we be allowed to submit a brief as it relates to the rulings that you just made as relates to the objections by defense counsel under 607 and 6021 was the impeachment by contradiction, which in the state's understanding would allow the use of extrinsic evidence to impeach the specific testimony here of Mr. Bradley. So we're just asking for leave to provide a brief and have the court to further consider your ruling.
Well, if you still got your witnesses here and you think you've got a better legal argument, I'm willing to hear it. You said 607 and 608.
607 and 621.
Okay, I see 621 and I see 608. And
in both of those instances, they allow testimony that related to the testimony of another witness here, Mr. Bradley, that we can prove this is patently false, as he testified that he didn't commit a sexual assault and that he didn't pay off witnesses and things of that nature.
Okay, and how do you get around 608B's prohibition on extrinsic evidence of collateral matters?
Both 607 and 621 allow the use of extrinsic evidence to specifically impeach facts known to be false.
But if that held true, respectfully, that would mean that any time a witness denied something, you'd be able to, of a matter testified to, you'd be able to impeach with extrinsic evidence, and that's, respectfully, that's not.
Well, here's what I'm fine with. Mr. Abadi, if you want to submit that brief on purely legal argument, you can, but I don't want to have this as a vehicle to essentially put forth an extended and long-winded proffer of what you expected the evidence to be. So if you think I've made a legal error on that point, feel free to brief it, and we can reopen the hearing if that's legally invalid. Okay? All right. Mr. Chopra, is your client still here?
I believe so, Your Honor, but I'm sorry. They went in the
That's fine. If he is still here, let's relocate to the jury room. Okay. We will be adjourned for today. Thank you all. Miss Taylor, I don't it logged out on me. Do you think it? Yeah. Do you think it lost battery or? I don't need to know. Where are you going to put the